Of documents, dépôt de documents. Introduction of government bills. Déclaration.
Statements by ministers.
Reports from interparliamentary delegations. Présentation de rapport.
Presenting reports from committees.
Cambridge.
Mr. Speaker, I have two reports this morning. First report, Mr. Speaker, pursuant to Standing Order 113, I have the honour to present the 21st report of the Standing Committee on Procedures and House Affairs regarding the membership of the Legislative Committee on Bill C-27, an act to amend the Criminal Code, dangerous offenders, and recognize recognizance to keep the peace. My second report, Mr. Speaker, if I may.
Honourable member does that, I can say that pursuant to Standing Order 113.1, the report he just tabled is deemed adopted. The Parliamentary Secretary has a second report. The Honourable Member for Cambridge has a second report. Sorry.
Thank you, Mr. Speaker. Yes, indeed. I believe if you now ask, all the parties, I believe, have been consulted. And Mr. Speaker, if the House now gives its consent, I move that the 20th report of the Standing Committee of Procedures and House Affairs concerning the membership of committees of the House presented to the House yesterday now be concurred in. Thank you.
I know the honourable member is jumping ahead of the game here, but does he have the unanimous consent of the House to propose this motion at this time? Oui. The
House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed.
Presenting reports from committees. The honourable member for Vegreville Wainwright.
Thank you very much, Mr. Speaker. I have the honour to present in both official languages the fourth report of the Committee on International Trade. In accordance with its order of reference of Wednesday, October 18, 2006, your committee has considered Bill C-24, an act to impose a charge on the export of certain softwood lumber products to the United States and a charge on refunds of certain duty deposits paid to the United States, to authorize certain payments, to amend the Export and Imports Permits Act, and to amend other acts as a consequence, and has agreed on Tuesday, November 7, 2006, to report it with amendments. Thank you.
Presenting reports from committees. Dépôt de projet de loi émanant.
Introduction of private members' bills.
By Mr. Stauffer, moves for leave to introduce a bill entitled An Act to Amend the National Capital Act, Appointments and Meetings. This motion is deemed adopted. The honourable member for Ottawa Centre.
Thank you, Speaker, and I'd like to thank my seconder for helping me with this important project, An Act to Amend the National Capital Act on Appointments and Public Meetings. Mr. Speaker, for years now, people have asked for transparency, for a public process for the appointment of people to the National Capital Commission, and today I'm just delighted to be able to present this bill to bring democracy to the National Capital Commission and to make sure that we have a National Capital Commission that we all will be proud of. And I hope for the government to actually take my bill and adopt it and make it theirs. Thank you, Mr. Speaker.
Mr. Dewar, seconded by Mr. Stauffer, moves that the bill be now read a first time and reprinted. Cette motion.
Motion is deemed adopted.
First reading of this bill, première lecture de ce projet de loi.
When shall the bill be read for a second time at the
next sitting of the House? First reading of Senate public bills. Motion.
Motions.
Presenting petitions. The honourable member for Davenport.
Thank you very much, Mr. Speaker. I have the pleasure to coordinate petitions from across Canada protesting the competence and irrational cuts to adult literacy programs by this Conservative government. It is my sad duty to present to you the first of several petitions, which is from the Halidem Norfolk, the Ministers for HRDC's own riding. Hundreds of petitioners note the importance of literacy for social and economic development and the impact it has in our society. I stand with citizens of Halidem Norfolk in calling for the reinstatement of literacy funding, since their own MP will not. I also have the sad duty to present a petition from the Minister of Health's riding the same subject. Hopefully, the Minister will stand up for literacy programs. Finally, I have the duty to present the same petition, this time from the Ontario Literacy Council. These people are on the front lines combating literacy. I honor to support their efforts, along with them call on government to reinstate funding so they can keep doing their vital work. Thank you, Mr. Speaker.
The honourable member for York West.
Thank you, Mr. Speaker. I have several petitions. The first one is a petition containing names from residents in my riding of York West and the surrounding GTA. The petitioners recognize that religious persecution is an international crisis affecting many religious groups in countless countries of the world, and that the persecution of groups for their religious beliefs is immoral, unjust, and violates an individual's fundamental right to religious freedom. The petitioners call upon the federal government to develop an automatic array of interventions that may be imposed by Canada against foreign governments such as Iraq that may support religious persecution or fail to prevent it, and to improve measures for refugees who have suffered religious persecution. And as well, Mr. Speaker, I'd like to present a petition on behalf of the constituents of St. John's, Newfoundland, on the whole issue of literacy and the need for the reinstatement of funding to literacy programs that have been cut by the minority Conservative government, and to undertake a national literacy strategy to ensure that all Canadians have the opportunity to achieve this vital skill. Thank you.
The honourable member for Huron-Bruce.
Mr. Speaker, I have the privilege this morning to present on behalf of constituents from the riding of Timmins, James Bay, and from the riding of Mount Royal, Mount Pearl, names of petitioners who have petitioned us to look at the whole issue of illiteracy and the fact that the government most recently cut funding for some of these programs, including the literacy program. They would have us to understand that the elimination of adult literacy is a key component in ensuring Canadian competitiveness in the global market, as well as ensuring the quality of life for thousands of Canadians. And they would call upon us to reinstate the funding to literacy programs cut by this Conservative government, and to undertake a national literacy strategy to ensure that all Canadians have the opportunity to achieve this vital skill. Thank you, Mr. Speaker.
The honourable member for Calgary Northeast.
Mr. Speaker, I have the honour to present petitions from 612 individuals from my area of the country, which is in and around Calgary. The petitioners, the undersigned citizens of Canada, would like to draw the attention of the House to the following. Whereas the protection of our children from sexual predators must be a top priority of the federal government. Whereas the Canadian Police Association, a number of provincial governments, and a parliamentary committee report all favour raising the age of consent. Whereas the studies show that 14 and 15-year-olds are most vulnerable to sexual exploitation, including recruitments from pimps. And whereas it is the duty of Parliament, through the enactment and enforcement of the Criminal Code, to protect the most vulnerable members of our society from harm. These petitioners pray that government assembled in Parliament take all measures necessary to immediately raise the age of consent from 14 to 16 years. Thank you.
The honourable member for Vancouver Quadra.
Thank you, Mr. Speaker. I have the honour to rise today and present to the House two petitions, one from my constituents in Vancouver Quadra. Approximately 150 signatures accumulated in a very short period of time in a small area of the constituency, which shows, I think, the potency of the concern that they're raising with this petition, which is that Canadian forces and other personnel in Afghanistan are put at some great risk, as well as Afghan people being at risk. And these petitioners, Mr. Speaker, ask for Canada to remove its troops from Afghanistan. I have a second petition which relates to the national literacy programs and funding that was cut recently by the government, and this comes from the citizens of Lethbridge, who I can assume are not pleased with the representation made on this matter by their Conservative member of Parliament. But their concern, Mr. Speaker, is simply that these programs be returned and funded immediately, noticing that adult illiteracy can affect as much as 38% of the population and has a huge impact on the social and economic development of individuals and their own quality of life, as well as that of our country. Thank you, Mr. Speaker.
The honourable member for Charlottetown.
Mr. Speaker, it's my honour to rise in the House to present a petition signed by the constituents of the riding of Labrador. The petition expresses these constituents' outrage at the cuts to the literacy funding committed by this Conservative government. It calls on the government to immediately reinstate this funding for what is an absolutely vital social service in Atlantic Canada. I do hope that the government will pay close attention to this and other petitions from around the country and to stop turning its back on Canada's most vulnerable people.
The honourable member for Halifax.
Mr. Speaker, it's my privilege to table a petition from hundreds of Canadians calling upon Parliament to hold extensive public hearings to gather information, expert advice and opinion from Canadian and Afghan citizens on how best to use military and other forms of Canadian involvement in Afghanistan for the creation of a stable, democratic and self-sustaining state. And they go on to propose that following public hearings there be a full debate and vote in Parliament on the extent and nature of Canada's future commitments to Afghanistan.
The honourable member for York South Weston.
Thank you, Mr. Speaker. Mr. Speaker, on this National Literacy Day, it's altogether appropriate that we present petitions from hundreds of Canadians that are reminding the government of how important literacy programs are, in particular as they add value to the capacity for Canadians to mainstream and become part of of life here in Canada. In particular, my riding, Mr. Speaker, in York South Weston, these programs are extremely fundamental to the community, and we are hoping that the government will reconsider its intent to cut these literacy programs. I present these petitions. They come from the areas around Peterborough, Beamsville, and St. Catharines, Mr. Speaker. Thank you.
Honourable member for Vegreville Wainwright.
Thank you, Mr. Speaker. My petitioners note that in federal criminal law right now, an unborn child is not recognized as a victim with respect to violent crimes. And when Olivia Talbot of Edmonton was shot and killed in November 2005, her 27-week-old unborn son, Lane Jr., also died. But because there is no legal protection for unborn children today, no charge could be laid in the death of baby Lane. They have indicated, Mr. Speaker, that studies show that violence against women often begins or escalates during pregnancy, and therefore the petitioners are calling on Parliament to enact legislation which would recognize unborn children as separate victims when they are injured or killed during the commission of an offence against against the mother, allowing 2 charges to be laid against the offender instead of 1. Thank you, Mr. Speaker.
The honourable member for Thunder Bay Rainy River.
Thank you very much, Mr. Speaker. I have a petition from the people of Atacocan in the Great Riding of Thunder Bay Rainy River protesting Prime Minister Harper's despicable, cruel and incompetent cuts to literacy, which have wreaked enormous damage to all the...
Order. Order. The members should know they can't refer to the Prime Minister by his name, even in a petition.
Wreaking enormous damage to all the great work of the staff and volunteers of centres such as Atacocan's Literacy Centre. They want the Conservatives to immediately reinstate this vital funding. They would also understand that this would not have happened without the NDP supporting the Conservatives. They just don't understand how important this is to the people all over Canada. Thank you.
The honourable member for Algoma, Manitoulin, Kapuskasing.
Thank you, Mr. Speaker. I'd like to join colleagues presenting a petition where hundreds of constituents of Northern Ontario, whether it's the Sioux or Timmins or Wawa and other parts of our region in the north, call upon this government to reinstate funding for literacy programs. Far too often the most vulnerable in our society are left behind, and those adults who suffer from illiteracy need our attention and care. Thank you very much, Mr. Speaker.
Honourable member for Bonavista, Grander, Grand Falls, Windsor.
Thank you, Mr. Speaker. Indeed, it is an honour to rise on this being Literacy Day. I have the honour of presenting a petition from the citizens residents of the riding of Labrador. And they have a petition calling on Parliament to reinstate funding to literacy programs cut by the Conservative government and to undertake a national literacy strategy to ensure that all Canadians have the opportunity to achieve this vital skill. Thank you.
Honourable member for Yukon.
Thank you, Mr. Speaker. I have 2 petitions to present. The first one from the people of St. John, suggesting that because literacy is so important for social and economic development, And because 38% of Canadians have difficulty in writing and reading, and because it costs Canada $10 billion a year for because those people are illiterate, because literacy is key for the competitiveness and quality of life in Canada, they would like the Conservative governments to reinstate the funding that they cut to literacy programs, especially appropriate on this day of National Literacy Day. And I have a second petition from the people of Iqaluit in Nunavut, who once again on National Literacy Day emphasized the fact that it's so important to the people in their area for their social and economic development, that there are many people that have difficulty writing and reading, and it costs Canadians $10 billion. It's very key to the competitiveness and quality of life in Canada, and so it's absolutely essential, no excuse, that Canada should reinstate, and the Conservative government should reinstate the cuts that they made to literacy, and that would be very appropriate to do on National Literacy Day today. Thank you, Mr. Speaker.
Honourable Deputy de Laval-les-Îles.
Honourable Member for Laval-les-Îles. Thank you, Mr. Speaker.
A petition signed by many citizens of Edmonton Centre, Lethbridge and West Loch St. Paul who are frustrated by the minority Conservative government who has slashed $17.7 million in literacy funding despite a $13 billion surplus. Dans cette journée de l'alphabétisation,
in this Literacy Day in Canada, we understand their anger about these cuts because 38% of Canadians have difficulty reading and writing. In Quebec, there is an organization that says that almost one Quebecer out of every two age 16 and over cannot read enough to function properly in society.
Parliament to reinstate funding to literacy program cut by this Conservative government and to undertake a national literacy strategy to ensure that all Canadians have the opportunity to achieve this vital skill. Thank you.
Are there any other petitions?
For Calgary Centre on a point of order.
I'd like to ask unanimous consent to revert to presenting reports from committees.
The honourable member for Calgary Centre has asked for unanimous consent to revert to reports from interparliamentary delegation, parliamentary committees, rather. Is there agreement? Agreed? Agreed. The honourable member for Calgary Centre.
Thank you, Mr. Speaker, and I thank my colleagues. I have the honour to present in both official languages the third report of the Standing Committee of Natural Resources in relation to supplementary estimates 2006-2007.
Point of order, the honourable member for Bonavista, Grand Falls, Gander, Windsor.
Bonavista, Gander, Grand Falls, Windsor, Mr. Speaker, and a fine job. Since we're all being in somewhat of a generous mood, I would like or seek consent from the House to revert back to reports from the interparliamentary delegations.
Heard the honourable member's request. Is there agreement? Agreed. Agreed. The honourable member.
I thank my honourable colleagues for consenting. Mr. Speaker, pursuant to Standing Order 34.1, I have the honour to present to the House in both official languages the report of the Canadian Parliamentary Delegation of the Canada-Europe Parliamentary Association to the Council of Europe Parliamentary Assembly, or PACE, for its meeting of the Committee on the Environment, Agriculture and Local and Regional Affairs in Paris, France, June 9, 2006.
Questions on the order paper? The Honourable Parliamentary Secretary to the Government House Leader.
Thank you, Mr. Speaker. I ask that all questions be allowed to stand.
Agreed. Agreed. So ordered. Orders of the day.
Orders of the day, Government Orders, Government Bills, Commons.
Resuming debate at third reading stage of Bill C-17, an act to amend the Judges Act and certain other acts in relation to courts.
Debate. The honourable member for Windsor-Tecumseh.
Thank you, Mr. Speaker. Mr. Speaker, I rise to speak on the third reading of Bill C-17. Bill C-17, Mr. Speaker, is a piece of legislation that purports, at least, to incorporate, as is required by legislation, into law the report of an independent commission with regards to salaries and other compensation for our judiciary at the federal level. So that's all the way from the Supreme Court of Canada, Mr. Speaker, to our superior courts across the country, as well as our federal court system. So all of those judges, approximately 1,100 of them across the country. Historically, Mr. Speaker, this has been a very difficult problem for legislatures at both the federal and provincial level. And the problem we have, Mr. Speaker, is because of the structure of our Constitution that recognizes the independence of our judiciary, the importance, quite frankly, of an independent judiciary to the democracy of Canada, that we've never been able to satisfactorily deal with how we compensate those judges and maintain their independence from the legislative and administrative branches of government. A number of years ago, approximately 10 years ago, a system was developed as a result, Mr. Speaker, of several court decisions, and one that has now come since then, that required the legislative branch, this House, this government, to establish this independent commission. A commission that would be composed of an independent chair, a neutral chair, and then one person delegated from the government and one person delegated from the judiciary. That commission was then to investigate the compensation that was paid to judges, our judges right across the country at the federal level, and make recommendations in the form of a report. That report then coming back to first the government, to the House as well, to be dealt with in committee and encompassed in legislation. So that's why this bill is before the House at this point. Mr. Speaker, what happened was to some significant degree, and I think shamefully, the process has been, I suppose we could use interchangeable terms here, either ignored by this government in its proper sense, or been hijacked to some degree for ideological reasons by the government. What happened, Mr. Speaker, was the report that came back recommended certain compensation levels, straight salary levels, or a number of issues around pensions and fringe benefits, if I can put it in that vernacular, that were to be dealt with by way of these recommendations and recommendations to the government to implement. Mr. Speaker, one of the travesties of what's gone on here is that this report is almost 4 years old now. The previous Liberal government, as was so common with that government, dithered on it, didn't deal with it, other than preparing some legislation to accept it, and then basically just let it sit, ignoring their responsibilities, really their constitutional responsibilities, to process the Commission's recommendations in a reasonable time frame. And that has been part of one of the court decisions, was that whatever methodology was deployed, it had to be used in a reasonable time frame. Liberal government, past Liberal government, did not do that. Then we got the Conservative government, and of course, I think the country generally knows of their attitude towards the judiciary. One of the first things that they did was to slash, in the form of this legislation that's encompassed in C-17, slashed by over 25% the compensation, both in salary and in some of the benefits. That bill, Mr. Speaker, and I'm just going through the history of it, then went to the Justice Committee. Attempts were made there by myself on behalf of the NDP to reinstate the Commission's recommendations. And, Mr. Speaker, if I can, I want to go directly to the intellectual dishonesty of this government with regards to this. The courts, in a series of cases, have said the Commission's recommendations are to be accepted and can only be deviated from if there are set criteria that are met. And what came forward from this government were a couple of arguments, and I say they're no more than that, They tried to characterize them as sound reasons, but they were arguments, Mr. Speaker, that were specious and that were, in fact, intellectually dishonest. One of the things that they said for slashing the compensation recommendation was that the government had the right to take into account the financial circumstances, the state of financial circumstances at the federal level when making a determination. Now, Mr. Speaker, you have to appreciate how ridiculous that one was, because in the three and a half years of that period of time when this report was sitting, not being dealt with, both by the Liberal government and the Conservative government, we had surpluses in this country that amounted to in excess over that period of time of over $20 billion. And this wasn't money that was going to be spent either by the Liberal government or the Conservative government on other programs, other necessities in the country. It was simply sent back and used to pay down the debt. That's what it was used for, Mr. Speaker. So anyway, they tried to contrive an argument that somehow they had the right to take into account financial circumstances, but when you looked at the facts, that, of course, was meaningless. The other argument that they made was that when the Commission did their assessment, they didn't properly take into account incomes of lawyers, because that's one of the tests that we use to set the compensation we pay our judges. They didn't take into account a broad enough scope. Mr. Speaker, that just simply wasn't true. Members of the Commission, in fact, appeared before the Justice Committee, pointed out that they had made an assessment of income levels within the legal community right across the country, large cities, large law firms, small communities, small law firms to individual practitioners of law. That they had done all that they had done their job, they had done it properly, and had reached a consensus amongst the three of them, the independent chair, the government appointee, and the judiciary appointee. They had reached a consensus that this was the proper amount to be dealing with. So the second argument, the second so-called reason, was basically destroyed by the facts of how the Commission had conducted its work. Mr. Speaker, we then, as I said, the NDP in my personage attempted to bring it back. It was voted down. First, there was a decision that the government wouldn't grant the royal prerogative, even though that, when the minister was in front of the committee, he was equivocal as to whether he would accept the recommendation to increase the amount of the compensation back to what it was originally in the Commission's recommendations. So it was ruled out, and Mr. Speaker, there was no indication since then, in fact, just the opposite. The government would very clearly, if those amendments were brought forward to increase the amount to its original level as recommended by the Commission, they in fact would invoke the royal prerogative and not be prepared to accept those changes. So that's the bill that we now have in front of us on third reading for its final vote upcoming in this House. And Mr. Speaker, I think I have to say very clearly with regards to this process, it wasn't honored, just the opposite, both in terms of the timelines that were applied here. It's a disgrace for both governments, both the Liberal and the Conservative, and specifically with this government, with the Conservative government, their approach and their attempt to explain away their reasons for reducing the amount of compensation for the judges is, as I said earlier, specious, it's intellectually dishonest, and quite frankly, it's a disgrace to the importance, the significance of having an independent judiciary, because this goes right to the heart of it. If you're going to go after judges as compensation, the amount that they are paid in this fashion, both ignoring the process and then trying to undermine it with specious arguments, it really is very difficult to see that the independence of the judiciary is not being attacked here by this government. And Mr. Speaker, of course, it's a pattern, right? It's a pattern that we have seen from this government, both as a political party before they got into government this last year and since they've been in. I'm going to come back to that, Mr. Speaker, just to give you other examples of how I've seen the judiciary in the country at the federal level come under attack from this political party. But before I do that, I want to make one final point with regards to the process. We are now at a stage, given that it's taken us so long, that this government now has to appoint a new commission. A new commission has to be put into place because the cycle for judicial compensation is actually in vogue at this point. It's in process. They haven't done that. I assume they will be doing it shortly. But it begs the question, Mr. Speaker, are we going to go through the same process, assuming this government, one would hope not, but this government was still in power when that recommendation comes back from the Commission? Are we going to go through the same process? Are they going to ignore an independent commission doing good work, solid processing of information to determine what is appropriate compensation for our judiciary? Are they going to undermine it once again? And I have no reason to believe, given what I saw go on in this process, other than to believe they will undermine it if they don't get the recommendation that they believe is appropriate, rather than what the independent commission believes is appropriate. Speaker, I want to go to this being part of a pattern. And I'm just going to go through a number of points where I see this party, political party, and now government, attacking our judiciary from a number of different vantage points. We had, when the debate was going on in the country over same-sex marriage, we had the leader of the party, Conservative Party, now the Prime Minister, making these wild accusations of our judiciary being biased, that they were appointments by small L, they were small L liberal appointments appointed by large L liberal governments to specifically enhance the program of rights for the gay and lesbian community in this country. That was the accusation he made. It was a wild accusation. It was offensive to the independence of our judiciary. And, Mr. Speaker, it was wrong. One of the leading decisions out of the Court of Appeal in Ontario was that court, it was a three-member court, was made by Justice McMurtry, who was a Conservative cabinet minister in the provincial government in Ontario at one time, and appointed by a Conservative government to the bench originally, by the Mulroney government. So, you know, it was a wild accusation driven by frustration that they weren't getting their way, that the courts, in fact, were interpreting the Constitution and the Charter of Rights specifically based on equality rights. That's not what the Conservative Party wanted to hear. And so you hear the leader of the Conservative Party making this wild accusation that ultimately was factually incorrect. And then you heard him during the election, Mr. Speaker, right near the end of the election, seeing the judiciary, and he used these terms, seeing the judiciary as one of his opponents if he was to be elected. That was the way he put it. And that's the way he and his government and his party see the judiciary in this country. Not as part of the constitutional structure of this country, not as part of a fundamental support for democracy in this country, but as an ideological opponent to this government and their political party. And then we had, shortly after the election, Mr. Speaker, the member from Saskatoon, Wanuskewin, attacking, putting words into the mouth of the Supreme Court of Canada Chief Justice, alleging she had made these statements. Subsequently had to apologize because they were statements, in fact, that he had made up. But again, what it showed, Mr. Speaker, is the attitude of this party and this government towards the judiciary. Total disrespect, willingness to fabricate accusations against them, all of it based on a strong ideological bent that they see the Supreme Court and our superior courts and our federal court not supporting. You hear the constant attack, Mr. Speaker, by a number of members from that party on the judiciary of making law, not interpreting it, which is their role and, in fact, is the role that they play. And I want to say, Mr. Speaker, having practiced in our courts for 27 years before I was appointed here, they do that better They do that better. Our judges do that better than any judges in the world. I don't hesitate to say this. I'm proud of the fact that I'm part of a legal system, legal community that produces those judges. They're not perfect, but they are better, Mr. Speaker, than any other judicial branch in the world. And that's recognized. You can go into Australia, you can go into the United States, you can go into Britain, any number of other Commonwealth countries that have a similar legal structure, and that's what you hear. Those decisions that they make are used repeatedly over and over again in other countries because of the respect that our judiciary is held to, but not by this government and certainly not by the Conservative Party. And so they're under this constant attack that they're making law. They're not, Mr. Speaker. Their role is to interpret the Constitution, to interpret the Charter. They do that, and they do it extremely well. And then you saw, once this party got into power, them cut the court challenges program. And that's a methodology of undermining the role that our judges play. Because it's going to mean, Mr. Speaker, that we're going to have a reduction in the quality, and I might even say the quantity, of cases that are going to go in front of the court that challenge both federal and provincial statutes and practices and policies. They're going to be reduced. And if they do get there, there's likely to be a lesser quality of argument because the funding for the court challenges program has been cut by this government in a very petty, vindictive way, Mr. Speaker, with absolutely no rationale for it. I mean, you hear the President of the Treasury Board constantly standing up in this House in his bombastic fashion and attacking the court challenges program. That's really an attack on the judiciary, Mr. Speaker. And then they cut the Law Commission, which again has played a role of support for this House, for the committees in this House, and for the legal infrastructure, if I can put it that way. A very important role, Mr. Speaker, in the research that they do and the reports that they produce. It allows for a dialogue that goes on within the legal community particularly, but also in the political community. And they have helped foster that dialogue, that discussion, as to where we should be going with our legal system. Again, a great program that has now been cut, and I think cut, Mr. Speaker, illegally. This government didn't even have the gumption to bring forth a bill, which is what I believe they have to do in order to terminate the Law Commission. They didn't have the gumption to bring that forth because they know that all three of the opposition parties would have voted it down. But again, very clear indication of their attitude towards the judiciary, towards the judicial system, and seeing themselves as being opponents of that system and doing whatever they can in a variety of ways to undermine it. And then we have the appointments of the judges. Mr. Speaker, we see this government, and I mean, at a level of hypocrisy that's frightening, including the minister, who on the Justice Committee was very strong about us cleaning up the judicial appointment process to try to depoliticize it as much as possible. We have models at the provincial level where that's been done. They've been in power now for a number of months. They could have done it. We've heard nothing from that. And in fact, what we are seeing is that a good third of the appointments that have been made so far at the federal level are appointments of people who have very close ties to the Conservative Party. They may very well be good judges. The minister thinks he may in fact have done even more than those, Mr. Speaker, and it wouldn't surprise me if they have. We maybe haven't identified all of them. The point being, Mr. Speaker, is that it's again the cynical approach that they see to the judiciary, and one they see again. This is an opponent. We have to take care of them. That means we have to undermine them and do whatever we can to lessen their authority. Mr. Speaker, ultimately, it brings into disrepute this government, and it does, Mr. Speaker, attack the very essence of the constitutional structure in this country, and the important leg of that, of course, being the independent judiciary. I see my time is up, Mr. Speaker. I did have a number more points I wanted to make, but I will sit down in reference to the fact that I've used up my full 20 minutes. Thank you, Mr. Speaker.
Questions and comments? Honourable Member for Halifax.
Well, thank you, Mr. Speaker. I'm really pleased to be here in the House to have heard my colleagues' comments on the bill that is before us, C-17, dealing with the whole issue of compensation for the judiciary. And I have to say that I have enormous respect for the in-depth knowledge of the law by my colleague, which is why he's such a good justice critic, but also for his very, I think, profound understanding of what is so dangerous about this bill. And it would be very easy for the government to just sort of fluff it off and persuade people, well, judges are well paid anyway, so what's your problem? But I think what is clear, and I want to ask the member about this, is that it goes so much further, it's so much deeper, the concern about what underlies the proposed changes that are brought forward here in terms of an outright attack on the independence of the judiciary. And I want to ask the member, he referred to the fact that it is well known that we have an outstanding judiciary, respected in the world. And I've become aware as the international development and foreign affairs critic of how much judges in Canada and retired judges are sought after by countries around the world to assist with the judicial reforms needed in other countries. In fact, the new love affair of this government is to be talking about democratic development. And anybody knows that the reform of the judiciary and the independence of the judiciary is absolutely critical. And I wonder if the member might elaborate further on the stature of our judiciary. He said that they're not perfect, none is, but in terms of how they are seen not just within Canada, but literally around the world for their distinguished service to justice.
The Honourable Member for Windsor-Tecumseh.
Thank you, Mr. Speaker, and thank you, my colleague from Halifax, for the question, because it does give me the opportunity to point out the role that they play, both as retired judges and even active. They're regularly at international conferences, Mr. Speaker, to share their experiences of how they built the strong judiciary we have here in this country. But let me just take a couple of examples of the role. One of them is obviously Justice Arbour, the role that she played with regards to crimes against humanity, war crimes, the role that she's playing at the United Nations, being a typical, she's not atypical. She's good, very good, but she's not atypical. And the role that she played in that. And in advancing, which again I would guess this government, like the Bush administration in the United States, would be opposed to, advancing the development of international law and specifically an international criminal court that would deal with crimes against humanity, deal with genocide, deal with Holocaust. She's been one of the leading judicial figures in the world in leading that, in developing it. Let me use another example because it comes out of my law school at Windsor. The work that's being done with the direct active assistance of a number of the judges in this country of developing in Palestine a judicial system there, of dealing with the, quite frankly, the corruption that has permeated their judicial system in the past, the overabundance of direct conflict with the involvement of the political level in the judiciary in Palestine. Quite frankly, a program that was in serious jeopardy because of the decision by this government to cut funding to the Palestine government. But that has been used as a model, a program that was established, and the key part of it are the judges who come from Canada to Palestine to help them try to better their judicial system. I can go into the program that we've used in Russia to try and do the same thing. Again, with active participations by our judiciary in showing them that, yeah, the old Soviet system isn't the way to go. You don't have government telling your independent, or your so-called, in that case, independent judiciary. You, in fact, have an independent judiciary. And it's beginning to have some impact in Russia, even under the current government. So, and that's a role. And just the quality of the judges that we send to take part in that contributes to the development of a better judiciary right around the globe.
Further questions and comments? The honourable member for Yukon.
Thank you, Mr. Speaker. Just following up on the international aspect, I just wanted to comment that when the eminent member from Mount Royal went around the world shortly after the cuts to the Court Commission and the other body, I forgot the name, he was, other nations were astounded that Canada would cut these eminent institutions that were leaders in the world. But my question is, the Minister has very appropriately said yesterday in debate and at committee that this was a decision of Parliament on the Judges Act and the recommendations for judges' remuneration and benefits. And he said that in committee, that it was not a decision of the government, it was a decision of Parliament. And as that is outlined in the Constitution, Section 100. And I would just like to ask the member that as this process is unfolded, does he see it's unfolding as a decision of Parliament, that Parliament is unencumbered making that recommendation and decision?
Honourable member for Windsor-Tecumseh.
I thank you, my colleague from the Yukon, for the question, because it allows me to touch on just very briefly in my comments in my speech, but it gives me a chance to expand on it. Absolutely not. And again, the government and the minister is making they're making those statements that this is a decision by Parliament, but it's not, because they are refusing to say that if we did amend it, and I think there may be enough votes, although we've got the bloc over here that's got their own agenda on this, which again is very shameful, Mr. Speaker. But in any event, we're never going to get the opportunity. This House is never going to get the opportunity because the government has taken their position, which by the tradition of this Parliament they can, but have taken the position that if those amendments come forward to increase the amount that we pay our judges in accordance with the Commission, the Independent Commission's recommendations, that they will invoke the royal prerogative, they will refuse to make a royal recommendation, and so that will be by your chair, Mr. Speaker, those amendments would be ruled out of order because we don't have the support of the government to make those amendments, to present those amendments, because we won't get a royal recommendation. That's their role, and they are. I get the sense from some of the discussions I'm having with some of the contacts within the judiciary that they're putting out this message, they're spinning it, that it's Parliament that's making the decision. That's just absolutely false, Mr. Speaker, because we can't make the change. They won't let us. It's as simple as that. This is going through because they have taken that position, that they've cut the recommendations by 25%. Our judges are going to be compensated by that much less because of this government, not because of this House.
Further questions and comments? Now, member for Halifax.
Thank you, Mr. Speaker. One of the points that the member has just made is that, in a sense, the decision to cut the court challenges program is a frontal attack on the judiciary itself. And I think of all the bad decisions this government has made, one of the very worst is the decision to eliminate the court challenges program. I mean, in a country that I think has prided itself on ensuring that justice actually meant something, that there's actually a way for people who don't have deep pockets and high-placed connections with the government in power, that they actually can have their rights and their views upheld in the judicial process. But of course the government has thrown that on the scrap heap. And I wonder if the member could elaborate briefly on what he means when he says that in effect cancelling the court challenges program is an all-out attack on the judiciary.
The honourable member for Windsor-Tecumseh.
Again, I thank my colleague from Halifax for that question. Mr. Speaker, in some respects, it may be difficult, and I always get laughed at when I say this, that if you're not a lawyer, you just may not be able to appreciate this. And then you get all the boos about lawyers, Mr. Speaker. But I think it's true to some respect, and I'm not being arrogant. We have to appreciate just how important it is to have quality representation before the judge in order for the judge to make good decisions. And it's just about as simple as that. Perhaps a better way of describing this is, and this preceded me, I'm not quite that old, Mr. Speaker, but before we had legal aid in Canada, broadly based and broadly available, if you talk to judges who were practicing, who were making judicial decisions in our criminal courts at that period of time, of how difficult it was for them to make good decisions where you had the accused unrepresented. You'd have the Crown prosecutor who would be presenting the case for the state, but no one there to challenge the prosecutor, to put forth legal arguments, to present evidence in a better fashion than the individual untrained could. And it's like that. And so when we get rid of the court challenges program, it's the same thing. It's like cutting legal aid. You're just simply not going to have qualified people in front of the judges presenting good evidence and presenting good legal arguments. It's just not going to happen. And it's a shame that this has happened. Again, hopefully this government will be gone shortly and will reinstate the program shortly. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Scarborough-Rouge River.
Thank you, Mr. Speaker. And I think my remarks will pretty much follow along the same context as our colleague who just spoke. I want to, in my remarks today, capture three separate perspectives on this bill. Not because I'm looking in a rearview mirror, Mr. Speaker, but because the way the government appears to want to handle this matter will likely cause new files to open in the future. And the other place, next door to the House of Commons, will undoubtedly be interested in some of these perspectives as it reviews this bill. Well, as we all know, that the Supreme Court of Canada a few years ago decided that the only solution to the ambiguities and imprecision in the matter of setting judges' salaries or adjusting judges' salaries was the need for an independent commission which would study and recommend what those salary levels should be. And the commission has functioned for the last 5 or 10 years. The second last report, as I recall it, was implemented as the Supreme Court had recommended. It was a Supreme Court decision, Mr. Speaker. I guess that's a little bit more than a recommendation. It actually created the law, in that case in a vacuum, or in an arguable vacuum, taking into account the contingencies that the court felt were relevant at that time. So the report that we're dealing with now from the Independent Commission, not the report back from the Justice Committee, but the Independent Commission's report, was actually introduced a couple of years ago now. The last government introduced a bill that would have implemented the recommendations of that commission. That bill, of course, fell from the order paper at dissolution of the last Parliament. The new government now has introduced a bill that would reduce what the commission had recommended, reduced by a substantial amount. And I think part of the problem identified by the government, which they felt empowered to identify, was that in assessing what the costs and what should be paid to judges and the courts, there was a kind of there is a difference between street inflation in Canada and what I would call lawyer-judge inflation. And the Supreme Court recognized, and the Commission recognizes, that one of the functions of setting judicial salaries, one of the conditions or considerations, is that we have to be able to attract some of the best legal minds into the judicial profession. So in order to attract them, there have to be appropriate amounts paid in salaries. And so the court has accepted that lawyer-judge type inflation is very relevant to the setting of those. And the setting of those amounts actually don't have a lot to do, very much to do, whether one agrees with this or not, with what a bus driver might make in Winnipeg or what a fish plant worker might make in Nova Scotia. And as a result, you have these two different worlds competing. So when the commission, independent commission, makes its report, it's looking at the judicial lawyer type inflation and the salary amounts that should be paid to attract, continue to attract good people into the profession. Now, as I said, the previous government had followed through on that. The new government has not. And I want to now turn my attention to the legal infrastructure that's here in this place to deal with judges' salaries. Just so the record's really clear, Section 100 of the Constitution Act says that judges' salaries shall be fixed by the Parliament of Canada. Now, Section 17 of the Constitution Act says there shall be a Parliament of Canada composed of the Queen, the House of Commons, and the Senate. So our Parliament has three heads. I think most would agree the modern manifestation of the Queen would be the Privy Council, which, for all practical purposes, is the Cabinet. And the Cabinet is represented here in the House of Commons through the Prime Minister and the other ministers. Dealing with judicial matters, it would be the Minister of Justice. Now, there's another section of the Constitution which is a bit of a sleeper, but very important to us here. And notwithstanding that Section 100 says that Parliament shall fix judges' salaries, there's a Section 54 of the Constitution that says the House of Commons may not pass a bill or a motion that involves the expenditure of public money unless the government, the Queen, the Privy Council, has already given a royal recommendation for the expenditure of that amount. So as this House deals with these matters in the ordinary course, this House cannot increase any of this spending of public money without a royal recommendation. That's a very important thing, because what's happened here in this case is that the consideration of the report of the Independent Commission is done by this House. And while this House, under those constitutional rules, could reduce the amount recommended by the Commission and put into a bill for adoption, we could never increase it. So the best laid plans of the Supreme Court of Canada of setting up this independent commission, which then makes a recommendation to Parliament, is handicapped by the fact that there's only one player in the mechanism that has the ability to fairly implement, and that is the Privy Council bringing a bill in, a government bringing a bill in with the royal recommendation. But I would make the point here that it looks to me as though Section 54, requiring a royal recommendation, hobbles, handicaps, is an impediment to the House fairly dealing with this Commission report. And the independence that the Supreme Court of Canada had hoped for when it went through the Prince Edward Island case and the Bodner case has been lost simply because Section 54 requires the existence of a royal recommendation. We got one hand tied behind our back, Mr. Speaker, as we deal with this. Now, oddly enough, the Minister of Justice, and confirmed as recently as yesterday by his parliamentary secretary, said to the Justice Committee as we reviewed this report, if the Justice Committee wants to increase the amount recommended, go ahead. That's essentially what was said. Well, that coming from the Justice Minister, I would suggest to the House, in this circumstance, knowing the law as he should, I'm looking for an adverb or an adjective here, but that position could be described as falling on a spectrum somewhere between ignorance and deceit, sincerity in the middle. Surely the Justice Minister knows that the committee and the House could never recommend an increase or adopt an amount that was in excess of what the Privy Council put into the bill without a royal recommendation. And yet it appears that publicly they are giving this impression that they are open, that the government, the Privy Council, is open to Parliament fixing this amount of what they think, of what Parliament thinks, what the House thinks is appropriate, when all along they know full well that such an increase could not be implemented, recommended, moved, proposed, at least at the committee and even in the House, because there is no royal recommendation. And I would say now today, if the government was sincere in saying it's possible to raise these amounts to what the independent commission had recommended, I challenge the government now. I challenge the minister now. I challenge the members of the Conservative caucus in this House to say they will give a royal recommendation to implement what this House wants, what the committee would have adopted at committee had the proposed amendments to increase the commission's, to increase the amount in the bill, had they not been ruled out of order at the committee. And those amendments to reinstate the commission's report were ruled out of order. So if the government was really sincere in its suggestion that the House could increase the amounts, it must, Mr. Speaker, say that it is also prepared to provide a royal recommendation, which the government is apparently not prepared to do. Now, as this bill moves through third reading, it will move to the Senate, to the other place, and there's another rule in the Constitution which also says that the other place, the Senate, is not able to initiate a money bill or spending. So the only place in the whole world where one could implement an increase in this bill is in this House, but we have one arm tied behind our back because of Section 54 that says we need a royal recommendation, and that royal recommendation can only come from the government. So I regret that, and I wanted the record to show that, and it is most insincere for the Attorney General to hold that out, that he and the government are willing to see an increase, they will not come forward and say they will give a royal recommendation for the increase that might be there. So now that I've gotten that out of the way, I want to do two more things. The first is to talk about the independent commission mechanism that was set up by the courts. Looking back over that, it occurred within the last 10 years. It seems to me that while the court was sincere in wishing to create the independent mechanism and to have a vehicle that Parliament could make use of, I believe the courts overlooked some of these elements that I've described here today. The incapacity of the House to move anything upward or to make a move without a royal recommendation. At the end of the day, the one component of government that obstructs the court, i.e. the Cabinet and the Privy Council, is the one component that the court wanted to distance itself from when it set up the mechanism. The courts felt that there should be a degree of judicial independence, and it should not be in a position to go cap in hand to the Cabinet, to the Privy Council. And yet, after implementing this mechanism, after putting it in place, we are still stuck with the problem that was there before. The Cabinet, the Privy Council, still has that one piece of paper, the royal recommendation, that prevents Parliament from fulfilling its constitutional obligation. And there was a time at the committee, Mr. Speaker, when I was prepared, I didn't actually prepared to argue that the royal recommendation provision, section 54, I won't say it was unconstitutional, but because there was a conflict between section 100 and section 54, that section 100, empowering Parliament to fix the salaries of judges, should prevail over section 54. It's an argument for another day, not here. But I do suggest that in the event the court wishes to deal with this matter again, and the courts may, given what's happened here with this bill, that they make an attempt to implement an improved dialogue between Parliament and the courts. Just this one time. They don't have to come cap in hand here. They are an independent institution and have to be constitutionally. But if they are designing a judicial salary adjustment mechanism, and if Parliament is an integral part of that process, then the mechanism that they propose surely must be designed in collaboration with the institution, with Parliament itself. And I feel that had that dialogue occurred 10 or so years ago, the problem we have here today might have been avoided. The last thing I want to do is to connect some dots. And my colleague who spoke just prior to me actually did begin to connect some dots. And it has to do with the position of the current government, the Conservative government, that has, in one sequence of actions here, managed to clip the increases to the judges' salaries. Some would say not very respectfully, or at least respectful of the mechanism that had been put in place. They have managed to clip the Court Challenges program, virtually abolishing it, and the Law Commission, getting rid of the Law Commission. Now, what do all of these things have in common? Well, I'm going to try and connect some dots here. I could be wrong. I can only do this by inference. But it's very difficult for me to figure out why, in a period of relative prosperity in this country, where we've had balanced budgets and surpluses since 1997 or 1998, 7 or 8 years, surpluses every year, this government finds the need to get rid of the Law Commission and the Court Challenges program and to not implement the Independent Commission's report on judges' salaries. And the only thing I can see that these things have in common is disposition over the last 2 or 3 years of the same-sex marriage issue. And I recall the report from the Law Commission that had as its title Beyond Conjugality. It was a discussion of the law related to spousal, non-spousal relationships. And it contained a discussion, at least in part, of many of the same-sex marriage issues which this House has dealt with. So I couldn't help but detect some disfavor on the part of many of the Conservative members here. I've seen it at the Justice Committee. It's not always on the record. But it's there. And the Court Challenges program, which brings court charter challenges into the courts, And we'll all recall that the same-sex marriage issue, the redevelopment of the definition of marriage, of civil marriage, was accomplished primarily as a result of litigation charter challenge. I'm not certain whether the court challenges program funded any of that. It may have. I just don't know. But it's passing strange that I think there's a connection there. I can see it. And then the Law Commission. I mentioned the Law Commission, their report, and now the judges who made these decisions that essentially required Parliament to act a year or two ago. And I've simply had no choice but to draw the inference that the Conservatives' distaste for those decisions was a prime motivator in this, because I cannot see any economic or fiscal reason to turn attention to these very viable working mechanisms in our judicial sector. And I'll point out that the Law Commission, which is being scrapped now, was the reincarnation of the old Law Reform Commission, which was scrapped by the previous Conservative government in about 1990 or 91. Very strange thing. The Conservatives don't like law commissions or law reform commissions. They junk them. So I appreciate, Mr. Speaker, the opportunity to make those remarks, and I hope they'll be helpful for the record. Thank you very much.
Questions and comments? Honourable Deputy.
Honourable Member Alfred Pelland. Thank you, Mr. Speaker. I listened to the presentation made by my colleague from the official opposition, and it's true that when you debate an increase in judges' salaries publicly at the House of Commons, it's always sensitive for those who are concerned, and the same applied to parliamentarians. That's why our salaries are determined by an independent committee, and they set the rate of increase, of salary increase. Now, this can apply to judges as well, because a great deal of demagoguery can go into the debate when we compare judges' salaries and increases to those of politicians. And since he's very familiar with this area, I'd like to ask the honourable member whether he knows if judges would prefer to have another mechanism so that their salaries wouldn't be debated in the House of Commons whenever an increase is warranted.
Well, that's a very good question, because it goes to the core of why the Supreme Court originally recommended that there would be an independent commission whose report would be presented and essentially adopted as is, and thereby obviating any need for Parliament itself or the Cabinet or anybody else to actually go and reinvent the wheel and figure out how much judges' salary should be increased by. So the independent commission, as established, is the mechanism that the judges hoped would avoid this kind of a back-and-forth argument. And originally, it's worth noting, as the member mentions, when the mechanism was created for the judges, it was felt that members of the House of Commons and the Senate could simply piggyback on that same salary adjustment mechanism. But what turned out was something I referred to in my speech, was that lawyer and judge inflation is different than street inflation. And many of the members of the House just felt that we could not, in fairness, accept the relatively rich increases that were being generated in the lawyer-judge area, and we preferred to peg our salaries here to combinations. I think it's either the consumer price index or the industrial aggregate. Those numbers, those percentage increases, are closer to what I referred to earlier, where I guess the bus driver in Winnipeg and the fish plant worker in Nova Scotia tracked by Statistics Canada. So members got the right idea, and the Supreme Court had the right idea. At this point in time, I think the government is trying to change that, and the future will tend for itself.
Further questions and comments? Reprise de débat, l'honorable.
Resuming debate, the honourable member for Roberval, Lac-Saint-Jean. Thank you, Mr. Speaker. I'm pleased to rise to once again speak to Bill C-17, which deals with salaries for the judiciary, who have a federal responsibility throughout Canada, and it's a very delicate matter when we talk about judges' salaries, and we all agree on that. But for those who are watching and who are trying to understand, because the Bloc Québécois voted against this bill in second reading, we felt that the increase provided to judges by the government went well beyond the increases in other sectors of activity where the federal government is involved. So we felt it was important to explain why we are taking this position. On May 31st, 2004, the mechanism to determine judges' salaries tabled a report and recommended for judges and parliamentarians a salary adjustment of 10%, 10 point something percent, and parliamentarians' salaries were twinned by the previous Liberal government, not the one that was defeated in the last election, but during Jean Chrétien's time. It was determined with unanimous consent of the House that it was important to remove from public debate not only the judges' salaries but parliamentarian salaries as well. And so they did something at the time, something that we agreed with, and that is they linked the salaries of the judges to that of members of Parliament, because we felt that it was unreasonable that the Chief Justice of the Supreme Court, who has an important function but not as important as that of the Prime Minister, we felt it was illogical that the Chief Justice of the Supreme Court and other judges would have a salary that was much higher than that of the Prime Minister.
If they listen to us and they will act in good faith, they probably will say that it is quite normal. It would be a normal event. This idea trickled down, Mr. Speaker. If the mechanisms for establishing judges' salaries work that well, well then it should work for parliamentarians as well, because they will be establishing their own salaries. It's all right for parliamentarians to speak about establishing judges' salaries, but it is rather embarrassing for them to discuss their own. And public opinion was such that in the provinces, ministers, judges have salaries that are lesser than provincial justices. There should be some justice that should exist, some equilibrium. Citizens must know what the situation is. We had, under the previous government of Jean Chrétien, set the salaries of justices in tandem, twinned them with ministers' salaries. And here we have a request for some 10%. The minister at the federal level, who was there, the member, the Prime Minister at the time, the member for La Salle et Mar, hesitated. It became very, very strange. The 10% that was going to be given to members of Parliament because they were twinned with judges became something that was unworthy. Yes, it was a large increase when you know that the overall global increases in other areas of work is 2%, 2.5%, 3%, that type of increase. How can you justify that parliamentarians would be given a 10% pay rise? It was the mechanism for setting judges' salaries that accounted for it. So 10% for judges, then automatically 10% for members of parliament. I was told by people, oh, you're going to get a 10% increase. The Prime Minister became quite agitated and said, doesn't make any sense at all. Canadians can't afford to pay 10% to politicians. We also understood that it didn't make any sense at all when others were getting 2 or 3% increase across the board. We would be getting 10%. But when they decided to break up the legislation, to separate the parliamentarians from judges, parliamentarians stated the following: if 10% is a scandal for politicians because the people don't have the means to afford to give us an increase of that nature, well, on the contrary, they don't have the means to pay the judges 10%. There are more judges than there are members of this House. I try to understand the reasoning, the rationale of the member who was Prime Minister at the time, why he would say that it was a scandal. It was truly scandalous. They have to be separated, the one from the other. Employees cannot afford elsewhere to be given a pay rise like that, and so why should they get it? But what the citizens of this country didn't know was that the Prime Minister of the day was thinking that this increase, which was too rich for the blood of ordinary Canadians, was not too rich for the blood of the 300 or so judges in Canada. So for the Prime Minister of the day, it just didn't wash. It's because of behavior like that that we find ourselves in the situation that we are in today, where we have to reevaluate judges' salaries. We have to set aside a mechanism because there are people who, through political opportunism, who destroyed the credibility of the mechanism, destroyed the system, and here we are again leading Canadians to believe that they will be far poorer if they were to give too high a percentage of pay increase to judges or to parliamentarians. Well, we agreed with the Prime Minister of the time, but what's good sauce for the goose is sauce for the gander, Mr. Speaker. We agree. Therefore, it will not be given, but we don't give it to anyone. We're not going to give it to half the world and not the other. We're not going to say yes to half the world and not the other, the universe of these people who would be affected by a pay rise. But we're not wealthy enough to give this pay rise to members of Parliament, but we're wealthy enough to give it to the judges. What we want is justice. We want social justice here, Mr. Speaker. What is sauce for the goose is sauce for the gander. The decision should apply to both sides. The member for La Salle-et-Mar. The member for La Salle-et-Mar, the Prime Minister of the day broke the mechanism of the day. The Bloc said, okay then, we won't accept any other form of mechanism as long as they cannot guarantee that the judiciary will be treated fairly. Fairly means vis-a-vis the electorate, the citizens of this country. That is, that they would have pay rises that would correspond to the general across-the-board pay rise for ordinary citizens. Why would you give 4% increase to a deputy minister or an ADM, 4% to an official, a public servant who works in keeping the premises clean here, 4% for an engineer, for an accountant, 4% for members of Parliament, but for the judges, we can afford 7%. Well, Mr. Speaker, It's the same taxpayer paying. It's the same taxpayer that's going to have to ante up. And precisely because we want the judiciary to continue to be respected by the citizenry, to be independent, to retain the confidence and trust of the citizenry, we must at all costs avoid placing the judiciary in a situation where they will have a salary increase that has nothing to do with the across-the-board normal salary increase for those people who serve the state here in Canada at any level whatsoever. The judges serve the Canadian state. We want to have an independent judiciary. We want to have one that is not disconnected from the economic reality of this country. That is our reality, Mr. Speaker. In Alberta, the Bonne, in the matter of Bonne, the court recognized that the decisions concerning public resources belonged to the legislature and to the government, and with respect to any change in the recommendations of the Commission, there would have to be a legitimate ground. This is a reasonable basis. Well, all right, Mr. Speaker. And in giving due deference to the government's position, we can say that the wishes of the Commission were respected. But, Mr. Speaker, when you say the following, the Commission made its report. The government feels that the economy doesn't allow anyone to get a larger pay increase than those elsewhere in the economic society. It seems to me that this should be applied. But the government doesn't have the courage. Governments don't have the courage to apply the decisions that they should. Governments have this type of mania of wanting to, when it's a matter of public opinion, act in one way, but when the public are less aware of what's going on, they act in another way. I am ready in any circumstance whatsoever to meet with my constituents to justify the decision, my positive vote in this House. But I am not ready to meet with my constituents to explain injustice. I'm not ready to meet with my constituents to say that the government says, the Conservative government says it doesn't have enough money for very worthy causes, that it doesn't have enough money to help older workers, those older workers that have been let go in massive layoffs because of globalization. The workers of Roberval, the forestry workers of Roberval, who after having worked for 35 years in a shop, in a sawmill, as a shop as we call it at home, that they're just let go. They're tossed away like that at 60 years of age, 62 years of age, without having the pension that they need. They have to sell off everything they own, their home, their chalet, their cottage, everything they have, because they have to be able to live. I am not able to meet these people, look them in the eye, and say that the government doesn't have $75 billion to give to all those workers who were victims of massive layoffs in Canada, but it has the $75 billion to give to the justices, and they are going to give a 7.3% increase to judges. I respect judges, Mr. Speaker. I respect parliamentarians. But in all conscience, as a member of Parliament, I cannot say to my constituents that I agree with a salary increase that will be $14 million for the judiciary that already earns several $100,000. When you have these families that are living in poverty, because of the force of the economy, the strength of the economy, rather, and because of globalization. I'm sorry, Mr. Speaker, but I can't do that. There are some things that you can't do in life, and this is one of them. I can't do that. I like and respect the judiciary, but just apply the same criteria to them as are being applied to members of Parliament. When we talk about this enrichment of the collective wealth of society, Mr. Speaker, protecting the judiciary in that way against the populace, it seems to me that you cannot do that by giving them more and not giving anything at all to those people who are living in misery, yes, and poverty. They have a fair salary, yes, but to say that the judiciary in Canada to date, till this year, is 7% poorer than the average of people? No, Mr. Speaker. The judiciary in Canada is very well taken care of. It should be well taken care of. And the increase that is given to them should be linked to social and economic reality, which, Mr. Speaker, we cannot disassociate ourselves from. Mr. Speaker, I do not believe that objections have been heard from the other side. I would like to hear an explanation of reality. I would like to hear an explanation of how the judges' salaries are set. If I'm saying such terrible things today, what did I say that isn't right here this morning? That the Chief Justice of the Supreme Court should not have a salary that is higher than that of the Prime Minister? That doesn't seem scandalous to me. It seems to me quite rational on my part. We have to set benchmarks here, Mr. Speaker. And if you look at the discussion of judges' salaries, imagine the situation that people might find themselves. For example, a judge is appointed. He knows the profession well, but he also knows what salary is attached to the position. And then you appoint a lawyer. Well, we like lawyers. There are people who have some substantial remuneration as lawyers. And how can I say? They are quite successful in the area of business. And we have very successful businessmen for whom the salary of a judge may be a little less than they earn. All these people, I've seen this when I was a member in Quebec, all these people who talk about the salaries of members of the Legislative Assembly look at reports and they say, look at, do they want 20 or 25% more? They can't have that. It's normal. These people who are on a commission are trying to establish a baseline, but they are not directly connected with the ordinary reality that parliamentarians have to deal with on a daily basis. So what they do is establish benchmarks. It's all well and good to have a little committee set up to establish what judges' salaries should be, but it's up to the government to say that the committee should take into account, as it exists in the Judges Act, those benchmarks that are set by the government for the normal escalation of salaries. If it's 3% per year for other people, I agree that the judiciary should get 2 or 3%, just like we do as members of Parliament. That's normal. That's the normal progression, Mr. Speaker. But if the economy grows by 2 or 3% a year, I know that there are people who are already very well paid in society, but why should they get 10%? What do you have? Another report and another 10%? So what happens is that those judges who were paid at the same rate, more or less, as members of Parliament at the beginning of the 80s are now well above. It's not that I don't like judges. It's not that I don't believe that they do a good job. But you have to pay them with hand over heart. And when I put my hand over my heart, it means that I have to do my duty for all citizens of this country. And that includes the people who earn very small salaries, those people who do the housekeeping here in the house, those people who have to work at small jobs to make ends meet, those people who have to work for a living. The judges must demonstrate this respect and their capacity to adapt to the situation.
For Halifax.
Monsieur le Président, j'ai entendu.
Mr. Speaker, I listened very closely to the speech of the honourable member to understand the arguments that he was putting forward to the House.
I would say that I listened very carefully to the social justice arguments that were put forward on behalf of the Bloc Québécois that has allowed the Bloc to rationalize why it is supporting the government position in regard to Bill C-17. And I have a lot of sympathy for that social justice argument. I think that there is every reason to be concerned about the growing gap. There's every reason to be concerned about paying exorbitant, excessive salaries to one segment of population, even if you can make a case for a lot higher level of education and so on, as compared to working people. And I think he knows that my party, the New Democratic Party, is very much seized with the same arguments. But I have to say that I'm extremely surprised, frankly, that this member chose not to address at all what I think is at the heart of the government's actions with respect to this bill, and that is a serious erosion of the independence of the judiciary. And I listened carefully. The member made the arguments on the basis of comparability of salaries and so on. But what I didn't hear was any suggestion, whatever, coming from this member about whether his party has any concerns about the independence of the judiciary, which has been being severely compromised by the government's actions. They've been described as really that we're involved in a farcical process because the government knows that we don't have the means to actually act on even a decision that might represent the majority of this party because they're holding the power and the purse strings to do that in the processes. I didn't hear the member acknowledge that taken in and of itself, the encroachment on the independence of the judiciary represented by this bill is problematic enough, but taken together with the elimination of the court challenges program, taken together with the elimination of the Law Commission, you're seeing a very serious, dangerous, devious pattern here. And I wonder if I might ask the member to address those aspects of concern that have certainly been identified as a very serious aspect of what is going on here with the government's decision to basically throw out the independent process for determining the level of remuneration for judges.
The Honourable Member for Ocoberval, Lac-Saint-Jean. Mr. Speaker, I would like to thank the member for her judicious comments. I would like to clarify one thing, Mr. Speaker. The idea is not to abolish the mechanism or the structure for setting judges' salaries. The idea is to do what the law allows, which is to set parameters so that that structure can take into account the financial needs of judges and of the whole structure be tied in with the growth of the economy. Certainly the Commission can be told what the parameters will be, for example, the state of the economy, the cost of living, and the overall government economic and financial realities, the role of the hiring of recruitment and financial needs and so on for judges need to be taken into account as well. So We just need to keep the mechanism and put in place these parameters. For going beyond that, I don't believe that judges are any less independent, that they will be any less able to interpret laws and do their work if they get $220,000 or $260,000 a year. We need to look at what we are comparing that function with in terms of responsibility. There are levels of responsibility, people in the state structure, for example, the Deputy Minister of Justice, that has very important functions and no doubt has an equivalent level of education to Superior Court judges. We need to see how the state determines the level of responsibility and compensation. I do not believe that the ministers or the Prime Minister are less independent, less dedicated, less objective when they make their decisions just because they get a certain salary and not some other salary. Whether the Prime Minister gets $250,000 or $300,000 a year, I do not believe that that affects his independence. What we need is for each person to have salary equivalent to the responsibilities. So when I am told that the Supreme Court Justice needs the Prime Minister's salary less $1 and that other judges need to have their salaries set in consequence, then I don't see why that is necessarily the case. I don't see why the justices need to have a much higher salary than the Prime Minister. We need to pay them properly. We need to look at the capacity to pay as well. And what surprises me is the NDP amendments. Perhaps my colleague is unaware of this, but the NDP is proposing higher benefits than what the government is proposing. That is not 7.2%, but rather over 10% with indexing. And yet I know that the NDP is more interested usually in social justice rather than helping increase salaries for certain people. And I don't understand the basis of those amendments. The Honourable Member for Laval. Mr. Speaker, I listened carefully to the very sensible and judicious remarks made by my colleague. He talked about social needs of older workers who lose their jobs in mass layoffs. There are also people that need affordable housing, that need access to the guaranteed income supplement. There are people who no longer have access to literacy training because of government cuts, or older people who get 1.5% or 2% increases a year, people who have contributed to the wealth of our country. And then there are the veterans whose programs are not going to be improved. And could my colleague sort of make the connection between those and the judges' salaries? I want to thank my colleague. This will enable me to clarify something. Obviously, we have to avoid being all the rhetoric that can go with judges' salaries. Obviously, when we think about people who do not have enough in our society, we can't expect to make a tight connection with judges' salaries. But I know that when we look at the problem of the homeless, people who get this tiny pension increase and have difficulty living with it, and the average salary of public servants, which is not very high, then it seems to me that the government could do better for everyone, but do it within the government's means. And those means and resources should be taken into account in all cases. The government, within its means, could do a lot more for older workers, a lot more for the homeless, because we're talking about a lot of people, but it is not enough that the government would be threatened in its financial management. So the government should do more for the homeless, more for older workers that are subject to mass layoffs, and older people that need more support, and other groups in society that need support. We should do the same thing for judges, MPs, and public servants, and that is less than is what is proposed right now in this case, because the government's resources are important in taking into account what is logical for the homeless and for everyone, and especially for judges who are we have great respect for, but are not disconnected from reality.
Member from Yukon.
Merci, Monsieur le Président.
Thank you, Mr. Speaker. I'm very pleased to rise today to speak to Bill C-17, an act to amend the Judges Act and certain other acts in relation to courts.
And just before I start, I would like to say I've just come from a meeting down the hall with our delegation from Mongolia, and I certainly commend them for being here. I think we have a lot in common with that country, and I think it's delighted that we can be meeting with Mongolians that have made the effort to come to Parliament today. I'd like to just briefly comment on to the member of the bloc that just spoke. I think it's sort of good news and bad news. The good news is I recently, a few hours ago actually, made a recommendation of how eloquent a speaker he was. And that was certainly upheld by his speech today. I think parliamentarians should take quite note of how eloquent, and one of the keys in making an eloquent speech is that you only make 1 or 2 points, and he did that admirably, and it was a dynamic speech. The bad news is I disagree with the points that he made, the 2 points. One is I've always had difficulty in talking about salaries of members of Parliament, and I never thought that salaries should be decided by elected officials at any level, their own salaries. And the second point is I think comparing judges and members of Parliament is like comparing apples and oranges in a way. A special committee, independent commission was set up to do the research on a particular occupation group, and they did that research and came up with a recommendation. So you can't necessarily apply it to other groups because they may have different histories, different conditions, different situations. And so you have to, it's a more complex situation. I want to say that, and also I'd like to say that a couple of speakers have suggested that it's a delicate topic anytime you talk about judges' salaries in a debate. And I'd like to say that I'm not going to talk about the salaries at all because it would be a contradiction of the whole point that I'm trying to make in this debate, and that's the independence of the legislative branch and the government. So I'm not going to comment whether the judges are making too much, whether they're making not enough, whether the original recommendation was enough, whether the government's cut is too much, because that would defeat the whole purpose. The whole purpose is that we should not be have great influence over the judiciary, so it can be independent. And so I'll probably vote for this bill. Certainly the Liberals will be supporting it, but only under extreme duress. And I want to explain why that is today. And it basically, it goes around the whole argument of the independence of the judiciary. First of all, before I do, though, I just wanted to reiterate a technical point that I was making at the previous reading, and that's related to my jurisdiction, to the northern, actually as northern critic to the 3 northern territories. In the bill, the chief justices in the provinces are so named in the bill, but under sections 22, subsection 1, subsection 2, and subsection 2.1, it refers to what is really the chief justices in the territories as senior judges. This is an old, archaic definition that everyone basically agrees. There's been no objection in the House. The three territorial governments have suggested the names be harmonized. The Federal Minister of Justice at the time and the Judicial Council all recommended that just be modernized and updated so that the senior judges in the territories are also called the Chief Justices. As you'll see in this bill, they have the same responsibilities, they get the same remuneration, and so they should get the same name, and hopefully that technicality could be changed in the bill. The Justice Minister, and I would like to thank him, has taken this, he committed in the previous discussions, has taken this to the Prime Minister, who apparently has to make that decision, and so hopefully he can make that alteration, and just so we get that technical improvement that people are asking for in the titles of the senior judges, Chief Justices, so they're all the same. Of course, as the representative from the North representing the North, I'm totally in favor of the discussions related to Northern Allowance and the added costs of doing business and living in the North that are covered in this bill. Now, I'd like to comment on the, first of all, some of the witnesses. One of the first, I think maybe the first group of witnesses we had at committee was the commission that determined these salaries. And they were, I have to say, and just like some of us, they were apoplectic when I talked to them personally about this decision that had been made. They weren't apoplectic that their decision had been changed, but that the process had been politicized. You know, a previous government, they had given their report to the government. Previous government was carrying through with it, had agreed with the report, and was going to carry it on to maintain that independence of the judiciary with no serious reason to question it. And all of a sudden, a new government came in. I mean, what's changed from one day to the next? And they changed the recommendations. And the members of that committee just thought that that was exceptional politicization of the process and exactly what was not supposed to occur, what was trying to be created by the independence of this commission, and to not have political interference or legislative interference in the judiciary. You know, the reason that was given at the time was the costs, that the government couldn't influence its agenda the way they wanted to with its costs. Now, really, except for a few members on the other side of the House and the Conservative side of the House, I don't think anyone would really could really understand or accept that cost. I mean, a minor amount of $3,000 in the scope of the entire Canadian budget, and you're going to say that that would stop a government from implementing its agenda. In fact, in particular, we find it in a time when there's $13 billion surplus. I mean, it's really ludicrous to even consider that argument. And on top of that, as a matter of fact, the government has more cash than it ever expected to, in that it cut the Kelowna Accord. There's $5 billion extra. The daycare agreements that we have with the province, which would be $10 and $15 billion more. And they let all the greenhouse gas programs, or not all of them, but a number of them, excellent programs like EnerGuide, expire, so that there was all sorts of extra cash. So if you were to go on that rationale, they probably have too much cash and they should be paying the judges more. It just doesn't wash. I'd just like to give other evidence to the other opinions to the same effect. The way the system has been set up to maintain an independence of the judiciary is that there was this independent commission set up, and that commission had, you know, a member from the Canadian Superior Court, Judges Association, a member from the government, and then they chose a chair. And and this commission makes recommendations on the benefits of judges, and then unless there's serious reasons, and it's very specifically laid out as to the definition of those reasons, then Parliament would approve those and make the final decision. But as I was just suggesting, the government did not give any serious rationale, defensible rationale, under the under the guidelines, under the description that the Supreme Court of Canada gave. The Justice Minister, when we were decrying the very sad and senseless cutting of the Law Reform Commission, the Minister suggested there were a number of other bodies that could give advice to government. And one of them they suggested was the Canadian Bar Association, who, by the way, said at the time they were shocked that the government would suggest that because they don't have the resources and time to do all the good work the Law Commission was doing. But nevertheless, if the government wants to use the Law Commission as a reference, this Canadian Bar Association instead of the Law Reform Commission, let me just quote what the Canadian Bar Association submitted to committee on this bill. And it just backs up what I was just saying. More particularly, the government response fails to pay adequate heed to the constitutional imperative to depoliticize the process of setting judicial salaries and benefits in accordance with the principles set out by the Supreme Court of Canada. So it's not just coming from myself or from this side of the House and some of the other speakers that you've heard. It's coming from the Canadian Bar Association, who the Minister himself said was an excellent body to provide advice to the government. I'll go on. More particularly, the government response fails to provide adequate reasons and evidence in support of those reasons to deviate from the salaries recommendations in the 2003 Commission report. In fact, they went on, and they went on further, and I'll quote that in a minute. But the basis of the point that I'm trying to make today is on the independence of the judiciary. It is, as the Canadian Bar Association says, an independent judiciary is the cornerstone of a democratic society. This is, I'm sure all parliamentarians agree with that basic foundation of our constitutional democracy, of law and order acceptance in Canada, that there's a total separation of the judiciary and the legislative process. Because how could you have powerful legislators telling judges or influencing judges and their decisions and who they convicted and what they did, the types of sentences? Would that be fair? Would that be equal justice before all? Of course not. And I'm sure every parliamentarian would agree with that. And it's referenced in the Constitution, the independence of the judiciary, and it's just a cornerstone principle. As the Bar Association goes on to say, an independent judiciary is the lifeblood of constitutionalism in democratic societies. So it's this principle that I'm basing my arguments on today. I don't think anyone would suggest that if they were getting paid by someone influenced their salary, that could not have an influence on their decisions. Certainly all the employers I've had over my life who are paying me, I certainly took some deference to their opinions, to their views. So that is exactly why an independent commission was set up, that had to have serious reasons for altering its recommendations. I just want to go on to give further comments on the report and those reasons as identified by the Canadian Bar Association. The CBA believes that the government response is so generalized and so lacking in particulars, it fails to give a meaningful effort to the 2003 Commission report. Now, what the government submitted was two reasons. And the second reason that they provided, a technical reason, I give them credit, was actually accurate. It was accepted by the Bar Commission as a potential minor reason for some modification of the report. But they had this as the second reason, and their first reason, which was given much more prominence in the view of the Canadian Bar Association, was given much more prominence in their decision. There was no weighting specified in their decision, so it would be hard for observers to make an evaluation of that effect, but they seemed to give to the knowledgeable observers far more credibility to the first rationale, which was not found to be acceptable, which was not found to fall within the Supreme Court guidelines, which was not acceptable as a reason. So under those circumstances, the Canadian Bar Association just said that this is not acceptable. This does not maintain the independence of the judiciary, and so these changes are not appropriate. In fact, they suggested the best outcome for the judicial independence would be for Bill C-17 to be amended without delay to compare with the recommendations of the 2003 Commission. And I guess in the long run, that would be the best. But in that we live in the real world, in the day-to-day world, we also have to take into effect the other ramifications. The judges have now waited for, I think, 3 years out of a 4-year cycle. It's about to start next year again, and this decision is holding up the whole process. I certainly personally don't mind doing it on a matter of principle, but on the other hand, I don't want through these technicalities to hold up the process so that it can get over, so the judges can get on with their lives, so that the process can start again next year, and hopefully these considerations will be kept in mind. So I'm hoping that in the future that this is good warning to those people involved in this process, that they remember the great Canadian principle, the great democratic principle of modern constitutional democracies who believe in the rule of law, that there's the independence of the legislature and the judiciary should be maintained as much as possible as a very important principle of our society. So in conclusion, just one last reference from the Canadian Bar Association report to substantiate this, where they say if we carry on like this with this government bill as it was, it further risks damaging the judicial independence and the public support for the administration of justice. And we certainly don't want that to happen. As previous speakers have said, we have one of the most honored justice systems in the world. There are people from around the world that are looking for our retired judges to lead worldwide initiatives. There's great credibility, and part of that credibility is based on the independence of that judiciary to do their best. And I'm certainly, hopefully I've made that point strongly today, and hopefully that will be thought of carefully in the future when this process comes back in, unfortunately, not too distant future. Thank you, Mr. Speaker.
Questions and comments?
The Honourable Member for Alfred Pellant. Thank you, Mr. Speaker. I listened carefully to my colleague from the official opposition, and since I've been here as a member, I've met with many groups in my riding, older people, people who live in seniors' homes, and they complain about the small increases in the guaranteed income supplement that they receive as pensioners. The increases are very small, and they don't even equal the increase in the cost of living. So this bill that we have today provides an increase of 7.5%, and anybody working in any area would be delighted with an increase that size. You know that there are people living in very dire conditions today. The member for Lac-Saint-Jean mentioned Robertval, and all of the older workers, people who lose their jobs, and the government is constantly dragging its feet when it comes to helping them through programs that will allow them to make ends meet because they have no income. So I wonder how we can agree with this type of an increase when there's already an indexing mechanism that was used for parliamentarians, among others, and we felt it was reasonable. And this should be used to determine the increase in judges' salaries as well. So I'd like to know how the honourable member will defend this when facing his constituents. I'm sure that not everybody is wealthy in his constituency, so how will he explain an increase of this nature?
Thank you, Mr. Speaker, and I'd like to thank the member for the question. And I'd like to make 2 points. First of all, the point I was making in my entire speech would make it inappropriate for me to answer his question specifically on the judges' remuneration, because the point I was making is that is not our decision. That should not be what we are commenting on as legislators. We should not be trying to influence judges one way or another. I mean, if people know that a group has a charge over their salaries, how are they possibly going to be independent? So I'm not commenting on their salaries. Someone else, there are 30 million other Canadians, someone else should be making those recommendations, not us. We shouldn't be interfering whenever possible in those salaries. Now, there's a mechanism in place that the Supreme Court set up to somewhat preserve that independence. Now, if the member would like this escalator he was talking about to be a new system to put in place, there's nothing to stop the Bloc Québécois from suggesting that system. But I have to say I agree wholeheartedly with his point about the disadvantaged people and the seniors, seniors trying to get back to work. We had studies on that. And then how long did we put in a program? How many seniors are being covered? This government has attacked the most vulnerable since it's come in. We have income tax cuts and business cuts, which were wonderful. I'm totally in favor of those if they'd been even across the board. But why would you cut the poorest segment of society by increasing their income tax from 12% to 12.5%? Why would you give university students enough for a $70 book? And I had a student in the other day that told me her books cost $200 each, so she couldn't even buy an entire book with that when we were offering $3,000. Why, when you have a $13 billion surplus, could you not, again, as we did, increase the guaranteed income supplement? Why would you change reduce the my time is up. But finally, why would you reduce the amount available for the basic amount of deduction for your common average person when there's $13 billion in surplus and everyone could have achieved the benefit of that extra funds available?
Questions and comments. The Honourable Member for Halifax.
Sure, I listened very carefully to the comments from the member from the Yukon, and I have to say that I found favour overwhelmingly with his position, which was a very clear understanding of the importance of an independent judiciary, and secondly, his appreciation of the importance of having an independent commission determining the level of compensation, remuneration for the judiciary as part of maintaining that independence of the judiciary. I'm totally flabbergasted. I'm buffaloed because I don't understand, given how really cogent the arguments were, how clear an understanding the member from the Yukon seemed to have of why that independence of the judiciary absolutely must be maintained. He would nevertheless, at the beginning of his comments and again at the end, say, but he would be supporting this bill, which of course is being widely criticized because it does precisely what he has indicated is indefensible, is unacceptable. Now, I know he did say he would be doing it under extreme duress, and I guess maybe I'd like to hear him explain that a little bit more. The only other argument that I heard for why he was rationalizing support for this bill was a sort of pragmatic argument. It wasn't based on the important principles that he himself showed an understanding of. And I guess I find this doubly puzzling because if there was ever an important principle worth fighting for, worth preserving, absolutely refusing to allow to be eroded in any way, it is the independence of the judiciary because it's a fundamental cornerstone of a democratic society. And so if I understood correctly, I don't want to misinterpret, and that's why I'm asking for further interpretation. The member, I think, said, well, you know, we've now had 3 years go by since this 4-year independent review process has been set in motion. And I guess I have two questions. And as an argument, well, we're coming almost up to the end of the 4 years and we have to start the process over again, so let's just pass this, hold our noses doing it, do it under duress, and then we'll, respect the independence of the Commission the next time round? I mean, not to be provocative about it, but it seems as though the Liberals didn't really act on what needed to be dealt with, so that we're now 3 years into the process. Pretty hard. I mean, I find it terrifying, frankly, what the Conservatives are up to here, what the government is up to, because it's not just an isolated thing. It's about a frontal assault on the judiciary on many fronts, court challenges, law reform, commission elimination. But they've only been in power for, 8 months. So, where have the Liberals been in dealing with this with dispatch?
The honourable member for Yukon.
I appreciate the question, and I agree with most of what the member said. We certainly tried to act on this. As you know, we were trying to bring forward amendments. I think her colleague on the Justice Committee mentioned that earlier. We tried to bring forward amendments on this, and we were ruled out of order because we could not have a royal recommendation at the time. So we did everything in our power under the present procedures to get this point across and to implement in the committee. I said at the beginning of my speech that I would probably vote for this, and it was under duress, and my speech was basically all the reasons as to why I had a problem with it. But as she correctly outlined, the reason that I said I would likely vote for it is that after discussions with most of the people involved, they don't want this to hold up the next process, which once again, in a way, would be holding up the operation of an independent body and the independence of the judiciary. Because they couldn't get started on the next round because we're holding it up here with technicalities on a case that I seem to have no chance of winning. So, as I said, I may or may not vote for it, but certainly the people involved would like us to get on with it. But as I tried to give a passionate desire that the next time that people keep this in mind, we may have lost this battle this round, but we certainly inflicting enough damage that people are going to consider this more seriously next time. And I totally agree with the member that this is a fundamental principle of our law-abiding, law-respecting, constitutional democracy that we can't stop fighting for it.
Thank you, Mr. Speaker. Questions and comments? The honourable member for
York South-Weston.
Yes.
Thank you, Mr. Speaker. York South-Weston. Mr. Speaker, my question to my colleague is related to, again, the independence of the judiciary, and I think that is part of the checks and balances of our system. And he's made the point very well that he fears that the concept of if Parliament pays the piper, then Parliament should call the tune, and that, of course, would compromise the judiciary. But there's another facet, and the fact that Parliament is debating the bill in the form that it is in setting judges' salaries is, in fact, Parliament's role. And so it seems to me that's a check and balance on...
I apologize to the honourable member for York South-West, but of course I did have trouble remembering his riding name because I often have to refer to the seating chart to help remind me which member is from which riding. And he might find that he was over a couple of rows from his normal place. But I see now that he's a little bit close to where he ought to be, and continue on with his question. Just about 30 seconds left.
Thank you so much, Mr. Speaker, and I do apologize once again.
Point of order? I would like to know why he's sitting in the seat of my colleague from Berthier-Montcalm.
The honourable member for your request.
I think this is very, very short, and I apologize. Mr. Speaker, to my colleague, could he simply indicate what other checks and balances, for example, in the appointment of judges, that Parliament would be able to assert that there was a very clear and definitive difference between its power to appoint, its power to set salaries, but it would not compromise the objectivity of the judiciary?
The honourable member for Yukon, just about 30 seconds in reply, please.
Okay, just in case people that are watching wondering what's happening, you have to be sitting in your actual seat to be able to speak in Parliament. To give the government credit, there is one clause in the Constitution, Clause 100, that says that Parliament sets these salaries. But what I was trying to say, we have the independence, there's appointments, there's a whole process that keeps the appointments very detached from government, although they make the final decision, but that's an appointment for life. They can't revoke it. They can't take it back. And so there's the independence there. It's not like having an influence in setting the salaries every year.
Reprise du débat.
Resuming debate.
Government whip on a point of order.
So agreeable. Thank you, Mr. Speaker. There have been discussions between all the parties, and I think you would, if you were to seek it, you'd find unanimous consent for the following motion: that whenever debate concludes today on Bill C-17, that the vote on third reading of C-17 be deferred to Tuesday, November 21st, 2006 at 5:30 p.m.
Does the Honourable Chief Government Whip have the unanimous consent of the House to move the motion? Agreed. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed. So ordered. Reprise du débat.
Resuming debate, the honourable member for Montmorency, Charlevoix. No. Thank you, Mr. Speaker. I'd like to take this opportunity to congratulate you for the way in which you conduct the business of the House. When you're in the chair, everything goes like clockwork. And I'm happy to speak to C-17, which amends the Judges Act and other acts in relation to courts, particularly judges' salaries. And I would like to tell you that the Bloc Québécois is not in favor of the principle of this bill. I'll explain why, and I will also explain what we from the Bloc would suggest, particularly the Conservatives say after question period or when they have an opportunity that the Bloc is useless, the Bloc doesn't make any suggestions. And I might remind you that the Bloc doesn't simply criticize, but it suggests corrective measures when dealing with legislation put forward by the government. And when the legislation is acceptable, then we don't want to engage in partisanship and say that because it comes from the government or another party, we're not going to agree with it. But when the legislation is not acceptable, then the Bloc Québécois doesn't.
Loud and clear, and suggest some corrective measures. So, Mr. Speaker, this bill proposes a 7.25% increase in judges' salaries as of April the 1st. Yes, Mr. Speaker, you heard the figure right, 7.25%. I now address the people watching us in the galleries or those who are watching us on television. I think our viewers should ask themselves if they know many people who've gotten a 7.25% pay rise in the past few years. As my colleague from Alfred Pellin mentioned, when you go into the senior citizens clubs or go to some centre d'accueil, the people say to you, "Oh, Mr. Guimont, my check went up last month. I got 18 cents more. I got 46 cents more." At 18 cents more and 46 cents more, you can't even buy yourself a cup of coffee a week. It's very important for us to stress the fact that this is a pay rise for judges who, I might say, are not underpaid. It's a pay rise of 7.25%. I should say from the outset, Mr. Speaker, that the Bloc Québécois is not on the warpath against judges per se or the judiciary as an institution. What we have here before us is legislation that provides for judges getting 7.25% increase retroactive to April the 1st, 2004. This is what we're talking about, Mr. Speaker. I want no confusion about this, no ambiguity.
Le Bloc Québécois.
I don't want anybody to say that the Bloc has something against judges. We in the Bloc Québécois feel that this salary increase is unreasonable. I will explain what happened, how this came about in terms of the process, what existed before, and what happened to make it change so that we have a bill like this one before us. By constantly changing the recommendations of the commission that establishes judges' salaries, the Conservatives are unduly politicizing the process for setting judges' salaries. This was done in the past by the Liberals, and the Conservatives have followed on the tradition of the 13 years of Liberal hypocrisy with respect to judges' salaries. I will explain, Mr. Speaker. They realized that it was delicate. It was a very sensitive issue for members of Parliament to vote their own salary increase. There were comments, there were editorials, and the people in general, the citizenry that we met in the street, in shopping centres, or in social activities, made comments. Sometimes they said, it doesn't make any sense. You give yourself your own salary increase. Indeed, that was the case. At the time, the Liberal government, the government of the moment, approached us. They wanted to have a different process to set salaries for judges and for members of Parliament. There exists a commission for setting these salary increases. It looks at a variety of criteria, the cost of living, inflation, the inflation rate, and it also looks at the various collective agreements throughout Canada. It's a very complex system, and in a 20-minute speech I really cannot explain it adequately. But members, it was felt, through changing this system, in taking the recommendation of the Commission, would no longer have to vote on giving themselves a pay increase. I was in committee at the time, and our parliamentary leader, when he took our House leader rather, when he spoke earlier today, set out the fact that certain principles, basic principles, were established. For example, to set the Prime Minister's salary, the question was asked, who is the highest public servant in the land in terms of ranking, but who is also appointed by the Prime Minister? That person is the Chief Justice of the Supreme Court. Thereon, the following question was asked: is it normal, acceptable, realistic for the Prime Minister to earn the same salary as the highest bureaucrat that he appoints? Having answered yes, it meant that there was a threshold that was set, that is, that the Prime Minister should have the same salary as the Chief Justice of the Supreme Court. A second question was asked: is it normal, is it realistic for a minister who has a little less responsibility than the Prime Minister, but a bit more responsibility than a Member of Parliament? I'm not talking about ordinary member or backbencher, I have to explain that everybody here is a member of Parliament. Even the Prime Minister is a member of Parliament, contrary to, and the ministers are members of Parliament. It's not like other countries in the world where ministers can be appointed into cabinet, but they are not elected by their constituents, by any constituents. Therefore, the following question was asked. A minister has more responsibility than an ordinary member, but less responsibility than the Prime Minister. Therefore, is it normal that a minister should earn 75% of the Prime Minister? Having answered yes to this part of the question, the salary was set for ministers. The third question was this: what about the other members in the House? Myself and most of my colleagues who are here today, who are listening with great attention to my speech. Is it normal? This is the question. Is it normal for these members to earn 50% of the Prime Minister's salary because they have fewer responsibilities? So they would earn 50% less and 50% less than a minister. In that way, the member's salary was set. So the pay scale of the 308 elected members of this House were linked to the recommendations of this totally independent commission, and therefore to judges' salaries. But then what happened? Base partisanship intervened in 2004 when the Liberal Party was in power. The Prime Minister decided, no, it doesn't make sense anymore for these members' salaries to be spoken of in terms of judges' salaries, to be linked to judges' salaries. That has to come to an end. And I will, if time permits, explain the figures. The Chief Justice of the Supreme Court, as a result, will now earn more than the Prime Minister. Therefore, the highest-ranking official appointed by the Prime Minister will earn more than the Prime Minister. I worked 16 years in the bureaucracy before coming here, and I never saw a worker earn more than the manager of a plant. Unless, of course, this was such an exceptional set of circumstances that they got extra pay, they worked all the time and whatnot. But I can tell you that if a worker works too many hours, he can't go beyond the occupational health and safety rules that set 16 hours overtime. But this structure that we have before us today was initiated by Tony Valerie, the House Leader at the time, but was continued by the Conservative government. They broke the link between members' salaries. They uncoupled the boxcar of members' salaries from the boxcar of judges' salaries. This is why, through our House Leader, we, in good faith, agreed to support that at the time. We didn't want to play politics. We weren't trying to say that it was just meanness and mean-spiritedness towards the judges. We agreed to it then, but now why should it be different today? When I read this, and I can say that members got an increase of 2.4% for this year, which, to my mind, because I still have contacts in the private sector and in the public sector, I think that corresponds to the normal progression of increases for unionized workers, for organized workers in major areas, for example, in mines, in the automobile industry, in the pulp and paper industry. Unfortunately, we don't have much of an automobile industry left in Quebec now. But 2.4% salary increase is, to my mind, a reasonable one, an acceptable increase. But when you come to the 7.5% or 25% that the judges are going to get, I find that totally unacceptable. What we in the Bloc are saying is this. We propose a mechanism that will set salaries independently for both members of Parliament and for judges. We want to see the government reintroduce the legislative obligation that links members' salaries to those of judges also, because indexing is necessary and has to be reasonable for both judges and members of Parliament. We want to have the same mechanism for judges in terms of indexing as members have, and we want to link that to the increases that are given in the major corporations for their workers. Mr. Speaker, this is most of what I had to say to you on this subject. For all these reasons, I can say that the Bloc Québécois will not support this legislation, at least the principle of this bill. It will probably be referred to Procedure in House Affairs, where I sit as a member. At that time, we will assess whether or not amendments should be made to it. But I can tell you that this bill is totally unacceptable to us, and I hear the Liberals and Conservatives speaking with the same voice on this matter. It's just hypocrisy, pure hypocrisy. It is not that we are being mean-spirited or that we have some vendetta against judges that we are making our proposals. I don't want any ambiguity about this, about the tenor of our remarks. We have this bill, C-17. The Bloc Québécois is making its comments on Bill C-17 as it stands before us today. So let there be no misunderstanding about what we say. Let there be no personalizing of the debate with respect to certain individuals. Thank you, Mr. Speaker. Questions and comments? The Honourable Member for Alfred Pelin. I would like to say that I'm very proud to belong to a political party that opposes an increase of this nature, 7.25%. When I will be visiting and meeting with my constituents next week, when the House isn't sitting, we will have a great deal to discuss. There are many people who have minimal increases. For example, these tiny increases of 1% in a pension. These people are living practically at the poverty line, and they have great difficulty living decently. And I'm not even mentioning the unemployed or the older workers who lose their job and for whom the government is doing absolutely nothing at the present time. I would like to bring up another point to explain the reason why I oppose this increase. I know that the federal judiciary is paid much more than the provincial judiciary. In our province, Quebec, the judges in the provincial court ask for increases to reach the salaries that are given, that are paid to justices at the federal level. And this creates a snowball effect. I know that the government is quite prodigious in the salaries that it allots the justices. Perhaps there's too much money. We all know that here in Ottawa. That might contribute to this particular matter. So I would ask my colleague from Charlevoix, Montmorency, La Gaspésie what exactly he has to say about this. The honourable member. Yes, my colleague had some difficulty with my riding. He called me Moment Charlevoix Haute Gaspésie, so I think I should say that I have a riding of 351 square kilometers only on the north shore of Quebec. If I say that it's the Haute Gaspésie, I'm going to get into a lot of trouble with my constituents. But just to get serious here, my colleague is right. Of course, until Quebec attains sovereignty, when we have our own processes for setting Quebec judges' salaries in Quebec jurisdiction, but while awaiting sovereignty, this bill is pressuring, yes, is certainly pressuring the whole system for remuneration in Quebec jurisdiction. Questions and comments? The honourable member for Lévis-Bellechasse. Thank you very much, Mr. Speaker. I listened intently to my colleague's speech and also to the questions that question that followed. And with respect to the changing of the splitting of income for persons who are on pension, all he has to do is think about what we announced last week. When we talk about provincial judges' salaries and federal judges' salaries, the government has means, but it respects the pay level. My colleague talked about something that was not quite exact. He said that it's abnormal for an employee to earn more than the boss. I might say something about that, but in passing I want to say that I support our judges getting good salaries. It's very important. And we have an old saying in French, when you pay peanuts, you get a monkey. So he should bear that in mind with respect to the judges' salaries. My question is this. In a hospital, the hospital director earns more than the doctors who work there. And it's very important for the hospital to work well. So how does this sit with the argument that he was making?
Honourable member for Montmorency, Côte-Nord. Well, to make a distinction between, well, I can answer your question, but we need to really focus on the judicial salaries. I was actually a hospital director for 2 years, and doctors are paid by the Act and not a director who gets the salaries. And I can tell you that the director of professional services in a hospital, the director of professional services who is a doctor, it does not get more than the director general of the hospital. I was at level 14. The director general was level 15, and the overall head was level 21. But doctors, as we know, have privileges. They get paid for the work that they do. And Dr. George L'Espérant, who operated on me for the carpal tunnel syndrome, is not paid a salary by the hospital, even though he has privileges at the hospital. So in the private sector, there is a salary structure for management and a different one for unionized workers. So we could have a long debate on that. What is the member really looking at here? In the structure proposed by the Bloc Québécois, this bill, and I want to show you how the Bloc Québécois is nonpartisan in certain cases. We are not always partisan in every case. Because what we're calling for here is the old system where the Chief Justice had the same salary as the Prime Minister. But with this bill, the Chief Justice will get $3,000 more than the Prime Minister, and we find that unacceptable.
Questions and commentaires,
Questions and comments, the honourable member for Brossard-les Prairies. Questions and comments still? Yes. It's Virtue les Patriotes. Thank you. In his remarks, the Chief Whip of the Bloc Québécois indicated that the previous government, the Liberal government, who was the driver of the best way of compensating judges. But the Chief Bloc Web also said that the Liberals did a flip-flop, and the Liberals are now supporting this new bill brought in by the Conservatives. And so I would like to ask him, because the Chief Bloc Whip has been on the committee for a number of years, to try to explain to us how this radical change has taken place with the Liberals. The honourable member for Montmorency, Charlevoix, Haute-Côte-Nord. Well, simply, I think they are playing politics with the MP salary increases. The committee had suggested a larger increase, and in order to show themselves in a good light to the public, in fact, we were hitching our salaries to the judges' salaries, and that was the way the system worked. Everyone knew that. But now we have a suggestion from the Independent Commission for a higher level for the judges, and now the Liberals are saying, no, that is too much, and people are going to criticize us. The fact that it was decided on by the Commission meant that the parliamentarians were no longer voting on their own salary increase because this was a neutral, independent commission. And now the Liberals want to say that, okay, for the judges this is fine, but not for the parliamentarians. What we said at the time, and there the Bloc Québécois is being very consistent, because people listening to us will say, apparently only the Bloc Québécois is against this legislation. Why? Because we are being consistent. We're being consistent with what we said in 2004. At that time, we said it makes no sense to take that approach. We opposed it, and we said that we are not going to support the judges' salary increases because you are not, because of that reform. So we said that we were going to do that for the Judges Compensation Act. We know that the Conservatives have changed the situation, or rather we thought they would, but in fact they're acting just like the Liberals.
Reprise du débat.
Resuming debate.
Reprise du débat.
Resuming debate, the honourable member for Abitibi-Témiscamingue. Thank you, Mr. Speaker. I would like to point out that I will criticize the whip here because we are, but just at the beginning, we are at the third reading, and so the bill will not be able to go back to committee. Rather, I'm going to I will do this here in the House. He said that the bill could be reviewed, which we did in the Justice Committee. We considered Bill C-17 after second reading only a few days ago. And I find it strange, Mr. Speaker. In fact, extremely strange. More things change, more they're the same. The Liberals had put in place the same system for judges' salaries, and the Conservatives, because they wanted to make the judges happy or make someone happy, decided to go ahead with the same approach. But I want to beginning by saying that judges under federal jurisdiction are part of a constitutional responsibility as far as their compensation goes. So the federal government has to provide the salaries, pay those salaries, and there has always been a problem, Mr. Speaker. We saw this in the committee. The Minister of Justice came to explain his approach and his vision, and the senior officials as well. And everyone finds this problematic. If I can use this expression, judge's salary, with all due respect, is kind of a hot potato for the various government authorities and the various political parties that have problems with it. But the only party that doesn't have a problem with it is the Bloc Québécois, because we don't aspire to take office. We are here only until Quebecers decide as a majority to go in the direction of sovereignty for Quebec. We have no interest, and we think that we can speak to Canadians and tell them enough is enough. Mr. Speaker, I just called you Your Honor. I think you deserve a much higher salary, because a judge, and this is what I was going to say, if we allow this bill to become law, the Chief Justice of the Supreme Court will earn more than the Prime Minister. And this is irrational. It is irrational, and I do not accept this idea. I do not agree with the idea that the Prime Minister of Canada should earn less than the highest official in the country. So the Chief Justice would get $278,000. The Prime Minister would get $275,000. Senior court justices would have over $247,000, and that would be retroactive to January 1st, 2004. This would put undue pressure, and I am trying to express this in my own words. I have 25 years of experience in criminal justice, and I have pleaded before superior court justices and appeal court judges, and of course the same applies at the Supreme Court. At the current time, right today, and I think it is November 9th, there are nearly $50,000, which is the gap between the superior court judges and judges at higher levels. What is going to happen then? We will find that people lose interest, or the provinces, in particular the province of Quebec, will have to increase judges' salaries to close that gap between provincial and federal judges. If they can do that, to bring the salary nearer to the superior court judges, and that will be very expensive. The Bloc Québécois does not agree. We do not agree that a 7.25% increase should be given beginning April 1st, 2004, with indexing as of April 1st to every year. And that means, in ordinary words, that 7.25% would be given as of April 1st, 2004, and then indexing to the cost of living after that. Why? April 1st, 2004, there was a 2.5% cost of living increase. So why the extra 5%? We're not talking about $2,000 or $3,000 a year, but when you look at $250,000, then 7.5% is a whole lot of money. We believe that it is unacceptable and that the Canadian public, even if the Bloc Québécois is the only party to say so, we believe that the Canadian public is not or would not be in agreement with this if they were well informed, like we are here in the chamber and like we were at the Justice Committee, because we heard from all the experts and they told us that the increase was much too high. What we would like to see is for the Commission on Judges' Salaries should be allowed to do its work. And let me explain that. The government knows this is a hot potato, therefore it appoints a commission. The commission presents its report. The government doesn't like it. It scraps the report and tells the commission to start over. Whether we're talking about the Liberals or the Conservatives, that is the way it has worked for a number of years, for far too long. So we found a way to do this, which was to set up the Commission on Judges' Salaries. And I think, having had the opportunity to hear from the chairman of the commission, as well as the two members, Mr. McMillan and Ms. Chambers, and I've forgotten the name of the other male member of the commission, we were told that they looked at every aspect, they met with everyone concerned, and here are our recommendations. And sometimes we hear the question, why should the government get involved in this? In fact, the Commission has been asked to do the work and should be able to come up with its recommendations to solve the problem. With the previous government, we, in fact, were of the opinion that the Conservatives are being hypocritical, saying that we do not want to acknowledge the work of the Commission. Instead, we want to introduce a bill. We have to look at the bill, though, Mr. Speaker. It is so complex. I've looked at it, and we see that there are all sorts of classifications. We've got the federal court judges, the appeal court judges. We've got those that go into the northern territories. We've got those that actually work all the time in the north. We are making a whole Gruyere cheese full of complexities with this. But the Commission had actually addressed and resolved that problem. What we propose is a mechanism to set judges' salaries that is independent, not only for the judges' salaries, but also for those of parliamentarians. We have already said this. We're not talking about increasing MP salaries to $300,000 a year. What we want to have happen, and this is what used to happen, is that the MP salaries, parliamentarian salaries, would be set on the basis of those set by the Commission for Judges. And the idea behind that was to prevent parliamentarians from voting unacceptable increases for themselves. This is something that we said. I was not in the chamber at that time. I was a practicing lawyer in the area of activité mesquin. We talked about this at the Bar Association. We thought it was an excellent job. Parliamentarians, MPs, as well as their staff and judges would not be in a conflict of interest situation, but that's no longer the case. What is now being done is we've got C-17 for the judges, and the MPs will be dealt with at some other time by this government. We would like to have judges' salaries be based on the same indexing mechanisms as those of parliamentarians, so that those salaries would increase at the same rate as unionized members in the private sector. And we're talking about 2.4% around there, and that should be the indexing based on cost of living increases that should apply to everyone. But instead, this government wants to make judges a special category. They are giving them 7.5% retroactive to April 1st, 2004, and then indexing after that. Why? I don't really understand. Why 2004? They tried to explain this to us. The minister and the officials talked about the judicial independence and so on, but it seems to me that $250,000 a year should protect the independence of judges. Why give them 7.5% extra retroactive to January 1st, 2004? And that will mean that judges will have about $280,000 as their salary. So we find this excessive. We are planning to vote against this bill, even if we are the only ones in this House to do so. The Bloc Québécois will vote against the bill. Unfortunately, it is quite likely that the bill will be supported and will pass because the Liberals are playing the same game as the Conservatives, and they will probably give the judges a good increase. Perhaps they've got aspirations, but with time, the public will not accept this. We think it is unacceptable.
We have said time and again, we want the judges' salaries to be based on the same mechanism, the indexing mechanism that is applied to members of Parliament's salaries, because we have a 2.4% index now, and I don't understand why the judges wouldn't have the same increases, that is 2.4% per year. I don't know how much time I have left, Mr. Speaker, but I'd like to say one thing before I end my speech, and that is that we would like the government to reintroduce the legislative obligation relating or tying the salaries of parliamentarians to that of judges. And I'm sorry, Mr. Speaker, 5 minutes? Oh, well, then I won't hurry to conclude, and questions will come after that, so that will give me another 10 minutes. I see that my colleague for Lévis Bellechasse is in such a hurry to ask me questions, and I'll be happy to answer them. And I have an idea what kind of question he'll be asking. But what I wanted to say, Mr. Speaker, is that at the Supreme Court, we asked for a special appointment procedure because Supreme Court judges are appointed by the Prime Minister from names on a list, and we would like Quebec or a provincial government from a region that has a position to fill to submit a list, and federal members could review the list, which would then be submitted to the Federal Justice Minister and to the Prime Minister for a final decision. The Liberals had understood that. I hope that the Conservatives will understand it as well. We would like the same to apply when it comes to appointing judges for other federal courts. That is, there should be committees. And the independence of judges is essential, as far as we're concerned, to safeguarding our judicial system. And we on the side of this House, and I don't think I will be denigrating anyone when I say that all parliamentarians believe that one of the fundamental principles for our judicial system is the independence of the judiciary. I think everyone agrees with that. So what we would like is a system that would ensure that the judges who are appointed, for example, the Superior Court judges, at this time, it's the same as it always was. That is, the Liberals appointed Liberals, Conservatives will appoint Conservatives, and we have evidence of this. We saw this at the Justice Committee when the Justice Minister said that he had a list, and he said it in the House as well. He had a list, and on the list, all of the names were names of Liberals. And he asked the committee to go back to the drawing board. And all of a sudden, there were judges, potential judges, who had worked for the Conservative Party. Now that's unacceptable. That, and I can give you because I sat in Quebec on a judicial appointment committee, and you know that I did not aspire to becoming a judge, but I did sit on a committee. It was an independent committee, someone from the bar, someone, the Chief Justice of the relevant court, and someone from the public. We drew up a list, we met with all of the candidates, and then we gave the minister a list with 2, 3, or 4 names, and the minister used that list to appoint a judge. I asked the minister this question. I will ask again here in the House. Why could we not have the same type of system? This is a question that I put to the previous Justice Minister, the Honourable Member for Mount Royal. Yes, I've got it right. And I asked the current Justice Minister as well, and I still haven't had an answer. In this House, we have to reiterate the importance of the independence of the judiciary. And in closing, because I see that my time is just about up, Mr. Speaker, and to allow questions by my honourable colleague, Felipe Belchas, and others, I would say that we are against this bill. We will not be supporting this bill. We may be the only ones in the House to vote against it, but we will have maintained the same position during our entire time here, and as long as we are still here, and in coming years, if we're still here, because of the survey we saw this morning, we will be here to represent the interests of Quebec and defend until sovereignty the interests of Quebec. And one of these interests is that judges should not be receiving any more than a cost of living increase, and the cost of living at this time is 2.4% per year. So no one can explain why they should be getting any more than that. Thank you, Mr. Speaker. Questions and comments?
The honourable member for Winnipeg Centre.
Thank you, Mr. Speaker. I share many of the concerns raised by my colleague from the bloc regarding judicial appointments and compensation, and I found it useful for my colleague to outline the way the selection of judges is undertaken in the province of Quebec. And I should point out and ask him his views on this as well, but it is kind of mystifying that the current Minister of Justice, who comes from the province of Manitoba, should deviate so wildly from the practice of selection that we use in the province of Manitoba. The difference being that the committee that chooses or that recommends judges on the federal scene is established by the minister and exists at the pleasure of the minister, and the minister can take their recommendations or not take their recommendations as he sees fit, whereas the commission that puts names forward in the province of Manitoba is in fact appointed by the minister. It is those people are selected by the minister from a short list developed by other outside agencies as per the Provincial Court Act. So legal groups, the Law Society, etc., would recommend those names. So I guess I would ask my colleague, what we've heard from the current Minister of Justice is he would like to begin putting police officers on the commission that recommends the names of judges. Does he not feel that this is politicizing, I suppose, the judicial selection process, in that clearly the Minister of Justice has made no secret that he's frustrated by what he believes judges who are soft on crime. In other words, he's trying to put people on the commission who will put forward names who will suit his own views to rule in the way that he sees fit. That way, to me, lies danger. We should all, alarm should go off when we see an effort to politicize the judiciary. And it's one of the cornerstones of a free Western democracy to have an independent judiciary unaffected by the current minister of the day.
The Honourable Member for Abitibi-Témiscamingue. Thank you, Mr. Speaker, and I'd like to thank my colleague for his question, and I will deal with it in two parts. When it comes to the Minister of Justice, there's something that we must remember. That is, most people who appear before criminal courts, whether it be in Quebec or elsewhere, when they go before these judges, the judges are appointed by the provinces. If we take Quebec, for example, we have the judges who deal with about 90% of what is criminal law. They go before the Quebec court, and these judges are not appointed, but rather they're recommended by a committee. And this is how it's done. A position is open in Abitibi-Témiscamingue. So in the newspapers, there's a notice saying that they're looking for a judge, and candidates who have practiced for more than 10 years are invited to apply. And a committee is struck. This committee is made up of someone from the public, a representative from the bar, and a representative from the Chief Justice or the Chief Justice himself. So this is what happens. And I can speak from experience because, Mr. Speaker, I sat 4 times at least on this type of committee. So we see these candidates, we determine who can be a judge, and this is how we do it. We ask ourselves the question, would we like to be judged by this person? And if we feel that we wouldn't mind appearing before this person, then the name goes forward. And then it's up to the minister to appoint the judge from the names on the list. But at the federal level, this isn't what happens. At the federal level, there's always been this little secret. I'll explain what I mean, Mr. Speaker. This little secret is very simple. If you want to be a Superior Court judge, then you must be designated as being able to fill that position by a committee. So if I say I'm Joe Blow and I've been a practicing lawyer for 10 years and I think I would be a good Superior Court judge, then I send in my name and I get a call saying, would you like to come and appear before us at whatever date? And I appear before a committee made up of I don't know who. And this is true. You don't know who sits on the committee. And we asked for this to be checked to ensure that there was someone representing the bar, someone who would know this individual. And it is strongly recommended, and either the person is recommended, strongly recommended, or not recommended. And based on that list, the Minister of Justice then chooses the candidate. And this is what happens. And often it's a political choice.
Questions et commentaires.
Questions and comments. The Honourable Member for Louis Hébert. Mr. Speaker, Earlier, my colleague from the Bloc Québécois mentioned the hypocrisy of conservatives. Now, I'm not going to play with words here, because when you talk about a group that has no aspiration to anything whatsoever, and when that group calls someone else hypocritical, then perhaps they should understand that this applies to them. Now, I have a question for my colleague, and this deals with the relationship between salaries. That is, that the Prime Minister could not earn less than the Chief Justice of the Supreme Court. Now, in many areas, because we have specialized employees, some of these employees might earn more than others, be it in medicine, for example. A surgeon who is a specialist often earns more than a general practitioner. In sports, a coach would most often earn less than a player. So when you say that a prime minister should or must absolutely earn more than a specialist, someone who has dozens of years of legal experience as a lawyer and also as a judge, and to say that there should be some relationship with the salary earned by a prime minister, well, I'd like the honourable member to explain why that would be the case. The honourable member for Abitibi-Témiscamingue. Mr. Speaker, thank you, and I'd like to thank my colleague for Louis-Hubert for the question. First of all, this is what I would say. We aspire to one thing and one thing only in this House. That is, we want to represent the interests of Quebec until Quebecers, as a majority, decide to have a country. We're not playing any games here. We're defending the interests of Quebec. And when I mentioned hypocrisy earlier, I didn't say that anybody in particular was hypocritical. I said that, and you have to understand my entire speech in its context, suddenly the Conservatives denounced how the Liberals were appointing Superior Court judges and the Minister of Justice, and I know this because I was at the Justice Committee last year with my colleague for Charlebourg at the time, and the Minister of Justice, the current Minister of Justice, was criticizing how Superior Court judges had been appointed, and then told us to our faces at committee that he was going to do the same thing and proceed in the same way. So you can use whatever word you want to describe it. I chose a particular term. Now, with respect to salaries, it appears difficult to me, and I was in sports for years, so I know whereof I speak, and I am familiar with coaches, and I know that some coaches earn more than the athletes. That's true. But when you want a very specific opinion, I agree, yes, perhaps you'll seek out someone and give that person a salary commensurate with his or her experience. But everyone should be on equal footing. Every Superior Court judge would earn $240,000 at the outset. Well, that makes no sense. They'd be earning more than the Prime Minister, and that's what I don't agree with. Now, a Supreme Court justice, I can agree, and I might concede that. But a Federal Court justice, a Superior Court justice, the Chief Justice of the Court of Appeal, perhaps. But a Superior Court justice earning more than the Prime Minister of Canada, I can't understand that, and I will never understand it.
Reprise du débat.
Resuming debate, the honourable member from Montmagny-Lillet, Kamouraska, Rivière-du-Loup. Thank you, Mr. Speaker. And I'm pleased to rise to speak to this bill today, which deals with compensation for judges. And this is an important bill that when I proceeded to analyze it with other Bloc members, realized that something was not quite right, because it was decided, And this is why the Bloc Québécois is not in favor of passing this bill. We might remember that the bill would provide 7.25% as an increase as of 2004, with an indexation as of April 1st of each subsequent year. And this increase, we feel, is unreasonable. My colleague explained it quite well. He made a comparison between the salary of elected members and that of judges. And in this House, with the previous government, we had a mechanism to determine the salaries, and this allowed us to set aside the emotional aspect of the debate. But now the government is going back to this. And I wonder why we couldn't have maintained a procedure which ensured salary increases that could be compared to that. The salaries of elected members would be compared to that of judges, and my colleague explained why we didn't feel that was appropriate. But we're in a time when people lose their jobs at the age of 55, 56, 58, and we fought to have a program instituted to help older workers, and we wouldn't have they didn't offer 7% as a wage increase. They simply decided there would be no program for those people. Now, you can't have a double standard in this country. You can't have people from Montmagny who lose their jobs and then they get their EI and their severance pay, and they're 55 and they can't find a job, and they're slowly moving towards social assistance because they won't have any income for the next 4 or 5 years. And we thought a program would cost $75 million per year to help the people in our society. But no, the government doesn't want to provide this assistance. But during the same month, during the same session, they are moving with legislation to give 7.4% to judges, or 7.25% to judges, and index this on an annual basis, because we realize as members that we already make a good living, and so do judges, and there are things in society that don't make sense, and this is why people are upset. This is what causes the anger of the disadvantaged in society who are fighting for justice, and they never do receive this justice, and all the while they decide to give the judges over 7% as a salary increase, and that's why we find it unacceptable. And we can evaluate society on how it creates wealth. That's one way of doing it, but we have to look at how this wealth is distributed. And when people contributed to this wealth for years by working in plants and factories, when they've devoted their entire life to a company, and they supported their family that way, and then the income disappears because of market forces, and they're left with nothing, and at the same time you give 7% to judges. Well, that's unreasonable, and I think the judges themselves would admit that the bill is indecent when you look at it that way, and that's why it's important for us to vote against this bill and reject it. And there's still time for the government to correct things, to change their position, and find another way to determine these salaries, a method that would be more rational, less emotional, and wouldn't break the rules of the game, because it's astonishing that this Conservative government, which said that it would be different from the Liberals, is falling into the same pattern of behavior as the Liberal government.
We had people in the House who spoke out against the Liberal Prime Minister, the former Prime Minister, the member for La Salle-et-Mar, who wasn't respecting the ground rules and just responded emotionally to whatever he witnessed in society. Now the Conservatives are doing the same thing. It seems to me that this is an excessive increase. By constantly changing the conditions for setting judges' salaries. They are skewing the whole process for setting salaries. This is what, when the uniform method was established, we sought to avoid. The Conservatives are setting aside the uniform method that the Liberals had started to distort. But we really did expect better from this government, and we're not seeing it. The Conservative government has chosen to follow the traditional hypocritical path of the Liberals by increasing judges' salaries to this extent. We in the Bloc Québécois are going to propose, because it's very important, we are asking the government to recognize that there is a legislative responsibility that exists concerning both judges' salaries and members' salaries. You can look at the setting of the salaries. The Prime Minister, who was the first amongst those elected in the House, and the equivalent is in the judiciary, the Chief Justice. You can set the correspondence. They're a type of balance. They balance one another, and then you can set the salaries for each institution in consequence thereof. However, what they're doing now, the government is going back to the old type of behavior, which is unacceptable and totally irrational. The indexing of judges' salaries and members' salaries has to be reasonable. We in the Bloc would like to see the judges' salaries based on the same indexing system as exists for members of Parliament, similar to what exists for the 2.5% figure that arises from the major corporations. Now, here is where the unfairness builds. Yes, we can understand that members of Parliament and also judges should have something that is defensible in terms of what exists in business. That is a defensible position. But beside that, you look at society and you see the people in society who have no indexing attached to their pensions or to their jobs. You have people who have worked years and years, seasonal workers, for example, that have a check for 5, 6, 7 weeks only. They have no income to speak of. Those people who have contributed the most to employment insurance, employers, employees, and these people do not always benefit from the EI fund. Some $50 million was taken from the EI fund to pay down the debt. But they've never gotten a return on that, all those people who contributed. When you talk about the insurance, employment insurance payouts, we have people that are in great difficulty. For example, older workers. What are they facing? Nothing. They have a gap. You have unionized workers who do not have any type of guaranteed pension fund, and then one day after being on employment insurance a year, they face nothing. And here we're talking about a 7% increase for the judges. If you increase the salary of these workers by 7%, it wouldn't amount to the same type of figure. So it's a real shame that we see this type of legislation here in the House. We want to have a mechanism for computing and setting the salaries for judges and members that would be scientific and automatic. We don't want to have a sudden increase to attract the attention and an outcry from those particular groups. The way in which the setting of judges' salaries in this bill corresponds to the type of attitude that existed in the past. The Bloc Québécois is speaking on behalf of all people here, ordinary people who earn a living, who pay their debts, who go around, who have to go to a bargaining table to get any kind of increase, and then suddenly the Conservative government comes up and says that it's going to give a 7.25% retroactive to April the 1st, 2004, plus indexing rather that to the cost of living. Something's wrong in society. I gave the example of older workers. I can also give the example of those people whose benefits run out, and even those who don't even qualify for benefits because they are seasonal workers. Young people, for example, are another group that has little advantage. You can say that there is therefore discrimination that is written into the legislation. They haven't decided to lower the number of hours that are necessary to qualify for employment insurance, and it seems to me that if there is one group that we should give a break to in society, it is to young people. What the government is putting forward here doesn't correspond to what society would like to see. I do hope that we will be able to convince the government through our speeches that this bill needs to be reworked, that it has to be reviewed without admitting publicly. Today, perhaps the government can look to the future and provide more reasonable increases for judges' salaries in the future. You want to have something that is comparable for judges and members of parliament, taking into account the average, the mean for salary rises in the business business community, in society in general. Because what we have here is a distortion that is being created between the salaries for judges and salaries for members, and given the society in which we live today, nothing can justify this increase for judges. I'm not questioning the quality of our judiciary. I'm not saying whether the judges are doing a good job or not, but I'm just saying that the way that this government has decided to act, we feel that it is not consistent with what exists for the basis for pay raises in society, in the working world, and we have to find something that is more acceptable. In the position that was set out by the parties represented in the House of Commons, the Commission, which makes recommendations on salaries, would propose salaries that took into account the state of the economy of Canada, the finances of the government, the role that judges play in the preservation of society, and the choice of the best candidates available for the judiciary. The Prime Minister would therefore earn the same salary as the Chief Justice of the Supreme Court. Members would receive 50% of the annual salary of the Chief Justice, and so on. The whole mechanism was there, set out, and it was defensible. It could be justified, and it could be explained very clearly to the people. It was a simple and fair solution that existed in the past. It allowed for a fair remuneration to be given to the judiciary. It worked very, very well until the Commission in 2004 proposed an increase that was extremely high. The government, the Liberal government of the day, panicked and saw an opportunity for political partisanship and then changed the system. And this is where the problem stems from. If you looked at the overall picture of the years, you could see that it was an appropriate mechanism, and they could have continued to propose increases as suggested by the Commission, but thereupon the Conservatives decided to bring in legislation that mirrored what the Liberals did in 2004, and here we are with the bill that we have before the House. The Prime Minister gets $3 million less than the Chief Justice. I think that in our democracy there should be a minimal recognition of parliamentary members, of those who are elected to this House. There should be a method in which the setting mechanism could be applied adequately and fairly. This is why the Bloc is not supporting the bill before the House. I will conclude, Mr. Speaker, that judges do play an important role in our society. We all know that. Their remuneration must recognize that fact, but nonetheless, the weight of the judiciary and the way in which judges are appointed should be more transparent. In the spirit, then, the Bloc Québécois feels that this bill is not adequate. We will vote against it. In conclusion, I will state the main reasons. The increase of 7.25% for judges' salaries, retroactive to April 1st, 2004, breaking with the tradition that existed in the past for setting judges' salaries and the salaries of elected members of Parliament. That mold was broken, and therefore we feel that this bill should not be passed by the House. The process for setting salaries is not what we would wish it to be, and I personally want to say that I feel that this is an insult to the people in this country who don't even have minimal protection. To see that judges are given such an advantage, such an increase in salary, whereas they are living in poverty, I cannot accept that, and I will vote against this at third reading with the rest of the Bloc Québécois.
Questions et commentaires. Resuming debate. Is the House ready for the question? Question? La question est la suivante.
The question is the following.
Moved that Bill C-17, an act to amend the Judges Act and certain other acts in relation to courts, be now read a third time and do pass. Plaît-il à la Chambre?
Is it the pleasure of the House to adopt the motion?
Yes.
All those in favor of the motion will please say yea. Yay! All those opposed to the motion will please say nay. My opinion, the yeas have it. Pursuant to an order made earlier today, the recorded division stands deferred until Tuesday, November 21st, 2006 at 5:30 p.m. Orders of the day.
Government orders, government bills, Commons.
On the motion for second reading of Bill C-27, an act to amend the Criminal Code, dangerous offenders and recognizance to keep the peace.
Reprise du débat, l'honorable député de Marc-Aurèle.
Resuming debate, the honourable member for.
Sorry, Berthier-Masconanger. Je m'excuse.
Berthier-Masconanger. I'm sorry. I apologize.
Bonjour, Monsieur le Président.
Hello, Mr. Speaker. It's an honor for me to speak today. I'm not the member for Marc-Aurèle-Fortin. I would have been honored to be, but I am a member for Berthier-Masconanger. I am speaking to Bill C-27 today. It is an act to amend the Criminal Code, dangerous offenders and recognizance to keep the peace. Those who have been found guilty of 3 serious crimes, unless they can disprove their culpability, it is 3 strikes and you're out. When I was speaking a few weeks ago, I was saying that the Conservatives want to have mandatory sentencing. They want to make it automatic, and we find this is an irresponsible approach. My colleague, the member for Abitibi-Témiscamingue, explained it very well. We believe that the justice system must be based on a personalized system. That is, that it must be tailored to each case, and it must have a dimension of rehabilitation attached to the sentencing. The sentencing, the most individualized, here is non-existent. What we are dealing with is automatic sentencing. This is not all, Mr. Speaker. This bill goes even further than any in the past because it's going to set out the degree of sentencing. It will reverse the onus. At the present time, our legal system is based on the fundamental notion of the Crown's having to prove the guilt of the accused. By reversing the onus, Mr. Speaker, not only do we have serious concerns in the Bloc Québécois about the constitutionality of the bill, but we also feel that the reverse onus represents a very heavy burden of proof. It is a heavy onus because if the accused wants to escape being qualified as a violent offender, he has to disprove what is being set out by a variety of experts. The Conservatives should know that the presumption of innocence was created precisely because the accused too often does not have any means. They don't even have a lawyer to represent them. Why are we changing our process for designating offenders when the present process works? The Crown Attorney, to have the Crown Attorney declare that an offender is a violent offender from the very beginning, not 3 strikes and you're out, not after 3 offenses, well, it in no way will provide any type of support for rehabilitation. In Quebec, the Crown Prosecutor prefers to use a procedure that is called controlled delinquent, controlled offender, if you like, rather than violent offender for those repeat offenders. The correction services will follow him up for a period of 10 years once he is released into the community. Quebec is the place where there are the fewest violent crimes per 100,000 inhabitants. The Quebec system is founded on the rehabilitation of the offender, not just the repression of the offender in a penitentiary. And the Quebec system has borne fruit. It is very, very good. With this, the government is trying to once again give us the illusion that this bill, and I quote, will allow the government to protect innocent Canadians against any future offenders. Now, the government is unable to give us any studies supporting their statement.
The Conservatives are trying to convince people that those who criticize their bills are insensitive to the rights of victims and public safety. But people understand very well that changes to the criminal code that are being proposed by the Conservative government are not real solutions to violence in our society. I realize that the Conservatives are certainly driven by the American model and that they admire the American approach, but the government members have to understand that it is not by filling up our prisons and building new ones that the federal government is going to reduce the crime rate. We should remind people that the United States, according to the statistics, imprisons 7 times more people than Canada, and yet the homicide rate is 3 times higher than in Canada and 4 times higher than in Quebec. So why do we want to be inspired by the American model? I am certain that if we want to protect people better, then we need to attack the roots of the problem, which are the causes of crime and violence. The Conservatives need to understand that poverty, inequality, and the feeling of being excluded are the most important factors in criminal activity. And this is why we need to have social policies that share our wealth better and emphasize social integration and rehabilitation. Mr. Speaker, I worked for a number of years in the areas of child care and social services at other levels. I worked helping young people, young parents to do the best they could to raise their children well and give them what they needed. Because early childhood is important, and if we do not help children at that early stage, they are more likely to get into criminal activity. We know that the Conservative government is aware that this bill will involve additional costs for the prison system, which is already overburdened. And this money will not go to deal with the real causes of violence, which are poverty, exclusion, and social inequality. If the federal government absolutely wants to undertake reforms, then it should really assess the parole system to make sure that parole is always based on merit and the assurance that the individual no longer represents a danger for society. Finally, instead of trying to act once difficulties have arisen and the incidents have occurred, by reversing the onus of proof in the criminal code, the government should work on the source of the problem by adopting effective social policies and maintaining the gun control policy for weapons and making people aware of the responsibility that we have. When we cut people off employment insurance, literacy, training, and we take away resources, then we naturally increase the crime rate. And statistics show this, where communities have a lack of resources, where people are poor for years, where there is a high degree of inequality and injustice, then we have these problems. The Bloc Québécois, therefore, is against this bill, which does not work toward rehabilitation, but will actually increase recidivism. Of course, I would say that the criminal code does have the provisions it needs to imprison people who have committed serious offenses. And certainly, we are not against effective sentencing of criminals who commit serious offenses. Mr. Speaker, I will conclude by saying that the Bloc Québécois will vote against this legislation.
Questions and comments? Questions and commentaires. The Honourable Member for Wild Rose.
Well, thank you, Mr. Speaker. As usual, when I hear from the opposition speeches in regards to trying to clamp down on crime and protect our society better, there's a big focus on the criminal and his rights, the criminal and his privileges, the criminal and how he should be treated. I don't ever hear a whole lot from the opposition, particularly the Bloc, about the victims of these people who are considered to be extremely dangerous because of their proven past. I don't understand how any human being that's been alive for any length of time at all could say for a moment that extreme, serious consequences should occur to an adult who rapes and murders and tortures little kids.
children. You know, I know it's very harsh for some people to say that, but I have a 5-year-old grandchild, and somebody would do that to my grandchild, I don't care if he ever sees the light of day again. Why should he? Oh, we can look at the root causes, but we even do that. I mean, we're not doing very well in the past 13 years regarding child poverty and all that. But also look at the number of things that's the root cause of a lot of attacks on our children. Child pornography. For 13 years, I have tried to get this place to do something serious about child pornography, and it's always that group of people on that side of the House that are always balking at getting tough on child pornographers. Does the member not know that child pornography is a real root cause of a lot of these people? It affects their brain to where they go out and they love attacking children. That's their way of life. I'm sorry, when they act like that, I don't care if I spend 1 penny trying to rehabilitate somebody with that kind of a poisoned mind. I really don't care. I want him off the streets, and I want him in a place where he can never hurt another child. I really don't understand why anybody would even hesitate when we're trying to accomplish that kind of a thing. And I really get tired of hearing the root causes, but I never hear the mention of child pornography, a major root cause for attacks on our children. Why don't they grow up, get smart, and start dealing with these people the way it ought to be dealt with?
L'honorable deputy. The honourable member for Berthier-Masquinongé. Mr. Speaker, I'm very concerned by the remarks made by the Conservative member when he says that the Bloc Québécois does not consider victims of these acts. In fact, we have community organizations locally that work to help victims of sexual assaults and criminal offenses, that work on prevention, and those groups are underfunded. If the Conservatives are so worried about helping victims of criminal acts and sexual assaults, I would ask you, Mr. Speaker, I would ask the government to provide better funding to the provinces for health and education and so on. In Quebec, we look after victims of sexual assault and criminal offenses. We would like to do more, but in fact what is happening right now is cuts to social policies. The Conservative member is saying that we don't look after victims. In fact, there have been cuts recently to social programs. The issue is not the criminal code. In fact, it doesn't mean that we are not worried about victims of crime. To act, though, in those areas, we need programs to support those people. But instead, the Conservatives are cutting in prevention. They want to criminalize more people. They want to put more people in jail. So I would say that to the member from the Conservative Party.
The Honourable Government House Leader on a point of order.
Thank you very much, Mr. Speaker. I apologize for interrupting the proceedings. Mr. Speaker, pursuant to Standing Order 83-1, I wish to table a Notice of Ways and Means motion to introduce an act to amend the Income Tax Act, including amendments in relation to foreign investments in entities and non-resident trusts. I'm also tabling explanatory notes to legislative proposals on the same subject. I ask that an order of the day be designated for consideration of the motion.
Questions or comments? Questions et commentaires. L'honorable député pour.
Member for York South-Weston.
Speaker. Mr. Speaker, if I may direct my question to the previous speaker, in terms of the criminal code, there are already provisions with respect to the sentencing of dangerous offenders. One of the concerns that has been raised is that if this bill is passed in its present framing, that portions of the existing criminal code dealing with dangerous offenders could in fact be struck down also. Could the member, Mr. Speaker, comment on whether he thinks that that is a valid enough concern that this bill should be given further consideration?
The Honourable Member for Berthier-Masquinongé. Mr. Speaker, yes, the Bloc Québécois believes that the current criminal code provisions have all the elements that are needed for designating dangerous offenders, and in Quebec we feel that this kind of person needs to be monitored and controlled. We do not need any more provisions to do this. It is up to the judges to make the determination. It is not for legislation of the type of 3 strikes you're out. And I certainly agree with what the member has just said, and we are very concerned. We have the judges, and the Conservatives want to improve their working conditions. We need to enable judges to do their work. Perhaps it would be good to have legislation to give judges more, the justice system more resources. We could evaluate the parole system, we could do other things, but not a bill that is more demagogic and that one offense would be necessary for somebody to be designated a dangerous offender. I'd like to thank my colleague.
Honourable Deputy for
the Honourable Member for Dufferin-Caledon.
Thank you, Mr. Speaker. I'd like to, my colleague from Wild Rose raised the issue about how the Bloc Québécois argument is disregarding the interest in the victim. And that's an excellent point. We on this side have raised that many times, and of course the Bloc has responded by saying, oh, well, you know, not enough money is being given to victim organizations. That's not what this legislation is all about. This legislation says that on the 3rd time you're convicted, not charged, but convicted for a very serious offense, the onus is on the person that's been convicted to show why they're not going to be dangerous offenders. That's what it's all about. It has nothing to do with all the other garbage that the Bloc Québécois is talking about. And so, Mr. Speaker, I'd like to zero in on one of the areas that my colleague from the Bloc had raised and said, oh, it's going to cost more money. It's going to cost too much money because there's no room in the jails to put these terrible people. So I assume from that they're saying, let them go. I don't think he realizes what the whole purpose of this is about. It's about, 1, a penalty. Number 2, it has to do with protecting the public and protecting the victim. I ask the member to reconsider his position and support this legislation.
Honourable Member for Berthier-Masquinongé. Mr. Speaker, as you know, I have answered the Conservatives' concerns and comments on such legislation, and I have told you in my remarks that we in Quebec are a nation, because we are a nation, which has the lowest crime rate per 100,000 inhabitants. We have a good justice system, we have a system of rehabilitation, but we also are quite capable under our justice system of convicting people. So what more do we need? This idea of 3 strikes, you're out, well, perhaps, Mr. Speaker, somebody might commit a serious offense the first time and be considered a dangerous offender for life. Why do we want this type of legislation? How will it improve the safety of our citizens? And I would like to point out that we are not against imprisonment. We are not against putting people in jail who commit serious offenses. But if there are no rehabilitation mechanisms, then I am not convinced that somebody who spends 20 years in jail without any rehabilitation services, when the person gets out.
Reprise du débat.
Resuming debate.
Reprise du débat.
Resuming debate. The honourable member for Marc-Aurèle-Fortin. Thank you, Mr. Speaker. I think that over the next few years we are going to have the courage to combat rhetoric, and I hope that people outside the United States will not have to face this. I've gotten to a certain age, and I've been Crown prosecutor, defense prosecutor. I've been Minister of Justice, and certainly I have perhaps a more complete vision of crime than the member for Wild Rose. But anybody who knows anything about criminal activity knows it is a danger for us in our daily lives. But this bill by the current government is based on the American model, and I would say, like I always do, that the real truth is that it is not quite as bad as the American model is based on. It doesn't go quite as far, but it is going in the wrong direction. We have to make some comparison. The homicide rate is one comparison. The homicide rate in the U.S. is 3 times higher than in Canada. You can ask any American, any educated, reasonable American why this is the case, and that person will say it is because people can get weapons so easily in the U.S. So we have this contradiction that we find in the U.S. and that people want to bring into Canada. Let us be harsher on crimes. Let us be more lax on guns. Let's put more people in jail. Let's get more weapons out there, and we will improve the situation. I have never understood this kind of argument, but yet that's what we want to import here. The homicide rate in the U.S. is 3 times as high as in Canada. And once again, I am being strictly honest. I know that, unlike what a lot of people think, the crime rate in the U.S. is similar to that in Canada. And so generally, most developed countries at a similar level have similar crime rates. But this American model that people want us to follow imprisons more and more people. 15 or 20 years ago, we had similar imprisonment rates. But now, in the United States, the rate is 7 times higher than in Canada. Does anyone here think that if you go to the United States, you are safer than in Canada? The crime rate overall is about the same, but for serious crime, violent crime, it is not. When we look at gun offenses in the United States, there are 5 times more spouses that are killed with guns than in Canada, and that shows very clearly that this situation needs to be taken into account, even though these are spectacular crimes that we hear about. So we also know that 10 times people overall are killed by guns than in Canada. There are always people that will commit crimes. But my question is, how can we deal effectively with crime? After the period question, I will come back to this.
L'honorable député va avoir 6 minutes.
The honourable member will have 16 minutes after question period.
The honourable member for Abbotsford.
Thank you, Mr. Speaker. As it does on every Remembrance Day, the Canadian flag atop the Peace Tower will fly at half-mast on Saturday. We do this to honor the courageous men and women that paid the ultimate sacrifice so that future generations of Canadians could live in peace and freedom. From the brave soldiers who fought and defeated tyranny during the World Wars I and II to those fighting the scourge of terrorism in Afghanistan today, these are ordinary men and women accomplishing extraordinary feats.
Here, here.
Today we're again reminded of the high price of our freedom. As we observe Remembrance Day, let's live each day as a tribute to those who have fought and given their lives for that freedom. To our fallen heroes, present and past, to our veterans, to the members of our armed forces serving at home and abroad, and to their families, we say thank you. Join with me in expressing our gratitude to Canada's real heroes.
Here, here. The honourable member for Malpeque.
Mr. Speaker, I rise to express concerns about Parks Canada's intent to destroy a perfectly sound tennis court at Green Gables Golf Course when other options are available. While I agree renovations are needed to improve the course, the planned demolition of the tennis court to accommodate a new practice putting green is absolutely unacceptable. Parks Canada made its decisions without consultations with either the community or users. A government agency has a responsibility to respect community views. The existing courts are low maintenance and offer the only public space to play tennis in the Cavendish area. With all the available acres of the golf course, there is no need for this irresponsible destruction. To destroy tennis courts that are in superior condition is unnecessary government waste, improper use of taxpayers' dollars, and shows a belligerent attitude by a government agency to the people it purports to represent. Minister, stop this destruction today.
The honourable member for Abitibi-Témiscamingue. Mr. Speaker, it's with a great deal of sadness that we learned of the death of Mr. Émile Boudreau, an ardent defender of workers. He was a colourful gentleman born in New Brunswick. He worked in a number of jobs related to forestry to finally settle in Abitibi. And he quickly took up the political cause and became very active in the metal workers union affiliated to the Fédération des Travailleurs du Québec, or the FTQ. He made his mark as the Occupational Health and Safety Director at the FTQ, where he worked for 32 years, and he was awarded the Antoine Aumont Award for his involvement in promoting industrial hygiene. Even after he retired, he continued from time to time to argue cases before the appeal review committees for professional injuries. And we will miss this passionate man whose energy was contagious. My colleagues from the Bloc Québécois and I offer our most sincere condolences to the family, friends, and those who had occasion to meet Émile.
Timmins James Bay.
Mr. Speaker, well, earlier this week, the Heritage Minister was caught passing the hat with industry insiders and lobbyists, and as soon as we shone the light, they scrambled to cancel the event so we wouldn't find out who was at the trough. And when I asked this government for accountability, the President of the Treasury Board stood up and asked for the NDP's help in order to get rid of the influence of big money in politics. I think the implication of his plea is clear. We're going to need an all-party strategy to keep the Heritage Minister on the straight and narrow. So I've done what I can to have a three-point plan to maintain the ethical sobriety of the Heritage Minister. Number one, reveal the list of who she's putting on a tap for money so we know which lobbyists are rewriting government policy on copyright and deregulation. Number two, institute a remedial plan so that she can learn how to listen to the groups and artists that she's supposed to be representing. And number three, Mr. Speaker, ask the House of Commons carpentry staff to head over to the Heritage Minister's office and paint over the big for sale sign that's on her door.
Honourable member for Calgary Centre.
Thank you, Mr. Speaker.
I need my windows faded.
I think we've got the best heritage minister we've had for years.
Here, here.
The Children's Fitness Tax Credit is part of Government of Canada's commitment to maintaining the health of Canadians, specifically to address the negative impact of declining levels of physical activity among our children. Canada's new government keeps its promises. An expert panel set up by the Minister of Finance and chaired by Dr. Kelly Leach has released their report to the government. During its consultations, the expert panel traveled across the country, gathering input from a broad range of Canadians. The Children's Fitness Tax Credit will encourage more children to be physically active and help parents with the cost of organized fitness activities. This is good news for Canadian families and another example of Canada's new Conservative government delivering for all Canadians.
Member for Desnathy, Mississippi, Churchill River.
Mr. Speaker, the Nisga'a Nation lost its Chief of Chiefs when the Honourable Frank Calder passed away last Saturday at the age of 91. He'll always be remembered as a leader, an advocate, and a proud Canadian. Raised during the time of the repressive Blue Book, he brought Aboriginal issues to the forefront of Canadian politics. In a life of achievement, such as being the first Aboriginal Cabinet Minister and being named a member of the Orders of Canada and BC, his lasting legacy will be the victory he secured in the court case that bears his name, Calder versus the Attorney General of BC. His father, Nisga'a Chief Nakwaun, foretold a great future when Mr. Calder was just an infant. Although many elders considered the Nisga'a land claim to be an immovable mountain, the chief responded that his son would move the mountain. The historic Calder case fulfilled that destiny. The Supreme Court of Canada affirmed the existence of Aboriginal title. This affirmation directly led to the success achieved in 2001, and it was proclaimed law. Rest peacefully, Chief of Chiefs.
Honourable member for Calgary Northeast.
Thank you, Mr. Speaker. On November the 11th, we remember the men and women who paid the supreme price for our freedom. We also remember our veterans who returned from the front lines years past, and some of whom are still fighting for their survival. Tragically, today, many veterans rely on food banks and other assistance to help make ends meet. For some years now, in an effort to help them, my Calgary office has been running the Food for Life program to help restock the shelves of the Calgary Poppy Fund. This year, a remarkable boy from Calgary was moved by the plight of our veterans and created a Christmas card to raise money to meet their needs. 11-year-old Dirk Chisholm contacted famous wildlife artist Robert Bateman, who shared Dirk's concern and generously volunteered one of his paintings. Sales of these wonderful cards featuring Mr. Bateman's art will likely raise more than $45,000 for the Calgary Poppy Fund this Christmas. My sincere thanks to young Dirk, Mr. Bateman, and all generous Calgarians who are remembering and supporting our veterans both now and throughout the year.
Honourable member for Quebec. Mr. Speaker, Friday, October 27th, on the occasion of the first Justitia evening, the law faculty of Laval University paid tribute to three of its graduates, founders of Lawyers Without Borders Quebec, and called them exceptional jurists whose social and university commitment made them pioneers in the area of law, and through their initiatives contributed to the progress of society and the outreach of Laval University. They are Dominique Anne-Roy, Pierre Brun, and Pascal Paradis, and at the same time they were recognized as lauréat de la semaine by the newspaper Le Soleil and by Radio-Canada. For 4 years now, they have carried out 23 missions to strengthen the capacity of lawyers in developing countries to defend human rights. I'd like to congratulate them for this well-deserved honor. Their motto, value is not counted in years, is a very good one. The honourable member for Mégantic-L'Érable. As you know, Mr. Speaker, water is very important in my riding of Mégantic-L'Érable. In response to a problem with the supply of drinking water in Thetford Mines, a project called Écolo was born, and this program encourages people to recover rainwater through a process called concept au bac, with barrels being used to catch the rain from roof downspouts. This water can then be used to wash cars or water gardens. This project was initiated by 69 dynamic senior elementary students at École Tournesol in Thetford Mines under the supervision of Mrs. Marie-France Lessard, whom I congratulate for dedicated work with the students and their wonderful project. The dynamism of these students and their involvement in environmental cause has spread well beyond the region. Chaudière-Appalaches won the first national award for senior elementary students at the Concours Québécois en Entrepreneuriat for their concept au bac. Thetford Mines supports and funds this project designed by our youth. It's a wonderful success. Their demand is high. The guidance counselors, teachers, scientists want to know all about écolo and are astonished to see such passion and determination from young student entrepreneurs. And I would like to congratulate
Jax Pickering.
Thank you, Mr. Speaker. Mr. Speaker, I'm pleased to bring to the attention of the House the Reading and Remembrance Project. Started and managed by the Durham West Arts Centre in my riding, this innovative program provides educators with tools to promote literacy while carrying out Remembrance Day activities in their classrooms and schools. This year's project is Holocaust and Anti-Racism Education and will focus on the values for which Canadians veterans have sacrificed their lives. Educators can select reading materials found on the Durham West Arts Centre website and will spend 10 to 20 minutes with their students reading and remembering on November 10th at close to 2:10 p.m. as possible. We, as members of Parliament, are in a unique position to share with young people the importance of the values that Canadians have and continue to fight for. It is my hope that on Remembrance Day, more students will have the chance to participate in this worthwhile event, and that my colleagues on all sides of the House will take a moment to read and remember with young Canadians.
Honourable Member for Fundy Royal.
Mr. Speaker, today marks the start of the one-year countdown to the decision of selecting the city that will host the 2014 Commonwealth Games. Canada is proudly represented by the regional municipality of Halifax. The successful candidate city will be announced in Sri Lanka on November 9, 2007, during the Commonwealth Games Federation Annual General Assembly. The historic role of Halifax within the Commonwealth is well known. Being selected to host the Games will only reinforce that role in the future. Canada's new government is proud to support Halifax and the province of Nova Scotia in their bid to host the 2014 Commonwealth Games. The whole Atlantic region stands to benefit because of increased exposure that will lead to the creation of jobs, increased tourism, economic investment, and development of state-of-the-art sport infrastructure. I have every confidence in the ability of Halifax and the entire region in hosting the Commonwealth nations, should the Commonwealth Games Federation give it the opportunity. Way to go, Halifax.
Honourable Member for Toronto, Danforth.
Mr. Speaker, I rise today on behalf of New Democrats to honour the service and sacrifice of our veterans and the more than 100,000 Canadians who did not return home from war. On Remembrance Day, we will pay tribute and give thanks to the soldiers, nurses, and the others who served and gave their lives for Canadians. They made the ultimate sacrifice so that we could live free. But we also must honour the veterans who served courageously and returned with the memories of fallen comrades and the horrors of war. They too made the sacrifices, and they bear a burden that the rest of us can barely imagine. Monsieur le Président, le jour...
Mr. Speaker, Remembrance Day is the link to the past, and it must be celebrated so that the lessons of history will guide us and prepare us for a better future. And it is my privilege on behalf of all New Democrats to thank those brave people who served Canada. We will never forget. Mr. Speaker, I rise to welcome literacy advocates who have come from across the country today to mark Literacy Action Day on Parliament Hill. This is the 13th anniversary of this important event. In Canada, 9 million adults of working age lack the reading skills needed in our knowledge-based society. The federal government needs to tackle this challenge immediately.
Spending $80 million on literacy, but refuse to show us how or where they are spending it. Canadians have watched the Conservatives' cruel so-called fat-trimming exercise and listened to a cabinet minister liken it to going without a cup of coffee for a week. Conservative cuts to federal literacy funding have undermined the quantity and quality of literacy services across the country. The Liberal caucus calls upon the Prime Minister to immediately restore the funding for literacy programs in Canada.
Député de Verchères-les-Patriotes.
The honourable member for Verchères-les-Patriotes. Hockey is a passion for Quebecers. They love hockey, and every week players of all ages, among them a growing number of girls and women, come together to practice throughout Quebec, and the skating rink becomes a gathering place like no other. The passion for this sport, no doubt, contributes to its great popularity and its longevity. In Quebec, hockey is a tradition. It's a family affair. All of these games and tournaments can't go on without the work of hundreds of volunteers who, with their constant support and dynamism, allow Quebec amateur hockey to prosper so well. Parents, coaches, and referees all give generously of their time so that players can develop their skills and play the game in the best possible conditions. That is why during Amateur Hockey Week, the members of the Bloc Québécois salute the volunteers, parents, players, and to them we say thank you.
Mr. Speaker, it's my pleasure to rise in the House today to recognize the launch of a new book and video, Proudly She Marched, Training Canada's World War II Women in Waterloo County. This book and DVD are the product of a research project undertaken by the Canadian Federation of University Women Kitchener-Waterloo. During World War II, Canadian women served for the first time in military uniform, and over 45,000 women enlisted, 21,624 with Canada's Women's Army Corps, 17,030 with the Royal Canadian Air Force Women's Division, and 6,783 with the Women's Royal Canadian Naval Service. Two of the largest military training centres for women were located in Waterloo County. Although these bustling military camps were significant parts of their community and of great local interest, they have been virtually forgotten until now. In its major book and video project, the Kitchener-Waterloo branch of CFUW has taken up the challenge of uncovering history. As we approach Remembrance Day, I ask this House to join me in paying special tribute to the women who served Canada in uniform.
The honourable member for Oshawa.
Mr. Speaker, while the Liberal leadership wannabe from Etobicoke Lakeshore has called the universal child care benefit a terrible use of public funds, the NDP's devious hidden agenda has also been exposed. Now, Christmas won't be here for a while yet, but the NDP Grinches are already at work threatening to rob Canadian families of precious social development programs. Through a motion introduced at the Human Resources Committee, the NDP have proposed to effectively take away the universal child care benefit from Canadian families. Oh, no! Mr. Speaker, this mean-spirited NDP assault on Canadian families is shameful. But then again, Mr. Speaker, what else can we expect from a party that is so out of touch with the daily realities of working Canadian families? Mr. Speaker, unlike the NDP and the Liberals, Canada's new government will stand up for the choice in childcare benefits and stand up for Canadian families.
Oral questions. Questions orales. The Honourable, the Leader of the Opposition.
Mr. Speaker, the Prime Minister has always refused to take a serious position on climate change. He continues to maintain that it does not exist. His government is opposed to targets to reduce greenhouse gas emissions. The government is just spreading confusion. We have put forward a proposal, 4 points that are clear and strong. Will the Prime Minister save Canada's reputation and tell his minister to defend our position in Nairobi? The Right Honourable the Prime Minister. Mr. Speaker, on the contrary, this government was the first to bring in a serious plan to reduce GHGs in Canada and to reduce air pollution. The government's balance sheet on this matter is clear. I can cite the member for King's Hants who said, instead of doing like the Liberal government with respect to Kyoto, it was drafted in the plane on the way to Kyoto. There was no planning. There was no real negotiation with the provinces. What it was a last-minute agreement that was hastily drafted. The Leader of the Opposition.
Canadians have seen that this emperor has no clothes. 71% of them are telling us they've got no plan whatsoever. What we're asking is that the Prime Minister change a course which is disaster for our environment, a disaster for our foreign policy, and a gross abandonment of our responsibility for the world. Will he not face the evidence that the planet is more important than any neoconservative anti-climate change ideology? Will he order his minister to follow a sensible course of action in Nairobi? Will he order to stop trying to destroy the Kyoto Protocol, adopt some short-term targets, fund projects in the developing world, set ambitious, concrete goals for the next phase of Kyoto, which is essential for our planet?
The Right Honourable Prime Minister.
Well, Mr. Speaker, the previous emperor had no clothes on Kyoto. That's why the people of Canada changed the emperor in the last election campaign. Let me quote once again one of his own members, the member for Esquimalt, Wanda Fuku, said the following: "Unfortunately, Kyoto is a shell game. My friend knows well that the Liberal government has made this into a shell game. We are to pay countries like Russia to buy the ability to produce greenhouse gases. We will produce the same amount of greenhouse gases and say disingenuously that we have met our commitments." That was the plan of the previous government. It's not the plan of this government.
The Honourable, the Leader of the Opposition.
Well, Mr. Speaker, I'm not sure what planet this new government's living on, but the rest of us are trying to save planet Earth. The Minister of the Environment has wasted this year as the World Chair on climate change. Not only is she going to the conference in Kenya with no prescription for global action, she's going with zero plan for Canadian action. The Minister of the Environment is not a leader on the environment, she's an anti-leader. Will the Prime Minister order his minister to quit trying to undermine Kyoto? Will he adopt a sensible, non-partisan plan that was proposed this morning by the opposition parties, Mr. Speaker?
Right Honourable Prime Minister.
Well, Mr. Speaker, the Minister of the Environment is going to Nairobi as the first Minister of the Environment in the history of this country who's tabled legislation to deal with the problem of greenhouse gases. This party opposite signed Canada onto Kyoto a decade ago, for 13 years didn't produce a single plan, and now have the gall to actually suggest that they would go to Nairobi and commit us to even more targets. Well, we're still waiting to see their plan after 13 years.
The Honourable Member for Westmount Ville-Marie. Mr. Speaker, Canadians in the majority of this House urge Canada to meet the Kyoto objectives. Most countries are in the process of putting in place aggressive measures to fight climate change. The consensus is clear. When is this Minister of Environment going to act? When will she join the international effort? When will the Conservatives set aside partisanship and work with the others to ensure the survival of the planet? The Minister. Thank you very much, Mr. Speaker. Mr. Speaker, our Clean Air bill will allow us to meet Kyoto objectives, with the exception of the unachievable ones set by the Liberals. We will have progress that will be made with our international partners, and I hope that the opposition will support the Clean Air Act. The member for Westmount Ville-Marie. Mr. Speaker, Canadians have heard enough of this type of talk from the minister. Canadians are entitled to know what will be said at Nairobi by their officials. The minister is refusing to listen to Canadians who believe in Kyoto. Will she stand up and make a commitment for the short term on the protocol and on the basis of the Montreal Conference? And will she unreservedly support the targets for the second phase?
Mr. Speaker, we have been honest with Canadians, honest with our international partners, and honest with ourselves. Compared to the last government, we have said to the international community we are committed to the Kyoto Protocol, committed to working with them, but we cannot meet the unachievable, unreachable targets set by the former government. But, Mr. Speaker, I would encourage the honourable member to go onto the United Nations website or the Environment Canada website, which has all of our position related to Kyoto, posted there for everyone to see before we leave to Nairobi.
The Honourable Member for Laurier-Sainte-Marie. Mr. Speaker, the Minister of the Environment has repeated several times that the objectives of Kyoto are unrealistic and unattainable. The Prime Minister stated that we had to go beyond Kyoto objectives, which would be achievable through the Clean Air Act. This is very ambiguous. At the moment when the climate change conference in Nairobi is opening, Can the Prime Minister give us some sort of conclusion with respect to his position on Kyoto? The Right Honourable the Prime Minister. Mr. Speaker, if you talk about confusion on Kyoto, I look with interest at this new alliance between the Liberal Party and the Bloc Québécois on the environment. But before going further, the leader of the Bloc, a word of advice, rather than continuing to associate with the Liberals, perhaps he should read this quotation. I think that our party will be in great difficulty with respect to the environmental issue because we don't really know what Kyoto Protocol means, and that was the member for Etobicoke who said that, the Honourable Member for Laurier-Sainte-Marie. Mr. Speaker, in the past we were aware of the weaknesses of the Liberal plan, but all they're doing to try to correct that is to deny that greenhouse gases exist. We can't proceed any longer like this. We can't deny when you can't continue to say that it doesn't exist. How can you continue to support Kyoto Phase 1 and then have other targets for Kyoto 2, the Prime Minister? Well, now the leader of the Bloc is working with the Liberal Party to settle greenhouse gases. This is a very interesting development. I look at Bob Ray. Bob Ray is not a member of the Liberal, has become a member of the Liberal Party and is in the Liberal leadership race. Perhaps the leader of the Bloc Québécois could jump into the Liberal convention and try to seek the Liberal leadership himself. The member for Roberval-Lac-Saint-Jean. Mr. Speaker, to answer the Prime Minister, the Bloc wishes to associate with all political parties, all countries in the world that want to reduce greenhouse gases. Let me say that Montreal is the only place where there is an exchange. They want to establish an environmental exchange, Mr. Speaker. I would ask the Minister of the Environment if she wishes to support the initiative undertaken by Montreal. What is she waiting for? Will she not give us some specific detail about an exchange in Montreal? Thank you, Mr. Speaker. The position of the Bloc is wasting the House's time and the Montreal market's time by opposing. Why is the Bloc opposing this difficulty? What has it got to do with the creation of a market in Montreal? I'm not going to oppose that. If the Bloc is opposing the bill, it is because, like the rest of the planet, we want to do something. We want to see Kyoto be successful, like the NDP, like the others. The minister must say that there are targets. The legislation says that there are targets going to be set for 2011, but it's 2006. We need targets before then. Will the minister set targets now? Minister of the Environment. Mr. Speaker, I invite the opposition to read Section 27 of the Clean Air Act, 27, 29, and 33 of the Clean Air Act, which sets out the notions with respect to acid rain. We are consulting with the parties, with the Liberals, the Bloc, the NDP, and also the provinces and industry. The Honourable Member for Toronto Danforth.
Tuesday, average Americans sent a very strong message to George Bush indicating that they thought his war in Iraq was wrong. And every day we see more and more Canadians speaking out with their concerns about the Liberal-Conservative mission in Kandahar. Mr. Speaker, the Liberals and this Prime Minister do not have the support of average Canadians when it comes to the mission in Afghanistan. Will this Prime Minister finally rethink this unbalanced and ill-defined mission before he meets the same fate as his southern cousin?
The Right Honourable the Prime Minister.
Well, Mr. Speaker, I do appreciate the Leader of the NDP's concern about my fate. That said, Mr. Speaker, regardless of what happens in the United States, our role here is to support our Canadian men and women in uniform. That's what I understand that yesterday the leader of the NDP in Nova Scotia did in supporting an all-party resolution. Darrell Dexter said our job here in this province is to support our soldiers and our military personnel. That's the job of Canadians in every province and in every party.
Honourable member for Toronto, Danforth.
Mr. Speaker, there are reasons to believe that increasing numbers of Canadians are opposed to the war in Afghanistan. It is unbalanced. There is no exit strategy. There are no criteria for success. It's just not working out. The average Americans sent a message to the Republicans: no more war in Iraq. Will the Prime Minister finally change the direction of the mission and rethink the mission in Afghanistan, like he should? The Right Honourable the Prime Minister. Mr. Speaker, the mission in Afghanistan was a mission, a UN mission that is supported by almost all the countries in the world, the people and the government of Afghanistan itself. It's important for us to always support our soldiers. I can say that just before Remembrance Day, the day when we remember our veterans, it's very important to support our troops when they are out there in the armed forces.
Valley West.
Every major environmental group in this country has slammed the Prime Minister, or as he now describes himself, Canada's new emperor. His 50 years environmental scheme. And Canadians have overwhelmingly rejected the Conservative approach. In a desperate attempt to salvage credibility, the Prime Minister voted non-confidence in his Environment Minister and asked the opposition parties to rewrite her legislation. Given that the Minister had her chance and failed, will the government commit now to allowing MPs who actually care about the environment to write Canada's environmental policy?
The Honourable, the Minister of the Environment.
Thank you, Mr. Speaker. If that's an offer of support for the Clean Air Act to go to Legislative Committee to work with the government and put forward a good piece of legislation, we're open to it. We always have been. And I would point out to the Honourable Member that we have support from people like the Clean Air Foundation, from the founder of Healthy Indoors Partnership, from Pollution Probe, from the Canadian Renewable Fuels Association, from the Canadian Medical Association, and the Canadian Lung Association. So we are happy to hear that the Liberal Party will also support us.
Member for Don Valley West.
But the Prime Minister has abandoned the fundamental principles of his Clean Air Act by agreeing to send it to a special committee before second reading, and he abandoned his minister at the same time. Yesterday, the Minister of the Environment was unable to explain her goals for the Nairobi conference. Now that the Minister of the Environment has thoroughly been discredited at home and internationally and by the Prime Minister, will she have the courage to withdraw her bill and let the committee draft a real climate change plan?
The Honourable, the Minister of the Environment.
Well, Mr. Speaker, after they had 13 years, they put forward 4 plans, and they completely ruined Canada's international reputation. We finally can go to the international community and get support for our new plan because this government had the guts to actually be honest with the international community, honest with Canadians, and put forward a bold piece of legislation to regulate every industry sector across this country. I wish they would have been as honest with the international community as we are.
The Honourable Member for Honoré-Mercier. Mr. Speaker, this morning in the Environment Committee there was a clear consensus on what is happening with the Minister's plan. It is short-term, nothing for the future. Everything's going to be put off to 2050. Quite to the contrary, our plan would reflect the respect that Kyoto deserves. From today on, the Minister must do something to protect the generations of Canadians to come. I implore the Minister to act in a non-partisan fashion and support our legislation to work for the future of our children. The Minister of the Environment.
Speaker, once again, our party, our government, is the first government to be honest with Canadians about where we're at with our Kyoto objectives. The bill that the honourable member has put forward, someone yesterday on committee said, would have been good back in 1998. But, Mr. Speaker, it's 2006. We're 35% above our target. We need to put bold regulations forward for industry, and we have to be honest with the international community and honest with Canadians that we're not going to achieve our target, but we are going to make progress towards it.
The honourable member for Honoré-Mercier. Mr. Speaker, the vast majority of Canadians will vote for the party that will start to fight global warming. But it's getting worse because of the inaction of the Conservative government. We want immediate action. Will this government not embrace what we are putting forward? Canadians in this House want something done right away. Why is this government the only entity that opposes my bill? Why is it the only one standing against Kyoto? The Minister of the Environment.
The member has a private member's bill. But, Mr. Speaker, that is not, after 13 years and 4 plans later, going to implement the Kyoto Protocol. We need real government legislation. That's what we have put forward. The NDP is being constructive. We have environmental groups supporting us. The international community is supporting us. I would ask the Liberal Party to stop hanging on to the past and move forward.
The honourable member for Laurentides-Labelle. Mr. Speaker, last Wednesday on the Gaza Strip, there was a terrible event. 18 civilians were killed. Everybody seems indifferent to this. The international community is shocked by what happened. This heightening of the violence, it has enormous consequences for the civilian population. How can the Minister of Foreign Affairs refuse to condemn this rise in violence while all the international community is criticizing it? The Minister. Thank you very much, Mr. Speaker. Thank you very much for the question. It's very clear that our government has expressed great concern with respect to the situation in Gaza.
Ongoing concern and support for peaceful measures to address the strife that is there. Clearly, President Omar has indicated his personal concern for this accident that took place in Gaza. The Prime Minister, thank you. And, Mr. Speaker, we continue to call upon both sides of the dispute, to come forward and take part in a peaceful and constructive resolution of the ongoing strife in the Middle East.
The honourable member for Laurentides-Labelle. Great Britain, France, the Secretary General of the UN, they are not enemies of Israel, have reproached the violence in that area. Is the Prime Minister and the Minister for Foreign Affairs going to stand alone, isolated from the international community with respect to the unacceptable consequences of this heightening of the violence? The Minister.
Well, yesterday, Mr. Speaker, we did express sympathy to those victims and their families on behalf of the Government of Canada. We similarly expressed concern for this escalation in violence. We called upon the Palestinian Authority as well as Israel to take concrete steps towards reducing violence, protecting civilian life, taking all steps to move towards a peaceful solution. And, Mr. Speaker, I'm also concerned about the leading Hamas official who encouraged attacks upon Israel. And once again, this is deeply disturbing and demonstrating the incompatibility between peaceful solutions and the incompatibility of terrorism and democratic principles in the Middle East.
The honourable member from Montmorency, Charlevoix-Haute-Côte-Nord. For a government that talks about transparency and boasts about its legislation, we are surprised when we learn that the fax machine of the riding office of the Minister of Foreign Affairs was used as a lobbyist tool by his father, Elmer MacKay, former Solicitor General, to defend someone from accusations, charges of fraud from the German justice officials. Is this not an inappropriate use of the material and equipment of the House of Commons? The Honourable the Minister of Foreign Affairs. Thank you very much, Mr. Speaker. I'm very happy to answer this question. It's clear my father is not a lobbyist. He is not an advocate and a lawyer representing other persons. He wrote a letter expressing his personal view. He used a fax machine in my office. He sent to send his opinion. But he lives in my riding, Mr. Speaker. And I think that the members opposite also use fax machines for people who live in their ridings. It's a very clear answer, Mr. Speaker. The Honourable Member for Montmorency, Charlevoix, Haute-Côte-Nord. Mr. Speaker, that means that anybody can use the fax in the Minister's office for any reason at all. Well, could I call on the Prime Minister to remind his Minister that this is not only lacking in ethics, but it violates the rules of the House of the House of Commons, and it is absolutely unacceptable.
Delighted to answer the question again. As I indicated, my father is not a lobbyist. He is a retired lawyer and parliamentarian, as you would know, having served in this chamber for 23 years. Almost 2 years ago, he went into my office, and unbeknownst to me, he sent a letter expressing a personal view, which he's entitled to do. He wrote this letter, Mr. Speaker, to express a personal view on behalf of himself. And I would expect that this happens quite often when constituents come in and want to express a fax. But he has guaranteed me, Mr. Speaker, that he will get his fax machine fixed and refund the 17 cents that this cost the taxpayers.
The
Honourable Member for Moncton Riverview, Dieppe.
Thank you, Mr. Speaker. The Conservatives broke their promise when they said they would treat Canada's veterans with, and I quote, the respect and honour that they deserve, and two, stand up for full, immediate compensation for veterans exposed to defoliant and Agent Orange. Can the Minister inform the House why victims of the spraying of Agent Orange at CFB Gagetown are still waiting for a comprehensive compensation package?
The Honourable, the Minister of Veterans Affairs.
Mr. Speaker, I can hardly believe that question is coming from that member and from that party who sat on this issue for decades, Mr. Speaker, have never even attempted to resolve it. Mr. Speaker, we are working on a solution. We will have a solution. I have the support of the Prime Minister. I have the support of my Cabinet colleagues and most of all my caucus members, Mr. Speaker. We will have a solution. We're working on it. Mr. Speaker, this member better examine the record of the Liberal Party on this issue. Go back and do his research.
Honourable Member for Moncton Riverview, Dieppe.
It's good to see that minister has some energy. He should put it into solving the Agent Orange problem. During the election stop and the election campaign and an election stop in Woodstock, New Brunswick, the Prime Minister falsely promised that a Conservative government would act immediately. When is this minority government going to offer immediate compensation to soldiers and civilians who were exposed to Agent Orange or to other toxic defoliants?
Honourable the Minister of Veterans Affairs.
Mr. Speaker, I think we have a pretty good record in dealing with veterans issues on this side of the House in the time that we've been in office, Mr. Speaker. And I can run through, and I will, Mr. Speaker, some of the things that we have done. And, Mr. Speaker, we made a commitment on this, and we will honour that commitment, Mr. Speaker. I would examine these people who were in a complete state of denial on this issue for all the years they were in office. And again, I can't believe the member would get up in such a hypocritical fashion, Mr. Speaker, on an issue that we are going to have a resolution to.
Honourable Member for Nipissing, Temiskaming.
Mr. Speaker, the Conservative election platform misled Canadians when it promised that the Conservative Party would immediately extend Veterans Independence Program to widows of all Second World War and Korean War veterans, regardless of when the veteran died or how long they had been receiving the benefit before they passed away. But this government voted against extending the benefits to these widows. Yet another broken Conservative promise. Is this the Minister's way of honouring veterans and war brides?
Honourable the Minister of Veterans Affairs.
Mr. Speaker, just for the record, we are spending $352 million more on veterans and their families than the previous government did last year alone. Mr. Speaker, in addition to that, we approved ex gratia payments for widows that are left outside of policies that they should have implemented. We did that almost immediately upon forming government, Mr. Speaker. They forget about that. In addition to that, Mr. Speaker, I initiated a health care review. We will act on that review to extend payments and benefits to all veterans.
The Honourable Member for Nipissing, Temiskaming.
Mr. Speaker, I remember the promise they made and they broke it. The Minister has confirmed that this government has no intention of honouring this commitment. In fact, the Standing Committee on Veterans Affairs, the Minister of Veterans Affairs had the gall to tell Canadians that it was never promised in the first place, when it was very clearly laid out in the Conservative platform. When is this government going to keep its promises to veterans and war brides?
The Honourable the Minister of Veterans Affairs.
Mr. Speaker, on that particular issue, the member is wrong in terms of his presentation. Mr. Speaker, we will honour our commitments, and we're going to do it in a comprehensive fashion, Mr. Speaker, not just for widows, not just for veterans, but for their families as well, Mr. Speaker, and the new force Canadian service members as well, Mr. Speaker. We will honour our commitments, Mr. Speaker. It'll be all for all veterans and all families, Mr. Speaker, not just a selected group.
The Honourable Member for Louis-Hébert, Mr. Speaker. The new government of Canada wants to fight crime. We are determined to have better gun control. The Minister of Public Safety has undertaken broad consultation of organizations to decide what measures are necessary for more effective gun control. Can the Minister update the House on the status of those consultations? The Honourable Minister of Public Safety. I continue to meet with groups on gun control. This morning, for example, I went to Dawson College to meet with Haider Kadim, one of the students who was tragically wounded, and as well the mother of Anastasia, who was tragically killed. The members of the Dawson College Gun Control Committee were there, and it was a constructive meeting.
The student, Kadim Hadir, who was injured at Dawson College, the mother of the slain student, it's very important we listen to their concerns, Mr. Speaker.
The Honourable Member for Parkdale High Park.
Thank you, Mr. Speaker. Under the previous Liberal government, A.T. Carney received a contract to produce a report on how to save the government money on procurement policy. They said it would cost $15 million over 4 years. Total cost of the contract, $24 million over 9 months. Mr. Fortier finally appeared before the Estimates Committee, and to my surprise, he said no report was ever produced. $24 million and no report. Could the Prime Minister explain to Canadians how he's going to get the money back? And where's the accountability in public works that this government promised?
The Honourable, the Parliamentary Secretary to the Minister of Public Works and Government Services.
As the member for Parkdale High Park mentioned, this was a contract that was signed by the Liberals. It was done in a way that frankly, this government certainly wouldn't do, because we believe in getting value for taxpayer dollars. With regard to the A.T. Kearney contract, we are going through an extensive process in order to get the best value for taxpayers' dollars with regard to procurement, and this was part of that process.
The Honourable Member for Parkdale High Park.
Well, Mr. Speaker, in August, the Globe and Mail reported on a junket to the UK taken by 2 ministerial advisors who ended up cancelling their meetings with British officials. Again, we learned today no reports have been produced. How is it possible at a time when over $1 billion has been cut for programs to help our most vulnerable citizens, this government, like the Liberals before them, waste so much of our hard-earned dollars for reports that don't even exist?
Honourable, the Parliamentary Secretary to the Minister of Public Works and Government Services.
Well, the two people in question that the member is referencing that the minister talked about today at committee were in fact held accountable, and they no longer work for the federal government.
The Honourable Member for Markham Unionville.
Mr. Speaker, on January 18th of this year, the Prime Minister wrote to the Premier of Ontario telling him that he would honour the Canada-Ontario Agreement. But just hours ago, the Finance Minister confirmed to the Finance Committee that this was yet another broken promise. I refer to the Minister's preposterous claim that funds paid to all Canadians in every province under the apprenticeship tax credit can be counted as part of the Canada-Ontario Agreement. Why can't the people of Ontario trust the signature of this Prime Minister?
The Honourable, the Minister of Finance.
Thank you, Mr. Speaker. As I explained to the member opposite at the committee, there are aspects of the agreement that are solely expenses that are going to be paid to the revenues that will be paid to the province of Ontario. For example, $300 million for infrastructure that only the province of Ontario will receive as a result of the Canada-Ontario agreement.
Honourable member for Markham Unionville.
Mr. Speaker, this is creative, deceptive accounting that did not answer the question, and it's perfectly obvious that you can't get fairness to Ontario by giving money to everybody when Ontario gets radically less in areas like labour market training. That was the whole point of the Canada-Ontario agreement. And students at Fanshawe College and the University of Western Ontario in London stand to benefit from this money if only the government would keep its word. Why can't the minister stand up for his own home province?
Honourable the Minister of Finance.
No province is doing better than the province of Ontario. An agreement not just for 5 years, which your government entered into, which their government entered into, Mr. Speaker, a full year more, 6 years, $6.9 billion from the federal government to the government of Ontario. This is a great agreement for the province of Ontario.
The honourable member for Davenport.
Mr. Speaker, literacy students and workers from across Canada are here today in Ottawa for their annual Literacy Action Day. Unfortunately, they're not here to celebrate, but to protest the loss of $17.7 million cut by this minority government. These cuts are forcing literacy organizations across this country to close their doors to adults who want to learn how to read and write. What does the minister have against students and organizations that are here to help these particular adults learn to read and write?
Thank you. The Honourable the Minister of Human Resources and Social Development.
Well, Mr. Speaker, as I explained to the literacy groups at lunch today, is that we are going to be honouring all our commitments, all our existing commitments for literacy projects with them. And I've said that many times in this House. But, Mr. Speaker, I might also point out that we are not cutting literacy training. I repeat, we are not cutting literacy training, but what we do believe is that Canadian taxpayers expect us to spend money on literacy education, not on supporting websites and overblown travel budgets for a literacy industry.
Honourable member for Davenport.
Mr. Speaker, this is the minister and the government that said that cuts was an exercise in fat trimming. This is the minister who dismissed more than $150 million cuts to her department as equal to going without a cup of coffee a week. Shame. Instead of callous remarks, will the minister do the right thing, apologize to literacy students that are here today, and restore the full $17.7 million in funding cuts from adult literacy?
Excellent.
The Honourable the Minister of Human Resources and Social Development.
Well, Mr. Speaker, we're going to focus our efforts on literacy education. Unlike the previous government, who was paying literacy groups $34,000 simply for media consultants, who are paying for travel budgets, who are paying for logo development. Again, $34,000 for a group to develop a logo. That's not helping people learn to read and write. We will, in fact, today I announced 5 new programs right across this country that will help Canadians learn to read and write.
The Honourable Member for Haute-Gaspésie, La Métis, Matane, Matapédia. Thank you, Mr. Speaker. The grain producers in Montreal have gone to Montreal and Quebec, have protested again today against the federal lack of federal help. Could the minister indicate at the meeting next week in Calgary of the Minister of Agriculture that he will help farmers, and we need a real agricultural policy to combat American subsidies? The Honourable Minister of Agriculture. In fact, Mr. Speaker, the president of the UPA indicates that agriculture is actually going well in Quebec, and that the industry is more vigorous than ever. This problem, in fact, actually, Quebec has received over $55 million, and we intend to provide more than $400 million before the end of the year. The Honourable Member for Compton Stamston. The Americans are dumping corn into the Canadian market. Will the minister finally admit that he needs to review the assistance programs to grain producers so that they can be more competitive with their American counterparts. He promised this during the election campaign. He needs to deliver now. The Minister of Agriculture.
This government took was to accelerate a $755 million payout to grains and oilseeds producers across the country. Quebec, of course, received their share of that, as they do on all programming, Mr. Speaker. Again, we've so far this year, our contribution in Quebec is about $135 million. We anticipate that our contribution again in Quebec this year will be over $400 million. Mr. Speaker, we continue to work with the government of Quebec and all our provincial counterparts to find the best programming possible to help the most farmers we can.
The Honourable Member for Laval-Les-Îles. Mr. Speaker, small investors know exactly what the Conservatives' word is worth. The Minister's announcement on income trusts has shown them they will remember when it comes time to vote again. They know that, as Stéphane Bougon has said, we know that the promises of the Conservatives are not worth the paper they are written on, and we know that the Minister of Public Works is not here to defend himself.
Mr. Speaker, the member opposite expresses concern about the little people, about small people in Canada. It was not in the interest of individual taxpayers and little people. Yes, the Treasury, the President of the Treasury Board likes the little people. Of individual taxpayers in Canada and their families, in the interests of tax fairness, that corporations, especially large corporations in Canada, pay their fair share of taxes. That was endangered by the growth of income trusts.
Honourable Member for Edmonton, Millwoods, Beaumont.
Mr. Speaker, yesterday Stats Canada released a startling report showing that violent crimes have increased as a direct result of gun and gang crime in our cities. The numbers show that the national homicide rate has gone up for the second straight year because of a spike in gang-related homicides. Mr. Speaker, could the Minister of Justice please tell this House and Canadians what steps he has taken to crack down on this type of crime?
The Honourable the Minister of Justice.
Thank the member for the question. Yes, I can answer that. The homicide survey released by Statistics Canada is a shocking wake-up call to Canadians. We need to take action on guns and gangs right now. I table Bill C-10, which is a targeted measure that proposes mandatory prison sentences for gang members who use guns to commit crimes. Mr. Speaker, during the election, we promised to introduce mandatory prison sentences for criminals who use guns. So did the Liberals. So did the NDP. We kept our word. Why won't they support the legislation?
The Honourable Member for British Columbia Southern Interior.
Mr. Speaker, every time the Agriculture Minister makes a wheat board decision, he steps in what prairie folk politely call a cow pie. This minister has denied wheat farmers the right to vote on the board's future. He set up a sham task force with the sole goal of dismantling the single desk. So, does the minister want to wipe some of that meadow muffin off his shoes and announce today that he will hold a fair vote on the future of the wheat board, announce that wheat farmers will also have a vote?
Honourable the Minister of Agriculture and Agri-Food.
Mr. Speaker, of course, what we anticipate is a very strong voluntary wheat board in a marketing choice world. And Mr. Speaker, we're taking steps to make sure that happens, but of course we're going to consult with farmers as we have been all along, Mr. Speaker. In fact, we're having a plebiscite in the new year, Mr. Speaker. We're going to be talking about barley at that time. We're going to have a very broad voter base and obviously a very clear and fair question. Mr. Speaker, I encourage all farmers to participate in that vote.
Honourable Member for British Columbia Southern Interior.
The government, Mr. Speaker, wants to eliminate the Canadian Wheat Board and wants to hurt grain producers in Quebec. The Americans have been dumping corn for years, and contrary to what the dumping entails, we are suffering. Why is the government not going to the WTO? Why is it abandoning Quebec farmers? The Honourable Minister of Agriculture, Agri-Food.
The Canadian International Trade Tribunal, Mr. Speaker, in an attempt to, or using an argument that American producers were dumping corn. improperly, Mr. Speaker. The Canadian International Trade Tribunal did not support that point of view. There are rumors out there that corn producers may want to go this route again, but Mr. Speaker, more properly, what we're doing is designing programming that will help farmers directly, and Mr. Speaker, working on things like biofuels and biomass enterprises and investment to make sure that farmers have more options, better prices. And Mr. Speaker, thankfully, price of corn is coming up. It's at a 10-year high.
The Honourable Member for Pierrefonds-Dallard. Mr. Speaker, today another Conservative minister has become the laughingstock of the international community. The Minister of International Development was at the Montreal Millennium Conference. Nothing new was announced. We've even gone back when it comes to malaria. Can the minister explain why she said nothing about malaria in her speech, why she has cut $60 million from the budget for buying equipment to combat malaria? Is she not aware that buying mosquito nets is essential to save lives, especially in Africa? Honourable Parliamentary Secretary to the Minister of International Cooperation.
Thank you to the Honourable Member for that question. Newfound interest on the other side of the House about malaria. In fact, CETA has for years been funding anti-malarial projects. The project that we've been working with the African Global Fund, we funded that earlier this year to the tune of $250 million. That, Mr. Speaker, will probably save 75,000 lives.
Member for Kitchener-Conestoga.
Mr. Speaker, we all know the Liberals' terrible 13-year track record on Aboriginal affairs. They left the community of Saskatchewan with a myriad of terrible problems, including flooding, tainted water, social problems, and violence. I think just about everyone would agree that this is a disgraceful legacy of Liberal incompetence. Can the Minister of Indian and Northern Affairs tell the House what Canada's new government has done to address the situation in Saskatchewan?
Honourable, the Minister of Indian Affairs and Northern Development.
Mr. Speaker, thank you for that question. First of all, I would like to thank Mr. Pope, who has tabled his report. I would thank him for his integrity and his hard work. As one respected commentator here in Ottawa said this morning, this is one of the best reports seen in Ottawa in a long time. It was not written by the Department of Indian Affairs in Ottawa. It was written by Mr. Pope, who met and consulted with the people in Saskatchewan. Mr. Speaker, this report provides a roadmap for the people of Saskatchewan. I would emphasize that it will be their choice as to whether they decide to pursue this road or not. We will do so in partnership with them. But, Mr. Speaker, this government intends to leave a legacy of improving the lives of the people of Saskatchewan.
The Honourable Member for Halton.
Thank you. My question is on behalf of soldiers, firefighters, policemen, and others who are forced into an early retirement from their jobs. It concerns pension splitting. I couldn't get an answer to this question from the bureaucrats. So, Minister, I'd like to ask you, will these folks have to wait until they're age 65 before they can split income, or will we do the right thing and let them do it now?
Twice a week. The Honourable, the Minister of Finance.
Mr. Speaker, as you know, as the member opposite knows, the rules have been set out with respect to income splitting for pensioners, and the rules will apply to everyone as they were set out when we announced it on October 31st. With respect to extending beyond that, as I've indicated previously to the Honourable Member, that's something that we can review among many other taxation issues going forward.
This being Thursday, I believe the Honourable Member for Wascana has a question.
Yes, Mr. Speaker. With the parliamentary break that is due for next week, I wonder if the government House Leader would be kind enough to inform us of his schedule for the rest of today and for tomorrow, and then what he would anticipate for at least the first week back when the House resumes after the Remembrance Day break. And I wonder if he is now in a position to give us any more information about when he would intend to call the measures that the government has indicated it will at some point call with respect to same-sex marriage.
The Honourable, the Government House Leader.
Thank you very much, Mr. Speaker. We'll be calling that debate that the Honourable Member just mentioned in due course. And today we will continue the debate on C-27, the Dangerous Offenders Act.
There is an agreement to complete C-25, proceeds of crime, tomorrow. In a few moments, I will be asking the approval of the House for a special order in that regard. When the House returns from the Remembrance Day break, we intend to call for a debate, a motion in response to the much-anticipated message from the Senate regarding Bill C-2, the Accountability Act. As well, we hope to complete the report and third reading stage of Bill C-24, the Softwood Lumber Act. Thursday, November 23rd, will be an allotted day, and I want to inform the House that it is the intention of the government to refer Bill C-30, the Clean Air Act, to a legislative committee before second reading. Now, Mr. Speaker, as I said earlier, I have a motion regarding C-25, which I believe you will find consent. Moved by myself and seconded by the Honourable Minister of Indian Affairs and Northern Development, that notwithstanding the standing orders or usual practices of the House, C-25 be amended as follows. Clause 38 be replaced with the following. 38. Section 72 of the Act is replaced by the following. 72, paragraph 1, every 5 years, beginning on the day on which this section comes into force, the administration and operation of this Act shall be reviewed by the Committee of the House of Commons of the Senate or of both houses that is designated or established for that purpose. 2, every 2 years, beginning on the day in which this section comes into force, the Privacy Commissioner, appointed under Section 53 of the Privacy Act, shall review the measures taken by the Centre to protect information it receives or collects under this Act, and shall, within 3 months after the review, submit a report on those measures to the Speaker of the Senate and the Speaker of the House of Commons, who shall each table the report in the House over which he or she presides without delay after receiving it, or, if the House is not then sitting, on any of the first 15 days on which that House is sitting after the Speaker receives it." End of quote. And the motion to concur in the report stage shall be deemed put and adopted, and when C-25 is called for debate on Friday, November 10th, 2006, after no more than one speaker from each of the recognized parties have spoken at the third reading stage, the bill be deemed read a third time and passed, and that after C-25 has been adopted at third reading, and provided that routine proceedings have already taken place, the House shall proceed immediately to private members' business. I believe you'll find unanimous consent for that, Mr. Speaker.
Does the Honourable Government House Leader have the unanimous consent of the House to propose this lengthy motion? La Chambre l'a entendu.
Is it the pleasure of the House to adopt?
Agreed. And so ordered. So ordered. The Honourable Government House Leader has another point of order.
Thank you very much, Mr. Speaker. I believe you will find that there is unanimous consent for a second motion, moved by myself and seconded by the Minister of Indian Affairs and Northern Developments, that the debate pursuant to Standing Orders 51. Subparagraph 1 be deemed to have taken place.
The Honourable the Government House Leader have the unanimous consent of the House to propose this motion. Agreed. La Chambre l'a entendu. Petit la Chambre.
Is it the pleasure of the House to adopt the motion?
Adopté. The Honourable the Government House Leader, another point of order.
Thank you, Mr. Speaker. And finally, I have a third motion, moved by myself and seconded by the Minister of Indian Affairs and Northern Development, that notwithstanding any standing order, when the House adjourns on November 29, 2006, it shall stand adjourned until December 4th, 2006. That notwithstanding Standing Order 54, during the adjournment of November 29, 2006 to December 4th, 2006, the time provided for filing with the clerk of any notice be no later than 2 p.m. on Friday, December 1st, 2006, and that notwithstanding any standing order or special order, there shall be 2 remaining allotted days in the current supply period, 1 allotted to the Bloc Québécois and 1 allotted to the Liberal Party. I believe you'll find unanimous consent for that, Mr. Speaker.
Est-ce que l'honorable leader du gouvernement
Has the Honourable House Leader, does he have the unanimous consent to table this motion?
D'accord.
Agreed. The House has heard the motion. Will it pass the motion? Agreed. Passed.
Any other motions? The Honourable Member for Don Valley West.
Point of order, Mr. Speaker. Canada had a climate change plan that would have met 80% of Canada's Kyoto obligations by 2010. It was called Project Green. I ask for the consent of the House to table this plan in Canada's 2 official languages.
Does the honourable member for Don Valley West have the unanimous consent of the House to table this document? There is no consent. Order. 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 I'm now prepared to rule on the point of order raised by the Honourable the Parliamentary Secretary, the Government House Leader and Minister for Democratic Reform concerning the need for a royal recommendation for Bill C-284, an act to amend the Canada Student Financial Assistance Act, Canada Access Grants, standing in the name of the Honourable Member for Halifax West.
I would like to thank the Honourable Parliamentary Secretary for having raised this question, as well as the member for Halifax West for the contribution.
That Bill C-284 seeks to create a new category of assistance for students with permanent disabilities and students from low-income families, claiming that such a program does not currently exist in the Canada Student Financial Assistance Act. The Honourable Member for Halifax West countered that this grant program already does exist and that the purpose of his bill is simply to extend the program over the course of 4 years. After examining Bill C-284, the Chair has concluded that it has 2 objectives. First, it takes the existing Canada Access Grants program established by regulation and transfers its provisions out of the regulations into the Canada Student Financial Assistance Act.
I'd like to remind honourable members that in order to spend from the Treasury, there has to be an enabling clause. The government cannot commit monies, but through the regulations, unless it's enabling legislation is accompanied by a royal recommendation.
By authority granted to the Minister by the Canada Student Assistance Act is covered by the royal recommendation which accompanied that Act. Accordingly, the Chair is satisfied that moving the program out of the regulations into the Act does not violate the royal recommendation. However, the second objective of Bill C-284 is more problematic for the Chair. As the sponsor of the bill, the Honourable Member for Halifax West himself pointed out, the bill seeks to expand the grants program so that students will be eligible for grants in every year of a program rather than only during their first year of post-secondary studies. In enlarging the program in this way, the bill extends the program's scope beyond that originally envisaged. Such an extension is not covered by the terms of any existing appropriation. Funds may only be appropriated by Parliament for purposes authorized by a royal recommendation. Any extension of the terms of an existing program must be accompanied by a new royal recommendation. Through the royal recommendation accompanying the original Act, the Minister was able to authorize the funding of a 1-year program. The royal recommendation did not cover a program of 4 years as proposed in the Honourable Member's bill. Therefore, the Chair must conclude that those provisions in Clause 1 of the bill which relate to increasing the availability of Canada Access Grants would require a royal recommendation. In its present form, I will therefore decline to put the question on third reading of this bill in its present form unless a royal recommendation is received. However, the debate is currently on the motion for second reading, and the motion shall be put to a vote at the close of the second reading debate. Orders of the day. Ordre du jour.
Government orders.
Bill C-27, an act to amend the Criminal Code, dangerous offenders and recognizance to keep the peace.
Avant la période des questions.
Before the question period, the Honourable Member for Marc-Aurèle-Fortin had the floor. He now has 16 minutes, and I recognize the Honourable Member for Marc-Aurèle-Fortin. It seems that my audience has diminished a bit, but I will continue. I'd like to try to convince this government, if possible, I don't know if it is possible, I'd like to convince the government that it's headed down the wrong road, and in imitation of the Americans, those who have, by bringing in this legislation, we will be bringing in automatic sentences. What we really want is a way of making sentences individual in a unique way and help us to deal with offenders in a way that is unique to each case. There's something that I've noticed is a constant with the members of the present government. Every time they want to increase sentences or impose minimum sentencing, they always present as examples the worst possible cases. But we're not sentencing for the very worst cases, but also for those that are less serious. Moreover, when they give examples of sentences that seem completely unjustified, I don't remember anyone having mentioned one of the sentences that was quashed by an appellate court. There are thousands of judges in Canada. There are thousands of sentences handed down. And in this sort of system, it's unavoidable that there will be errors. But we have a system in place that allows for the correction of errors, for rectifying errors. There are many factors that come into play when sentences are decided upon. And if we are to amend legislation, it must be shown that at the appellate order, there will be the ability for appropriate sentences in this legislation. The government seems deluded by the fact. It seems to be deluded in thinking that it can protect Canadians against all harm and all crime. I'm here to tell them that's not the case. Crime will always exist, and what we need is the best way to diminish crime. And people are always saying, why are we always opposed by Quebecers? And I'll tell you why. It's that in Quebec, we've tried other things rather than more rigorous sentencing. We in Quebec have less violent crime than does the rest of Canada. In Quebec, the homicide rate is lower than the Canadian average because Quebec has taken inspiration not only from the United States and its problems, but in Quebec, because of the difference of language and because of our various models we've been inspired by in other countries, particularly in Europe, and we've been particularly inspired by the Scandinavian model. These are countries that still believe in criminology and its findings, and they know that crime is a very complex subject. And it's not an exact science, like chemistry. But still, there are some truths that can be realized. We know that prison and imprisonment has very little influence on criminals. And the idea that prison is a deterrence, people think that this keeps people on the straight and narrow. And it may be that a society that had no punishments whatsoever for people who broke its rules, that yes, there might be a problem in a society and that police forces would be unable to control crime. But essentially, the way an offender thinks is not the way people here think. People here who would say, well, I'm not going to do this because I run the risk of a harsher sentence. These criminals are people who think only in the short term and only in the short term and no further. They don't think about long-term consequences. The department, before this bill was drafted, had asked for a study, had asked researchers to come up with an overview of studies on incarceration. And they came to the conclusion that they could not associate an increase. They noticed that not only did incarceration not diminish crime, but they even associated it with a slight increase in reoffending. so not only does it not help, but it may even hinder. And we seem to be ready 7 times more for imprisonment to deal with a problem, crime, and it's something that will always exist, but it is something that we can help lessen. Before this bill was tabled, I had asked my colleague and a fellow who has the same name as I do, the Honourable Member for Hochelaga, to undertake a study at the library, and it was a study on crime rates. And I'd like to quote certain excerpts, and they say that for decades, Canada has been witnessing an overall decline in the crime rate, and this since the beginning of the 70s. From 1971 to 1984, there's been a 10% fall in the crime rate, and this represents 1.6% reduction per year. The drop in crime is particularly significant during the 80s.
From 1991 to 2000 alone, the rate dropped by 26%, an average of 2% per year approximately. This decline was followed by a period of stability between 2000 and 2002, then an increase that was significant, 6% in 2003, attributable to the number of crimes, property crimes, not crimes against the person. A bit of a drop in 2004, 1%, indicated a return to the decline that started at the beginning of the decade. So, I'm convinced when I say this, and I often do this test, most people are learning something new when I tell them this. Why? Because most people, when it comes to crime, rely on the newspapers they read every day. Now, you have to realize one thing. Daily newspapers only report on exceptional cases. They don't report on common crimes. If something serious happens in the collection of crimes presented by the member for Wild Rose, you can be sure that a crime like that will be in the headlines of the daily newspapers. That has been the case for 30 years, the 30 years that I've been looking at opinion polls about crime rates. Crime is on the decline, but people get the impression that it's on the rise. But crime can be measured. This is something that can be measured because police receive complaints and they note this down. They report on the complaints they receive. These are compiled, and then you can look at this and have an overall view. In addition, as I was saying earlier, Quebec had a completely different attitude from that of the rest of Canada. So it's not surprising that its representatives in this House present solutions and approaches that may be different than those of Canada. Because it was successful, not only may I point out that violent crime in Quebec is lower than the Canadian average, but Quebec had remarkable success with young offenders, with an attitude that once again is individualized. A few years ago, despite this success, Quebec was forced to adopt a new Canadian orientation in which judges have their hands tied. They have to follow a certain track which leads to aberrations. I remember one judge who told me, "Look at this, Serge. I have a young person here who was arrested on the street for petty trafficking with a double agent in the drug squad. He had a cell phone. He has a car. He has his own apartment. He's dressed perhaps not tastefully, but expensively anyway. He has one prior, but he respected all conditions." So to my mind, if this was before the reform, I would have said, well, that young person is on the wrong track, maybe I should send him to an institution for a short time, but I can't do that because I'm told there's no violence. He respected the parole conditions. This trafficking he was into was quite petty. It's minimal quantities. So it went the other way in this case. But Quebec, which incarcerated half as many young offenders as the rest of Canada, still had a crime rate which was half that of the rest of Canada. So instead of, and I would have believed, within the same country we have two different communities, and when they apply different methods, seems to me you use the best practices and adapt them, but that's not what was done. We looked to the south once again. We only consult in English, of course. We're so impressed by the news from our neighbors to the south. So we impose this absolute model, and we don't rely on the good judgment of judges. And Quebec did that and has managed to reduce not only the juvenile crime rate, but also its overall adult crime rate. So that's why Quebec always objects here. We're trying to convince the rest of Canada that the American system, which incarcerates 7 times more people than Canada, where your chances of getting killed are 3 times greater than in Canada, is not the way to go. You'd be better off inspiring yourselves from models from foreign countries, European countries, and especially Scandinavian models. One always thinks that prison is the solution to crime. I understand that you're so impressed by economic success in the United States that we're trying to imitate all the time. But in other areas, perhaps we shouldn't be imitating them. Let me give you another example of a country which, with impressive economic success, that is Japan. Well, do you know that Japan incarcerates 3 times fewer people than Canada? 3 times fewer than Canada means 21 times fewer people incarcerated than in the U.S. It has the lowest crime rate in the world. Now, I'm not saying we can reproduce the social context of Japan, which is particular, but it's one more example of the fact that incarcerating blindly and systematically is not the right solution. The right solution to fight crime is individualization of sentences. You have to look at the crime committed. Of course, you look at the severity of the crime, you look at the circumstances in which it was committed, you look at the motives behind the crime, you look at whether the person was dragged into it, if there's a chance of rehabilitation, and then you come to solutions that are totally different sometimes. In my practice, I got a suspended sentence for 3 heroin traffickers, whereas the main trafficker got 12 years, but the suspended sentence was not only justified, but it was a great success for that person. I remember this person who's completely rehabilitated now, who wrote to me for years, sent me a picture of his family every Christmas, and I was quite moved to meet him coincidentally in a restaurant 15 years later. He was with his children. He had called his eldest daughter Sophie he named her after my own daughter. I was very touched by that. So the solution is not this automatic reflex we seem to have. Especially since there are crimes that are serious, but that cover all kinds of situations. I acknowledge that kidnapping, sequestration, kidnapping a child is certainly very serious. But it's not the same thing if you kidnap a child for ransom or if you kidnap a child when you're the child's father and you feel that the child who's been in the mother's custody is in danger because the mother is inadequate for caring for that child and the child wants to go with the father. I'm saying, yes, it's serious not to obey the law, but as you can see, kidnapping covers extremely different situations here. Same for sexual touching. There's a wide range of sexual contact. Of course, contact with violence is unacceptable. It's far more serious. But it can be a crime that's committed in a more or less serious manner. Now, you want to treat them all the same way, and it's that kind of reflex that we're against, because we got better results in Quebec by going toward individualization of sentences. Questions and comments?
Oh, the honourable member's rising on a point of order.
Yes,
the Parliamentary Secretary, the Government House Leader.
Mr. Speaker, thank you. And to briefly interrupt the question and answer period with my honourable colleague, I have two travel motions, Mr. Speaker. I believe you will find that there has been unanimous consent after discussions for the following motion. That in relation to a study of Bill C-10, an act to amend the criminal code, minimum penalties for offences involving firearms, and to make a consequential amendment to another act, 12 members of the Standing Committee on Justice and Human Rights be authorized to travel to Toronto on November 23, 2006, and that the necessary staff do accompany the committee.
The Honourable Parliamentary Secretary, of the unanimous consent of the House, this motion. La Chambre l'a entendu.
The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Carried.
Thank you once again, Mr. Speaker. Similarly, there have been discussions that I think you'll find again there is unanimous consent to the following motion, that in relation to a study of the challenges facing the Canadian manufacturing sector, 12 members of the Standing Committee on Industry, Science and Technology be authorized to travel to Halifax, Montreal, Granby, Oshawa, Toronto, Windsor and Edmonton from November 20th to 24th, 2006, and that the necessary staff do accompany that committee.
Does the Honourable Parliamentary Secretary have the unanimous consent of the House to propose this motion? Agreed. La Chambre l'a entendu.
The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Agreed. Carried.
Comments. The Honourable Member for Wild Rose.
Well, thank you, Mr. Speaker. I listened to the speech from the bloc member quite intently, and I want him to know on the onset that I respect the years that he put into the justice system as a Crown prosecutor, I understand, and as a defense attorney, probably some other avenues. During those years, and I'm assuming we're fairly close to the same age, during those years I spent in the 60s, and the 70s, and the 80s, and the 90s in the education field, in the schools, working with children. I remember in the 60s and the 70s, we allowed kids to go to the parks and play by themselves. We allowed them to go to the corner store to pick up some school supplies, and we didn't worry about their safety or anything. But as those years progressed, it got worse and worse and less safe, and it became more and more problems developing. All through those years, there was a steady increase. Now, I know he's talking about how much crime is really down. Well, I don't really believe that. I know a lot of crime that doesn't even get reported anymore. So if it don't get reported, it can't be in the stats. And that's too bad. But I'm telling the honourable member that during our generation, does he not agree that we sort of let things get out of control with drugs, with pornography, particularly child pornography, where it grew and grew and grew over those years that he's talking about when things were really bad? Well, I'm suggesting to the honourable member that today it is extremely bad that when we have our children being attacked and assaulted, murdered and raped, and I'm talking about babies and kids, little kids, by those evil people out there that like doing that. And they like doing it because they are fed through the pornography against children, through the avenues that are available, which we've let our generation let it got completely out of control. I'm ashamed of that. And I would think this member would be too. I never could understand why, when we work hard to get rid of child pornography, which feeds and poisons those minds, that we always end up in a block and we can't get it done for 13 years. Always somebody objecting. How can you object to those kinds of things? For Pete's sake, get serious. Let's clean up this mess. People who attack children should go to jail and never come out again.
The Honourable Member for Marc-Aurèle Fortin. Well, first of all, I tell the member for Wild Rose that he should rest assured in Quebec, people who attack children are imprisoned. And if they're second offenders, they will certainly spend an awful long time in prison. Unfortunately, maybe the big difference between us is that my experience is completely different from his. Personally, I've raised children. They went to the park. I didn't always go with them. Most of the time, I wouldn't go with them. They were never attacked. There are attacks, but they're relatively rare. I remember the newspapers in those days. I can tell you about crimes. I was looking the other day on the weekend, a movie called Monica la Mitraille. It's a very good Quebec movie. This woman, Monica, did exist. I saw her in court when I was a young man. These were the days of bank robberies, various armed robberies. You look at how somebody becomes a criminal. But when I started practicing as a lawyer, we had bank robberies just about every week. Bank robberies have just about disappeared. Why? It's simple, because preventive measures were far more effective. And so if children are not safe when they go into our parks, if they get attacked or whatever, it's far less expensive and far, far more effective to pay for guards so that children can play freely and safely. Prevention measures, I'm convinced, throughout my practice, they do have results. You don't believe that crime goes down or is down because you're not looking at the statistics. You don't trust those who compile crime statistics, and you're saying people don't report crime. Well, according to my experience, if someone's child is attacked, a woman who's injured in the street, these women do complain. They do go to the police. And the statistics are based on that. Now, of course, there are more and more sexual assaults that are being reported. When I was young, for instance, incest generally was almost never reported. Today, it is. A lot of sexual assault, let's say sexual touching, contact, harassment, that kind of thing was not reported in those days. Now it is. But rape, all violent crimes are reported just as much as they used to be. I'd like to know whether the member for Wild Rose knows anyone who knows a girl who was attacked violently and who didn't want to report it to the police, saying there's no point.
Questions et commentaires. The Honorable Deputy de Jean Lebert.
Honorable Member for Jean Lebert. Thank you, Mr. Speaker. I'd like to thank my bloc colleague for his presentation, which was very interesting, I must say. I was also surprised by the statements made by our Conservative colleague, who is telling us how dangerous it is to live in Quebec and walk around. I come from the southwestern part of Montreal. There's Saint-Henri, among others, that had an incredible reputation in the old days, and now throughout Quebec, people are settling in Saint-Henri because it's a haven of tranquility and safety. So it seems to me there's some disconnect here between the reality and what they're trying to have people believe just to scare them. Now, my question is this. I noted that throughout Canada, there are two different ways of seeing how we should be fighting crime. In Quebec, for many years now, we've been working on prevention, whereas the rest of Canada seems to want to focus on repression. That has happened many times in the past. We saw it with young offenders. And Quebec's work is always being delayed by the actions of the federal government. So I'd like my colleague from the bloc to explain whether there's any other avenue for Quebec. Could we vote for our own laws that suit us, make our own choices in criminal law, rather than have the views of the federal parliament imposed on us? The Honourable Member for Marc-Aurèle-Fortin. Well, that's a question that the person asking knows the answer. He has the solution. I'd say it's pretty sad, because I was always a partisan of Sovereignty Association. And when I said, well, the association, to my mind, and I'm convinced this is true of most Quebecers, as a matter of fact, We don't hate Canada. We don't hate Canada nor Canadians. What we don't like is the Canadian Constitution, which is assimilating us slowly, perhaps, but slowly but surely. And that's what we want to get out of. But generally speaking, we want to keep relations with the rest of Canada. I always thought that one of the things we could share was criminal law, but insofar as Canada wants to continue going down that U.S.-led path, it's a horrible thing. They incarcerate as many people in the U.S. as they do in Russia. That was unthinkable years ago. Perhaps they could get some inspiration from the good things we do. Perhaps we could explain why things don't happen back home the way they seem to in the riding of Wild Rose, but I still do think there's a bit of exaggeration in what the member from Wild Rose is saying.
The honourable member for Wild Rose has approximately 30 seconds for a quick question or comment.
I'll make a quick question. Pardon me, Mr. Speaker. The honourable member failed to really address a lot of things. You know, if he thinks for a minute that there's more drugs in Wild Rose than there is in Quebec ridings, or that pornography doesn't exist in Quebec, child pornography, like it does everywhere else, he's living in a different planet, not a different nation. I mean, he doesn't address the idea. Why is it that his party is so reluctant to come down hard on these elements that obviously are a real threat to our society because they poison the minds of individuals who would dare carry out a threat of violent crime?
Honourable Deputy.
Honourable Member for Marc-Aurèle-Fortin. I don't think there's any less drugs or pornography. But what I do believe, and according to my experiences, I don't know anyone who's not letting their children go to parks because they're afraid they'll be attacked. But if that did happen in Quebec, there'd be an immediate reaction. There'd be more police, more supervision, and I think that's a far better approach. The solution is not to hit hard, it's to hit effectively. And that means trying to understand why people commit crimes and what the real causes are. I don't have long to talk about it, but that's the difference between Quebec's experience and our experience. And thank God in Quebec we have less crime than you have. But you could have less too if you would just take a page from our book. Resuming debate.
Justice.
Thank you, Mr. Speaker, and thank you to everyone that's participating in this debate today. And I will be splitting my time, Mr. Speaker, with the member from South Surrey, White Rock, Cloverdale. Mr. Speaker, I think we've heard all the rhetoric from the other side time and time again, and I've seen this in committee. I have the privilege to serve on the Justice Committee. We've seen on our bill C-10 that would bring in mandatory minimum penalties for gun crimes, how all of the opposition, the NDP, the Liberals, and the Bloc are united in opposing getting tough on crime, even though the NDP and the Liberals ran on a platform in the last election of getting tough on crime, and actually they were promising to bring in measures that were even tougher than what our bill contains. So to now say our bill was too far is ridiculous. We saw it in Bill C-9, Mr. Speaker, that would have brought an end to conditional sentences for people that commit serious crimes like arson, like break and enter into a home, like car theft. And again, we saw the opposition gang up together to gut that bill, basically. And I think Canadians are saying enough is enough. I mean, 3 of the 4 parties in this House were elected with a mandate to get tougher on crime. 3 of the 4, the NDP, the Liberals, and the Conservatives, said that we would get tougher on crime. But now a few months later, when it actually comes time to doing the legislative work, and we've been doing the legislative work with C-9, conditional sentences, with C-10, mandatory minimum sentences, with raising the age of protection, when our party is putting forward the legislative initiatives to protect Canadians, we see the opposition parties dragging their feet, standing in the way, flip-flopping, when they should be cooperating with us so that we can make Canada safer. And I reject the premise of some of the remarks today that crime isn't getting worse. The crime statistics were just released yesterday. And it says that violent crime is up, that gun crime is up, that gang crime is up. I mean, I don't say that, Mr. Speaker, to be alarmist. It's just that we on this side of the House have decided that we're going to face the facts that Canadians want us to take crime seriously, and that crime is serious, and that there has to be effective measures put in place. I want to speak today, of course, Mr. Speaker, to Bill C-27. It's a bill involving dangerous offenders, and it's a bill that involves the worst of the worst, as it were, when it comes to criminal offenses, criminal offenders, those that prey on innocent Canadians, those that have been shown to be perhaps repeat offenders, those that commit the most serious crimes. This is not about any low-level crime. It's the most serious crimes and the most serious offenders. That's what this bill addresses. It responds to our government's goal of tackling crime by strengthening measures to protect families from offenders who are of a high risk to offend sexually or violently in our communities. Most of these amendments, Mr. Speaker, are the result of changes that the provinces, the territories, and other stakeholders, including victims groups, have supported. And that's important to note. The bill amends the dangerous offender and long-term offender provisions, as well as sections 810.1 and 810.2 of the Criminal Code dealing with peace bonds. Briefly, Mr. Speaker, the dangerous and long-term offender amendments of this bill seek to strengthen and enhance those provisions. One of the amendments deals with applications for a dangerous offender hearing under Part 24 of the Criminal Code. It requires a prosecutor to advise a court as soon as possible after a finding of guilt. And that's important to note, Mr. Speaker, this bill is after a finding of guilt and before the sentence is imposed, whether they intend on proceeding with an application. However, for this provision to apply, the prosecutor must be of the opinion that the predicate or current offense is a serious personal injury offense, as defined in the Code, and the offender was convicted at least twice previously of a designated offense as newly defined in Section 752, and, Mr. Speaker, was sentenced to at least 2 years of imprisonment for these prior convictions. So this person has to have committed a serious crime for which they were tried and sentenced twice before for this particular provision to come into play. And when that is the case, the Crown Prosecutor has to indicate whether they are going to pursue the designation of dangerous offender. Another amendment ensures that a court cannot refuse to order an assessment where it is of the opinion that there are reasonable grounds to believe that an offender might be found to be a dangerous or long-term offender. This was a technical amendment recommended by provincial and territorial ministers of justice. The bill also imposes a reverse onus on the offender in some situations where a Crown prosecutor has sought a dangerous offender designation. If a prosecutor is able to satisfy a court that an individual was convicted of a third primary designated serious sexual or violent offense, these are our most serious offenses under the Criminal Code, the Crown is deemed to have met its case that the individual is a dangerous offender, and the individual must then prove on a balance of probabilities that they do not meet those criteria. So we're shifting the onus on that third time onto the offender to show why they shouldn't be designated a dangerous offender. And this brings some balance and some fairness into our system. However, the bill also clarifies that even when the conditions to make a dangerous offender designation have been met, the court must consider whether a lesser sentence, including a long-term offender designation, would be adequate, and neither the prosecutor nor the offender have the onus of proof in that matter. Mr. Speaker, these amendments clearly strengthen the dangerous and long-term offender provisions and will ensure that prosecutors can more readily seek a designation for violent and or sexual criminals who will in turn receive some of the toughest sanctions in the Criminal Code. I also want to touch, Mr. Speaker, on the peace bonds. Bill C-27 seeks to amend the provisions related to Section 810.1 peace bonds for the prevention of sexual offenses against children. And the member from Wild Rose spoke passionately about his desire to protect children from sexual offenders, and this bill deals with just that. And I commend the member and all members that have taken this up and are concerned about protecting children. And also Section 810.2 peace bonds that target more serious violent and or sexual offenses. Mr. Speaker, these types of peace bonds are preventative in nature. They are instruments that are available to law enforcement officials to protect the public. It is not necessary for an offender to have committed a criminal offense for a judge to make such an order. These orders require individuals to agree to specific conditions to keep the peace and be of good behavior. They aim to protect individuals and the general public from persons who are a danger of committing sexual offenses against children or are likely to commit a serious personal injury offense. And these situations, we know, Mr. Speaker, all too often do exist. Once granted, failure or refusal to enter into peace bonds could result in an immediate term of imprisonment not exceeding 12 months. They can be renewed, and breaches of any of the conditions in the peace bond is considered a criminal offense and can be prosecuted in any provincial or territorial court with criminal jurisdiction, providing up to a 2-year prison sentence. Specifically on the peace bond where there's a fear of a sexual offense, the current section of the Code allows anyone who fears on reasonable grounds that another person will commit an offense under specific provisions of the Code against a person under the age of 14 years may lay an information before a provincial court judge for the purpose of having the defendant enter into a peace bond. The specific offenses covered include sexual assaults with a weapon, sexual interference, invitation to sexual touch, and child pornography offenses. Obviously, Mr. Speaker, these are very, very serious offenses, and this bill seeks to protect young Canadians, young children from offenses. And the peace bond can set out certain areas, for example, where an offender is not allowed to go. The Bill C-27 also clarifies and outlines several additional conditions available to a judge if the judge considers it desirable to secure good conduct from the offender. Mr. Speaker, our new government, we just came through an election in January. We said we would tackle crime to make our streets safer. What's a bit ironic is the NDP and the Liberals also said that they would take steps to tackle crime. We've seen no evidence of that so far in this session. Bill C-27 is one of the many initiatives the government has taken towards attaining that goal. We consider offenders who are at high risk of offending sexually or violently to be a very serious threat to public safety. I certainly support this bill, as do all members on this side, and I hope that other members of this House will see how important these provisions are and how they are necessary measures that can be implemented as soon as possible to protect Canadians, protect children, and protect society from the worst offenders. Thank you, Mr. Speaker.
Questions and comments. Questions et commentaires. The honourable member for Wild Rose.
Thank you, Mr. Speaker. What a pleasure it is to hear a speech that makes sense on this particular issue. Sort of gives you a little more confidence in what's been happening in the past little while. I'm wondering if the member could comment on what happened in my riding during the last election. I think most of the people know in this place that I've been working a lot of justice issues for quite a few years. Yes, I'm pretty passionate about some of them, particularly crimes against children. But when I was campaigning in the last election, we hardly ever got into any debates about it in that riding because the Liberal candidate and the ND candidate could only agree and cheered along with me on everything that I said in regards to getting tough on crime. And I thought, boy, this is going to work out pretty good, you know. I'm going to go back to Parliament and we're going to be the government and we're going to get some things done because we got the support of these guys on the left. I mean, this is unusual. You know, I thought this is looking good for Canada. And what I'm hearing today, it's looking sad for Canada. I wonder if the member would agree with me.
The Honourable Parliamentary Secretary to the Minister of Justice.
Thank the member from Wild Rose, and I have consulted with many of my fellow members, and what we found disturbingly is that was the case in many of our ridings. I know it was the case across the country. It was certainly the case when we looked at the platforms of the national parties, where the NDP platform and the Liberal platform were calling for getting tough on crime. I want to use just one quick example, if I may. Our bill on mandatory minimum sentences brings in, for the most serious offenses involving gun crimes, 3, 7, and then 10-year escalating offenses. And the bill, the proposal that the NDP was putting forward was for, on any firearms offense, serious and non-serious, to have a 4-year, on the first offense, a 4-year mandatory minimum sentence. On the Liberal side, they were proposing a doubling of the current mandatory minimum sentences from 4 years to 8 years. Now, our bill brings in what we feel are constitutional measures, proportional measures, escalating so that on the first offense it's less severe than on the second, and so on. It ramps up in severity as we see recidivist actions. The more someone repeats an offense, the more severe it is. The NDP and the Liberal platform went way beyond what we're proposing right now, and yet we see that they're not supporting our legislation. They're not supporting any of our legislation that's designed to protect Canadians. Why won't they get on board?
Questions and comments. The honourable member for Winnipeg Centre.
Mr. Speaker, I just have to point out from an NDP point of view that sometimes the government doesn't go far enough in getting tough on crime. And my colleague hasn't been listening if he hasn't heard some of the speeches from the colleagues in these benches down this way of the House, where we've been saying, for instance, in the seizing the proceeds of crime, the assets of terrorists, we've been saying that we can't understand why the government has gone soft on that bill, because we think you should be able to seize the proceeds of crime, whether it's a motorcycle from the Hells Angels or some organized crime figure. It shouldn't just be their bank accounts we should be able to seize. It should be their luxury mansions and their speedboats and their tricked-out Escalade cars. If they can't prove that they got those, that they purchased those luxury items through legitimate earnings, we should be able to seize them and put the reverse onus on the crook and make them prove that they didn't buy them through the proceeds of crime. Well, I'm only pointing this out, Mr. Speaker, because the member down there is wandering way off the subject of the day to accuse us of not being tough enough on crime, when in actual fact it's them that's going soft on organized crime. I don't know who they're worried about making angry.
Mr. Secretary, the Minister of Justice.
That's a little rich, Mr. Speaker. I mean, I can understand the honourable member's concern about having a record of being soft on crime that his party has. We only have to look at the evidence as what's taking place in committees where the Liberals and the NDP are ganging up with the Bloc to frustrate any attempt to get tough on crime, gutting Bill C-9 on conditional sentencing, opposing mandatory minimum sentences when they said they would be in favour of them during the election, and now on this bill, Bill C-27, that deals with the most violent, most serious offenders. We're talking about people that have a third-time serious offence. You are not willing to get tough on those individuals, and we are.
Resuming debate, the Honourable Parliamentary Secretary to the Minister of National Defence.
Thank you, Mr. Speaker. Mr. Speaker, I rise today to speak to Bill C-27, an act to amend the criminal code dealing with dangerous offenders and the recognizance to keep the peace. As you know, Mr. Speaker, our government has already presented a number of important measures aimed at furthering our key election commitment to tackle crime. Among many other promises in our election platform, we said we would, and I quote, create a presumption of dangerous offender designation for anyone convicted and sentenced to federal custody for 3 violent or sexual offenses. Bill C-27 seeks to fulfill this specific election promise. We said we'd do it, and we're doing it. Right now. Our Conservative government believes in treating criminals justly. But justice demands that after repeatedly offending against society, violent criminals must be stopped. After 3 strikes, the onus is on the violent criminal to prove he is no longer a danger to society. We do not believe in revolving door justice like the Liberals promoted over the past 13 years. A system where serious offenders were able to commit violent and sexual crimes repeatedly and then set free repeatedly to victimize even more Canadians. We believe the primary responsibility of government is to protect Canadians, and that is exactly what Bill C-27 will help us do. Bill C-27 strengthens existing measures that are available to protect our loved ones, our neighbours, and our communities from repeat offenders. Now, Mr. Speaker, I'm going to get into some of the technical aspects of the bill, but they're actually very important. The first portion of the bill deals with applications for dangerous and long-term offenders hearings under Part 24 of the Criminal Code. The amendments impose a duty on the prosecutor to advise a court whether they intend to proceed with a dangerous or long-term offender application as soon as possible after a finding of guilt and before sentencing when the following several criteria have been met. First, that they are of the opinion that the predicate or the current offence is a, quote, serious personal injury offence as defined in Section 752. Second, the offender was convicted at least twice previously of a designated offence as newly defined in Section 752 and was sentenced to at least 2 years for each of those convictions. Under the current legislative framework, a court will order a designation hearing based on whether the individual has been convicted of a serious personal injury offence and whether there is a reasonable likelihood that the individual will be found to be a dangerous or long-term offender. An amendment recommended by provincial and territorial ministers of justice ensures that a court cannot refuse to order an assessment when it is the opinion that there are reasonable grounds to believe that an offender might be found to be a dangerous or long-term offender. As well, an amendment is made to mandate a court, following an application by a prosecutor, if there are reasonable grounds to believe that the offender might be a dangerous or long-term offender, to order a psychiatric assessment before the hearing can proceed. This was previously done at the discretion of the court, no longer. Another amendment allows the court to extend up to 30 days the period within which a report must be filed if there are reasonable grounds to do so. Mr. Speaker, of particular interest to members of this House may be the amendments in this bill providing for a reverse onus in dangerous offender designation hearings. The amendments provide that the Crown is deemed to have satisfied the court that the offender meets the prerequisites for a dangerous offender designation once the court is satisfied of the following four principles: that the offender has had 2 prior convictions from the new list of 12 serious sexual or violent primary designated offences in Section 752, that the previous convictions carried a sentence of at least 2 years, and that the current offence, the predicate offence, must also be the one of those primary offences. And finally, that the predicate offence would otherwise merit at least a 2-year sentence. So there's some serious hurdles here that need to be overcome, but they're ones that we're confident that can be overcome. However, the amendments give the offender an opportunity to rebut this presumption on a balance of probabilities. The bill also clarifies that even when the conditions to make a dangerous offender designation have been met, the court must consider whether a lesser sentence, including a long-term offender designation, would be adequate, and neither the prosecutor nor the offender has the onus of proof in that matter. Mr. Speaker, these amendments will enable prosecutors to more readily seek a designation for violent and/or sexual criminals. They will also encourage consistency in prosecuting when considering a dangerous or long-term offender designation. Mr. Speaker, I would now like to speak briefly about the amendments to the provisions dealing with peace bonds. Bill C-27 amends Section 810.1, dealing with peace bonds for the prevention of sexual offences against children, and Section 810.2, dealing with peace bonds for more serious violent and sexual offences. These peace bonds are tools available to law enforcement for public protection against high-risk individuals who are likely to commit a sexual offence against children or personal injury to others. Mr. Speaker, the current Sections 810.1 and 810.2 of the Criminal Code may allow anyone who fears, on reasonable grounds, to lay in information before a provincial court judge for the purpose of having the defendant enter into a peace bond to keep the peace and to comply with any other conditions the court might impose designed to protect the public from future harm. Section 810.1, peace bond, is designed to protect against sexual offences against children under the age of 14, while Section 810.2 targets individuals who may commit, quote, a serious personal injury offence. Now, a serious personal injury offence is defined in the Criminal Code as including offences that are pursued by way of indictment, such as first-degree or second-degree murder involving violence, or conduct endangering or likely to endanger life or safety, or where the offender could be sentenced to 10 years of imprisonment or more. Alternatively, a serious personal injury offence also includes a conviction for sexual assault with a weapon, or aggravated sexual assault. Under the current legislative framework, a judge may order that a person enter into either of these peace bonds for a period not exceeding 12 months if the judge is satisfied that the informant has reasonable grounds to fear that another person will commit a relevant offence. This means a sexual offence against a child for the Section 810.1 peace bond or a serious personal injury against another person for the Section 810.2 peace bond. The amendments that we're bringing forward significantly extend the maximum duration of these peace bonds from 12 to 24 months in certain situations. For the Section 810.1 peace bond, this longer peace bond will be available where a judge is also satisfied that the person was convicted previously of a sexual offense in respect of a victim who was under the age of 14. For the Section 810.2 peace bond, the longer duration can apply where the court is satisfied that the offender has previously been convicted of a serious personal injury offense. Currently, the judge can also order that the defendant comply with any conditions that are reasonable in the circumstances to ensure the offender does not commit harm. These often include conditions to not have contact with potential victims or to stay away from certain places and to report regularly to the police or probation workers. The amendments that we're putting forward will clarify the broader conditions can be imposed on defendants than those that are currently described. The additional conditions that are outlined in the amendments relating to both types of peace bonds include requiring a defendant to, for example, participate in treatment programs, or wear an electronic monitoring device if the Attorney General consents, or remain within a specific geographic area unless permission to leave is granted by a judge, or remain at their residence at specific times, or abstain from consuming illegal drugs, alcohol, or intoxicating substances. Clearly, we're placing more options before the courts to prevent people from reoffending. In addition, the various subsections in the two provisions regarding the types of conditions that can be considered will be amended so they are worded more consistently. There are a number of wording differences between Section 810.1 and 810.2. While there are certainly differences in who these provisions target, many of the wording differences have caused some difficulties in interpretation in the courts, and as such, all provinces and territories have requested amendments that would provide a more uniform approach. It is proposed, for example, that the judge must now consider for both types of peace bonds, where they previously did so only for 810.2, whether it is desirable in the interest of safety to prohibit the defendant from possessing certain items, including firearms, and whether it is desirable to require the defendant to report to the correctional authority of a province or police authority. Mr. Speaker, the amendments in Bill C-27 will aid prosecutors considering a dangerous or long-term offender designation. The bill will also enhance the ability of law enforcement officials to supervise and control offenders longer and more stringently if they are at high risk of reoffending. Our three strikes law, Bill C-27, puts the protection of the public first, ends revolving door justice for violent offenders, and meets our election promise to Canadians. And I ask all members to support this bill. Thank you, Mr. Speaker.
Questions and comments? Questions and comments. The Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. Mr. Speaker, I'd like to ask my honourable colleague just to clarify something, perhaps not only for myself, but for any Canadian who may be observing these proceedings. My understanding with the provisions contained under Bill C-27 is that if someone has been convicted a third time for a dangerous or a sexual offense, the onus will be on that individual to try and demonstrate or prove to the courts why he should not be considered a dangerous offender. In other words, if someone has been convicted of a rape for the first time, goes to jail, gets out on parole, conducts a rape rapes another child or young woman again, is convicted once again for the second time, goes to jail, gets out and is convicted a third time for rape again, they then would have to prove to the courts why they should not be considered a dangerous offender. Now, to me, Mr. Speaker, that seems to be eminently reasonable, but what I'd like the honourable colleague of mine to comment on, my understanding is the NDP, the Bloc, and the Liberals will be voting against this bill. They will be voting against this bill. So once again, if someone is a three-time rapist, convicted, not accused, but convicted of rape, they would then have to make application to the courts why they would not be considered a dangerous offender. The onus would be on them. But my understanding is the opposition parties, all of them, for some strange reason that is totally unfathomable to me,
will be voting against this legislation, which is designed to protect citizens and victims. And I'd like my colleague to see, am I on the right track here? Is that exactly, do I believe my ears? Is that exactly what's going to happen here? They're going to vote against this legislation?
The Honourable Parliamentary Secretary, the Minister of National Defence.
Mr. Speaker, regrettably, his ears are working fine. It is incredibly unfortunate that this is in fact the case, that we've had for many months now. This bill has been coming forward, and I don't know about the honourable member or my colleagues, but I know that for myself, during the last election, I had numerous debates with members from the Liberals and members from the NDP, and they all came forward saying, yes, we're going to get tough on crime. Yes, we support mandatory minimum sentences. Yes, we support dangerous offender legislation. And now here we are in this chamber with an opportunity to pass the very bill that the member describes, one that would prevent somebody who's already committed horrible offences from being able to recommit those offences. And the members opposite, and to my right, or should I say to my left, simply refuse to come along and support this proposition when we know Canadians want this. Mr. Speaker, last fall I spent many months with the current finance minister going across the country talking to members and to police officers and to families and people who have been victimized by crime in our Safe Streets and Communities Task Force. And everywhere we went, at every stop across this country, Canadians demanded that we get tough on crime, that we don't allow people who have committed horrible crimes to reoffend. Once we know they're dangerous, they should not be let out again. And yet that's what the Liberal government has allowed, the previous Liberal government has allowed for so long. And here we have this opportunity to correct this huge problem within our justice system, and they're sitting on their hands in this empty chamber as I look across from here, and they're doing nothing to support the measures that we have come forward with a mandate from the Canadian public. So I would implore you, Mr. Speaker, to encourage the members opposite, the few that are here, to support this measure. Thank you.
Questions and comments? There's about 30 seconds left for the honourable member from Scarborough East?
Rouge River.
Scarborough Rouge River, sorry.
Well, I just have to say that the government benches look pretty empty too, Mr. Speaker, and I'm waiting for the day when the members of the Conservative Party in this government will be able to govern without having to mention the opposition parties. I wait for the day when this government will be able to stand on its own feet as a mature government and articulate public policy in a way that has merit on its own merits and does not require reference to the Liberals this and the NDP this and the Bloc this. When are they going to grow up? When is this government going to grow up and articulate good public policy from the floor in this House? Because that's what I'm waiting for. And I just note that a lot of what the member was just referring to as he stated the circumstances surrounding a rape, those conditions also are existing in the criminal code and allow the designation of a dangerous offender now. And I can see, Mr. Speaker.
The Honourable Parliamentary Secretary, the Minister of National Defence.
Mr. Speaker, coming from a member opposite who calls our border officers wimps, I don't think he has a lot of credibility on criminal justice issues. I can assure him that we have tremendous support for this, and he may be embarrassed at what his government has not done over the past 13 years and may want us to not refer to their failures going forward. But we have no other alternative but to look at the problems that they have left with our society that we are here now to correct. So I would encourage the member and his two colleagues to support this measure. Thank you very much.
Resuming debate. The Honourable Deputy for Scarborough-Guildwood.
Thank you, Mr. Speaker. Before I get started on this particular bill, I want to remind this government of neocons, that in fact more people voted against them than voted for them. I think sometimes that's just a little lost on members opposite. And if we look at the polls today, even fewer would vote for them than voted for them during the election. So the consequence of that is, Mr. Speaker, that this new minority government has to solicit the cooperation of the parties opposite. Now, I want you to know, Mr. Speaker, that this government dropped 11 bills on the floor of this House. And you know what, Mr. Speaker? The Liberal Party consented to 6 of them. 6 of them, Mr. Speaker, like that. We consented to 6 of them. Largely because, Mr. Speaker, they mirrored legislation that was put forward by the Liberal government in the last government. So, poor fellows, you know, like they can't take success. Isn't that what it boils down to? They can't take success. So there you got 6 free bills like that. Now, Mr. Speaker, they talk about being tough on crime. Well, tough doesn't mean stupid on crime at the same time. And this is one of those bills that's just plain stupid. You know, it's just plain stupid because it will not survive any kind of constitutional challenge. It's a classic. It's a classic. You whip up a fear, you get people all wired about how dangerous it is out there, that the whole nation is just going down the tubes, and then you put forward another dumb bill. So here we have one more dumb bill that somehow or another is going to save the nation from this massive crime rate. Now, I listened to the member from Wild Rose being rebutted by the member from the Bloc Québécois, because the member from Wild Rose is absolutely convinced that we are, in fact, under a massive crime rate in this country. The statistics, of course, don't bear them out. They haven't borne them out for the last decade, but that really doesn't much matter to the member from Wild Rose, and it doesn't seem to much matter to the members in his party, because they basically traffic in fear and smear. Get the population worked up about something that doesn't exist, and then propose a solution to a problem that doesn't exist, and then run away from it because the Crowns, the Defense Counsel, the accused, the victims, and the judges will have to clean up the mess afterwards. Now, it's a...
Order. I'm having difficulty hearing the member from Scarborough-Guildwood, and I think all honourable members would want to keep their questions and comments after his speech, when there will be an opportunity to ask him questions or provide him with some comments. So let's allow the honourable member to continue with his speech. The honourable member from Scarborough River on a point of order.
Mr. Speaker, I do want to support you in that there hasn't been a 5-second window since my colleague began his speech that the members of the government have not been yelling and interjecting. So I simply ask for the courtesy to let the member deliver.
I thank the honourable member, but I think I did just mention that to the honourable member from Scarborough.
I appreciate that intervention on the part of the Speaker and my honourable colleague from Scarborough Ridge River. It's certainly the honourable members opposite have no interest in dealing with facts or dealing with the Constitution or dealing with the Charter of Rights. And for whatever else the Liberal Party stands for, it is the party of the Constitution and the party of our Charter of Rights. Now, let me just, if I may, Mr. Speaker, turn to this bill, which, as I submit to you, is deeply flawed. Members who might be watching this debate, and I can't imagine why they would be, but maybe they are, should know that in the criminal code, as it presently exists, is a dangerous offender section, and it's section 753. And it says that the definition of expression is 752, and the offender has to constitute a threat to the life, safety, or physical or mental well-being of other persons on the basis of evidence, gentlemen, establishing A, a pattern of repetitive behavior, B, persistent aggressive behavior by the offender, C, behavior by the offender associated with the offense for which he or she has been convicted, that is of such a brutal nature as to compel the conclusion that the offender's behavior in the future is likely to be inhibited by normal standards of behavioral restraint. So, Mr. Speaker, that already exists in the criminal code. And this bill doesn't change that. This bill still stays with that standard of behavior. Now, what's going to happen if this bill passes? First of all, a Crown Attorney is going to have to give a notice. He's going to give a notice presumably after 2 convictions. Now, right now, you don't even have to have 2 convictions. You can do it after 1. If you can establish that the individual is going to be a threat to society. In fact, you can obtain an indeterminate sentence based upon just simply 1 conviction. But the Crown is still forced to prove beyond a reasonable doubt that those elements of that individual's behavior threaten the society at large. So what's going to happen here, Mr. Speaker, is that the Crown is going to give notice. Well, just think about that for a second, Mr. Speaker, because if you are defense counsel, you've suddenly got somebody who is probably a pretty bad person, probably has already evidenced the behavior such as having been so much so that he's been convicted of at least 2 offenses, and that person is now looking at an indeterminate sentence, not a determinate sentence. So, in other words, throw him away. He's going to be. And so now the defense counsel is going to say to himself or herself, well, we're going to fight this because if we're going to fight this and we're going to fight this hard. And so no deals and no convictions. And so what's going to happen then? So the defense counsel is going to, in effect, force the Crown to accept the plea to something lesser than possibly is appropriate under the circumstances. Because now you're looking at an indeterminate sentence rather than a determinate sentence. So instead of the individual going away for an appropriate period of time, on the apprehension that they may go away for a much longer period of time, they're going to try and plead it down to something less. Well, that may, for purists in this chamber, think, well, that's not very good at all. But on the other hand, that's the way the court system works. And I don't see that changing in any time soon. And so you're going to have a perverse consequence, Mr. Speaker, that in fact the courts are going to get clogged, that the Crowns are going to have to make deals that they don't want to make, and that the courts, in ending up clogged, are going to actually process fewer people who have been charged with offenses. So the reaction of the Crown is either twofold. The Crown can either say, okay, let's bring it on, let's have the fight, or it's going to be, let's make a deal time. And those are the 2 choices that the Crown is going to be faced with, and the likelihood is that the Crown is going to accept something of a lesser plea because, in fact, the provinces are not going to be greatly more resourced in order to be able to deal with this legislation. And you can ignore that kind of advice on the part of the experts who come before or will come before the committee, or you can take it into consideration when crafting a piece of legislation. The risk is that it puts the entire Section 752 in jeopardy. You can, Mr. Speaker, go to the bank on it. It will be absolutely certain that if, in fact, this section passes, if, in fact, an individual is convicted under this section, that this legislation will be challenged challenged by defense counsel in court under a charter application. There is an absolute certainty of that, and then, Mr. Speaker, you put at risk the entire 752, or they may either strike this bill, or they may strike the entire section. So you again have an ironic consequence. And the ironic consequence is that you lose the entire dangerous offender section and have nothing, which I don't think there's any party in this House would support that kind of a consequence. You play a high-stakes game here with things that clearly are of serious consequence. And, I don't think honourable members need to take my word for it, or even anybody else in this chamber. You might actually listen to what other people who have expertise in this area actually say about it. So if I may, Mr. Speaker, take some time and make reference to David Pacquiao, a professor of law at the University of Ottawa. And he starts in his speech by saying this is the best that can be said about this bill is an amalgam of unenforceable and constitutionally suspect provisions. It puts the burden of 3 strikes on the accused to prove that he or she does not pose that kind of danger that the dangerous offenders do. In other words, it reverses the burden. And when you're reversing the burden on somebody who has to prove that they will not likely do this again. And when you do that, you, in effect, are having to prove a negative. And if you're having to prove a negative, the courts who are constitutionally charged with reviewing this under the Charter of Rights will find it very, very difficult to accept that this is constitutionally acceptable. You have to, in effect, the individual accused has to, well, he's been convicted, has to prove that he's incapable of restraining himself or herself and likely to cause death or injury in the future. To have a substantial or general degree of indifference to the consequences of their behavior and be marked with an incorrigible brutality. And as the professor goes on to say, it provides, in effect, that judges are forced to find that offenders pose the kinds of risks I just described, not only in cases where there's a reasonable doubt about it, but even in cases where there's equally probable that the offender poses no such risk. And therein lies the difficulty that this bill poses for those members in this party who actually have to read the bill in the context of the Constitution, in the context of how courts actually behave. I mean, I listen to some of the rhetoric on the other side, and I wonder whether, in fact, they ever actually go to courts and actually see how they operate. Do they see what the dockets are like for these judges, 200 or 300 cases on a docket at any given time? Do they realize that plea bargaining is, in fact, a way of life in courts, that we would have no justice system at all, that it would grind to a halt if, in fact, every section of the criminal code was constitutionally challenged? And all you've done is raised a huge flag for defense counsel to challenge this constitutionally. He goes on to say that if this is true, the provision would fail to meet both the rational connection test. It will also fail to meet the ultimate balancing that is done under the proportionality test. The provision's costs to the liberty interests of the convict will outweigh the benefits the provision will produce. In either event, Section 1 would not justify the reverse onus. The court is continually balancing the rights of the accused versus the safety and security of the society. It is called the proportionality test, and it is a constant factor in any judge's mind. Is the sentence or is the proposal for an indeterminate sentence, does that weigh against the legitimate concerns of the safety and security of the larger society? So, Mr. Speaker, I hear this rhetoric about, getting tough on crime. I respectfully submit to members opposite that, frankly, they should get a little smarter on crime. They shouldn't put legislation on the floor which will almost inevitably be challenged in the courts, which will almost inevitably see charter challenges from defense counsel. And so I submit, Mr. Speaker, that from our side of the aisle, there is no way that we can, in fact, support this legislation. It does not meet the proportionality test. It does not meet the constitutional test. You cannot reverse the onus in a situation of this kind. You are, in effect, saying to the courts, put this person away indeterminately, and that person actually has to prove that they are not going to offend in the future. So, Mr. Speaker, this is very poorly drafted legislation. It deserves to fail, and I'd be interested in any questions that opposite members may want to pose.
Questions and comments? The honourable member, the honourable parliamentary secretary to the Minister of Public Safety.
Thank you, Mr. Speaker. I've sat and listened to a great deal of what my colleague across the floor had to say.
I would just suggest to them that I may have spent more time in courtrooms than most lawyers have, and one of the things that I've noticed in that 30-year career was that one of the things lawyers do continually is challenge the laws. I don't think we should be concerned about lawyers challenging the laws. And at the same time, I would suggest to him that he's fully aware that there are reverse onus provisions in the code already that have been challenged and upheld as constitutionally strong.
That's right.
The other part I would say to him is that these are the worst of the worst offenders. Talking about plugging up the courts are not continually dealing with these people, but they're dealing with them enough times that we need to deal with those offenders.
That's right.
The offenders are the worst of the worst. These are not shoplifters. These are not people that break windows. These are people that have run afoul of the law in the most heinous way. And we should not, as a society, necessarily have to wait for them for a fourth and fifth and sixth time. This is a law that only makes sense to ordinary Canadians. And I would ask him, what would we have to fear if someone does challenge it in the courts, being that that is the role of a lawyer to continually challenge? And we should not prejudge what the courts would say.
That's right.
For Scarborough-Guildwood. First of all, I agree with him that we are dealing with the worst of the worst, and therefore a very, very small minority of people. At any given time, there's only 21,000 people that are under Canada Corrections supervision, and of those, about 8,000 people are in some form of non-custodial supervision. So we are dealing with a very small subset of a group of people, and to wit, this commitment on the part of the Conservative Party during the election to crack down on crime, when in fact they're cracking down on a very micro subset of the worst of the worst. Now, I point out to the honourable member that Section 752 has already been constitutionally challenged and already been upheld in the courts. And what he does by putting this overreach into the courts is, in fact, open up 752 for an entire constitutional challenge. And I think that risk that he's running, it does not in any ways commensurate with the harm that he wishes to address. So 2 points. We're dealing with a micro subset of a subset of a micro subset. And 2, he's putting at risk the entire constitutionality of 752.
Questions and comments? The honourable member for Scarborough-Rouge River.
During these remarks and prior remarks, there was a suggestion that this particular legislation attempts to deal with the worst of the worst. And as I look at the schedule of offenses listed in this, while they are all indeed criminal offenses, I'm just wondering whether the member, my colleague, would want to comment on the list itself, given that it includes criminal offenses which, while they are indeed criminal offenses, might not be classed as what members opposite have called the worst of the worst. And there are some 56 separate offenses listed, not just the rape scenario mentioned by one of the members opposite in his remarks. And I would agree that a rape situation is an extremely serious offense, and 3 of them in a row leads one to an obvious conclusion. But the offenses in this, and I address it to my colleague, can include, based on what's here, ordinary assault, an abduction of a child from Canada. That could be a parent leaving with the child without authorization, a robbery. I'm not saying they're not criminal offenses, but the members opposite describe these offenses as the worst of the worst. And so I just wonder if my colleague would care to comment on that, given that we're dealing with a 3 strikes and you're out presumptive scenario here in this bill.
The Honourable Deputy de Scarborough.
The Honourable Member for Scarborough-Guildwood.
That California has something of a parallel legislation, and they're finding that it doesn't work, and it catches a whole bunch of unintended consequences. And my honourable colleague, in fact, addresses one of the unintended consequences. The members opposite here think that this is sort of like, 3
3 brutal assaults, and therefore this person is not able to control himself or herself, constitutes a danger to society, and therefore should be put away as a dangerous offender. When in fact, by, if you will, lowering the standard of the offense, effectively you are opening up the entire criminal code within a certain realm to people who are probably the members opposite don't intend to have convicted as serious offenders. But by reversing the onus, for instance, 2 assaults, you're now faced with a 3rd assault. You may or may not be the worst of the worst. You may, in fact, be you may have other problems which actually get you there. And I say to my member opposite, the times that I was in court, which I don't think were nearly as frequent as he was in court, were that a lot of the people who are convicted are people who have all kinds of other problems. I mean, something in the order of about 70% of the offender population is functionally illiterate. A lot of them have serious mental health issues. And so what you're doing is designating a lot of these kinds of people as dangerous offenders, putting them away in an indeterminate fashion, and they will rot. Now, so I just don't see the argument that the honourable members opposite are making to support this bill, because it is literally taking a howitzer to kill a gnat.
Questions and comments. The honourable member for Winnipeg Centre.
Well, thank you, Mr. Speaker. Coming from Winnipeg Centre, one of the most shocking things when you're dealing with criminal justice issues or sentencing is you have to acknowledge the shocking over-representation of Aboriginal people in our prison system to date. And when I looked at the schedule of offences being contemplated for inclusion under this bill, it struck me right away that that's going to exacerbate is the term I'm looking for, the appalling social situation where Aboriginal people are locked up at an alarming rate, disproportionate to their size in the population. Do you think, has my colleague given any thought to if there was any analysis, cultural analysis, given to this bill when it was crafted in that light?
The honourable member for Scarborough-Guildwood.
Well, the discouraging part about this bill, Mr. Speaker, is that I don't think there's much analysis going on in this bill at all. And that is what's it is simply election rhetoric. It's a reaction to election rhetoric, and you rightly point out that particularly in Manitoba and Saskatchewan, Aboriginal offenders are seriously overrepresented in the criminal court system, and frequently have problems outside of simply criminal issues, whether it's mental health issues or other social issues. The honourable member would know better than I how all of these things, and that's my point to the issue previous, is that this bill is just going to catch a whole bunch of people that not one person in this chamber thought was going to get caught, because it's easy. It's easy. You got 2 assaults. This individual is on the streets. They've got an alcoholic problem, or they got a mental health issue problem, et cetera, et cetera. The Crown gives a notice, so the defense counsel is usually duty counsel and doesn't really know the offender. Will try to do his or her best to do a defense on a reverse onus. And bingo, our friend on the streets of Winnipeg is in an indeterminate sentence, for which essentially is a life sentence for what otherwise would have been maybe a 2-year conviction or a 4-year conviction, et cetera, et cetera. So that's how it's going to play out. And I think that there's a significant chance of injustice as a consequence of that.
The honourable member for Palliser will have about 35 seconds for a quick question or comment.
That's going to be difficult, Mr. Speaker, but the honourable member from Scarborough-Guildwood has stood in this House and referred to this bill as being stupid, and I must thank him for this astute legal analysis as proof. As proof of this point, the honourable member offers up the assertion that the bill might be found unconstitutional by our courts because it contains what is called a reverse onus. Mr. Speaker, briefly, there's a list of provisions in the Criminal Code containing reverse onuses that have either been unchallenged through the years or held to be constitutional. S. 515, bail provisions, Section 490, sex offender registry provisions, Section 16, not criminally responsible provisions, 487, DNA orders, and I can go on, Mr. Speaker. In other words, there are multiple precedents in the Criminal Code for reverse onus provisions, so I wonder if the member from Scarborough-Guildwood would rise in his place and retract that statement.
Honourable member for Scarborough-Guildwood, 30 seconds.
Absolutely no chance. The honourable member is correct to say that there are reverse onus provisions in the Criminal Code. He's incorrect to say that it's reverse onus for indeterminate sentences. An indeterminate sentence is essentially a life sentence. You are away at the pleasure of Her Majesty. That's it. End of story. This is a red flag in front of the courts, which inevitably will be challenged. And what he's done is he and his government have put the entire dangerous offender section of the Criminal Code at risk by doing so.
Resuming debate, the honourable member for Palliser.
Well, thank you very much, Mr. Speaker. And just to finish up on that last point before I start, Mr. Speaker, there are multiple precedents in the Criminal Code for reverse onus provisions. Moreover, the burden on the accused, an accused who has already been found guilty of the crime. That's key, Mr. Speaker. They've already been found guilty. The bill is not stupid, Mr. Speaker. It's the honourable member's legal analysis opposite, which more readily meets this description. And it's humorous, Mr. Speaker, to watch the member anticipate almost with glee the efforts of defense lawyers. You know, he talks about the amount of time that he spent in court. What we really need to be listening to, Mr. Speaker, are the citizens of Canada that send us to this place, that sit and watch this on television, who've maybe spent no time in a courtroom, but they know that common sense tells them that people that commit multiple heinous crimes, and we're talking about the worst of the worst here, Mr. Speaker. We're talking about the Peter Whitmores of this world. This is part of what sparked this type of courageous bill from the Minister of Justice. We're talking about locking up indeterminately for at least 7 years, the worst of the worst. Canadians know it's the right thing to do. Coast to coast to coast, it's only the Liberals, the Bloc Québécois, and the NDP members that don't know it's the right thing to do. But, Mr. Speaker, it is my privilege today to speak in favour of Bill C-27, which proposes to strengthen and clarify certain provisions relating to dangerous and long-term offenders, as well as two types of peace bonds. This bill seeks to accomplish the following reforms. First, it proposes a number of changes to the dangerous offender provisions of the Criminal Code. These changes are designed to address concerns that since 2003, there have been problems encountered in securing dangerous offender designations. These changes include a new reverse onus provision, a new provision which codifies the determination of fitness of sentence, a new declaration provision, and some procedural changes regarding the psychiatric assessment. Second, this bill will introduce a number of amendments to toughen Section 810.1 and 810.2 peace bonds that allow police and Crown prosecutors to impose extensive conditions on individuals in our communities who have a high risk of committing serious sexual or violent offences. Certainly, these reforms are significant in the overall context of offender management, which is the federal responsibility of the Correctional Service of Canada, or CSC, within the Department of Public Safety and Emergency Preparedness, Mr. Speaker. My speech today will focus on correctional service, Canada's management of high-risk offenders, and how the proposed provisions will assist these officials to monitor and supervise criminals who are at risk to commit violent and/or sexual offences. The role of CSC is very important to highlight in the context of the amendments to the sentencing legislation. CSC is generally responsible for the management of all offenders who receive federal sentences of detention, that is, sentences of 2 years or more in a penitentiary. Once an offender is sentenced, the role of CSC commences in balancing assisting offenders in their rehabilitation, along with measures of control. This role continues throughout the duration of the sentence, and public safety is the paramount consideration. Upon intake, each offender is assessed to determine appropriate interventions or programs. The assessment is multifaceted and incorporates risk-based historical factors, as well as the need for correctional intervention. Risk-based historical factors are derived from tools such as criminal records, any sex offense history, as well as guidelines established by correctional services to assess serious harm. The need for correctional intervention is determined through an analysis of factors like employment, marital and family status, substance abuse, community functioning, and the attitude of the offender. The factors used to determine intervention are dynamic. As such, they require continuous monitoring to establish risks for reoffending posed by the offender at any given time. When all factors are considered, offenders can be identified as high risk. The level of intervention required to achieve safe and timely reintegration into society can be determined, and a correctional plan can be established for the offender. The correctional plan provides information about the management of an offender's sentence from beginning to end. It may include correctional interventions, such as the referral of one of a range of accredited correctional programs, including the Violence Prevention Program or the National Substance Abuse Program, in order to meet the varying needs of offenders. Other interventions may include increased levels of contact between an offender and a parole officer, psychological counseling, and community-based substance abuse programs. These interventions are crucial in assisting the successful reintegration of offenders. Mr. Speaker, I have briefly outlined the role of correctional services at intake. I'll now speak about parole of offenders generally and how this relates to the legislation before the House today. Generally, an offender may or may not be granted parole eligibility by a judge in accordance with the Criminal Code. For offenders who are granted parole eligibility, they must serve 1/3 of their sentences before they are eligible to be released on parole. For certain violent offenders, a judge may impose parole eligibility at 1/2 of the sentence or 10 years, whichever is less. For dangerous offenders, there is no parole eligibility for the first 7 years and then every 2 years thereafter. The offenses that carry a parole eligibility requirement of 1/2 of the offender's sentence must be pursued by way of indictment, may not be a minimum punishment, and the offender must receive a sentence of imprisonment of 2 years or more. These offenses include some of the most egregious crimes, such as sexual interference and sexual exploitation involving victims under 14 years of age. The paroled release of an offender has a graduated approach rather than a cold release into the community. For instance, conditions may be recommended to the National Parole Board, such as imposing a curfew on the offender to reduce the risk that the parolee will reoffend. Offenders who have not been granted parole eligibility under the Criminal Code are eligible for statutory release. This is an inmate's legal entitlement, with exceptions for inmates serving life or indeterminate sentences to be released into the community after serving 2/3 of their sentence, Mr. Speaker. All federal offenders are to be reviewed for parole by the National Parole Board, if eligible, unless they waive this right. The Board, in determining parole, is guided by a list of principles, including that the protection of society is the paramount consideration in all cases. The Board must also consider certain criteria to grant parole. It must be of the opinion that an offender will not reoffend. The National Parole Board must consider whether there is an undue risk to society before the expiration of the offender's sentence. It must also be satisfied that the release of an offender will contribute to the protection of society by facilitating the reintegration of the offender into society as a law-abiding citizen. For dangerous offenders, the onus is on the offender to prove that he or she poses no risk to the public if parole is granted. Dangerous offenders are very rarely granted even limited parole. According to the National Parole Board, about 99% of all dangerous offender parole applications are rejected outright. This compares to, for example, parole applications for offenders convicted of first- and second-degree murder. These parole applications are denied about 65% of the time. As a result, the dangerous offender indeterminate sentence is often referred to as the toughest penalty in Canadian criminal law. Three main areas are considered during the Board's review: an assessment of an offender's criminal and social history, the offender's institutional behavior and results of interventions, and third, the release plan and community management strategy. With respect to an offender's criminal and social history, many factors are assessed, such as the details of the offence, criminal history, substance abuse, and physical and mental health. An institutional behaviour and intervention assessment considers any evidence of a change in the offender as a result of the benefit of any treatment or program participation while incarcerated, as well as the offender's understanding of the current offence and previous criminal behaviour. When assessing the release plan and community management strategy, National Parole Board members will consider the availability of programs or counselling, supervision controls, and whether special conditions are required to manage risk factors in the community. Given all of these considerations and criteria, along with internal board policies, parole may not be granted to those offenders who are viewed as high risk and represent an undue risk to reoffend. Mr. Speaker, across the country, Canadians have told us that they want to take action on crime. With this landmark legislation, we are delivering. But we cannot do the job alone. We need the support of the opposition MPs to help pass this important legislation we have introduced to tackle crime. Despite their grand overtures and rhetoric, the opposition has done little to actually get tough on crime in this Parliament. They talked a lot about getting tough on crime, Mr. Speaker, during the election campaign, but it's really about what happens after the election and how members stand in this House and represent their constituents and how they vote. And there's only one party that's sticking up for safe streets and safe communities and sticking up for the safety of our children and our seniors, and that's the Conservative Party of Canada and this government. I call upon the opposition to stop watering down crime legislation and do as they promised in the election campaign. Let's get on with the job of making our streets safe for all Canadians. And, Mr. Speaker, I'd like to mention a few members in this House that are on board. They know the importance of getting tough on crime. First of all, led by the Minister of Justice, but also the member from Lumsden Lake Centre, the member from Coppell, the member from Wild Rose, the member from Cambridge, the member from Northumberland, Quinte West, the member from Oxford, the member from Okanagan, Shuswap, and the list goes on, Mr. Speaker. The amount, well, every single member on this side of the House. I see the member from McLeod looking at me. I see the member from Vegreville Wainwright. They all want credit, but they're all working extremely hard on this file to get tough on crime, Mr. Speaker. And I wish that the members opposite would join us in that venture. But, Mr. Speaker, I want to talk a little bit more. I thought I was going to have 10 minutes. It turns out I have 20 minutes, Mr. Speaker. I want to talk to this House a little bit about how crime affects the people in my riding of Palliser and the people across the entire province of Saskatchewan. And in case members don't know, Saskatchewan continues to be the crime capital of Canada under an NDP government. Mr. Speaker, for the information of this House and the members opposite, I'd like to let Canadians know what life is like under an NDP government. Per capita, Saskatchewan's overall crime rate is higher than Ontario's. Saskatchewan is the murder capital of Canada. And this is shocking stuff, Mr. Speaker. Saskatchewan has the highest rate of violent offences of any province in Canada. Saskatchewan continues to have the highest property crime rate in Canada, and crime rates for robbery in my home city of Regina are the third highest of any city in the country, and Regina has the highest number of car thefts in Canada, again per capita, Mr. Speaker. And, Mr. Speaker, I think all of us in this chamber and everyone watching at home recognize that that is a disgrace. The people of Palliser, the people of Saskatchewan have a right to feel safe in their homes and on their streets. And instead, every year they find that they live in the most dangerous province in Canada thanks to years of provincial NDP and federal Liberal governments. You would think that members of the opposition, when presented with a bill like C-27, would support our government's tough new measures to crack down on dangerous offenders. Again, Mr. Speaker, we're talking about the worst of the worst. 24 individuals a year. That's what we're talking about, Mr. Speaker. And the members opposite, the members in the NDP, refuse to support this bill. A bill that puts the onus back on offenders who have already been convicted of 3 violent or sexual offences to justify why that offender should be released back into communities. That's perfectly reasonable. People at home recognize that's perfectly reasonable. In fact, many of my constituents have contacted me and wondering, why do we give people 3 chances? Well, Mr. Speaker, this government, and this is the Canadian way, we have a heart, we try to rehabilitate people, but there's a certain point where you have to say enough is enough, and Canadians are with us. And to me and the citizens of Palliser, the approach of this government makes a lot of sense. That's not what we're hearing from the opposition benches today, and I can't believe that they're not going to support this bill. Mr. Speaker, Canada's new government is ready to take immediate action to get tough on dangerous offenders. I ask the members opposite, particularly the members of the NDP, to stand up today and join our efforts. I ask that they do the right thing and support our efforts to make our neighbourhoods safe. But perhaps that's wishful thinking, Mr. Speaker. After all, let's look at the record of the NDP when it comes to crime and criminal justice bills. The NDP joined with the Liberals to gut an important piece of legislation from our government, C9, that would have eliminated house arrest for arsonists, car thieves, and criminals who break into the homes of our citizens. Sounds perfectly reasonable to me, Mr. Speaker, if you have someone who's burning down property or stealing your car or breaking into your home, that they should probably go to jail. But the members opposite and the opposition parties, they don't think so. They think perhaps that these offenders should be eligible to serve their sentences perhaps in the comfort of their own living rooms. And Canadians know that that's wrong, Mr. Speaker. I know that the NDP members here like to advocate softer sentences for criminals and make excuses for why we shouldn't get tough on crime. But Canadians understand that gutting important crime bills and failing to stand behind legislation like C-27 is simply wrong. And when it comes to Bill C-27, the NDP justice critic didn't do the right thing and voice his support for our bill. Instead, he criticized the Conservative government for bringing forward the legislation to target dangerous offenders. He suggested that the bill, including its reverse onus provisions, violates the Charter of Rights and Freedoms. Yet during the last election campaign, the NDP said they supported a reverse onus on bail for all gun-related crimes. Well, you can't have it all ways, Mr. Speaker, and you can't say one thing during an election campaign and then do a flip-flop once you get to this chamber. I should mention while I'm on this topic, Mr. Speaker, that the former Justice Minister also dismissed this bill outright. Former Justice Minister on the Liberal side of the House, and it's shameful, Mr. Speaker. Mr. Speaker, it's clear that the NDP are content to say anything to get elected, but when it comes to standing behind their words and doing the right thing, they simply can't be trusted. And Mr. Speaker, I think the facts speak for themselves. There's only one party in Canada today that is standing up for safer communities, safer neighbourhoods, and safer streets, and that's the Conservative Party of Canada and this new government. I am so proud to support Bill C-27 on behalf of the citizens of Palliser. It's the right thing to do, and it's the tough action on crime that Palliser residents have called for. That's the thing I hear all the time, Mr. Speaker. Enough is enough, and this is the right thing to do. And, Mr. Speaker, just before I wrap up, I'm sure there will be a few questions. I would like to take this opportunity during Remembrance Week and going into Remembrance Day on Saturday to urge all Canadians to share the story of remembrance and take the time to remember our veterans and those who currently serve in the Canadian forces around the world, including our brave men and women in Afghanistan. The veterans and the members of the Canadian forces are people whom we owe everything that we enjoy today. We owe everything to those individuals, Mr. Speaker, and I just urge members to take the time to remember, as I'm sure all Canadians will. Thank you, Mr. Speaker, and I look forward to some questions.
Pursuant to Standing Order 38, I'd like to raise the questions that will be discussed today at adjournment. The Honourable Member for Laval Health, the Honourable Member for Nanaimo Cowichan, Aboriginal Affairs.
Thank you, Mr. Speaker. I just wanted to try and correct the record, if I could. The member who just spoke referred back to Bill C-9, which was just passed through this place, and while it arguably may not be bang-on relevant, it was mentioned by the member in his speech. And he and the Minister of Justice have publicly stated that arson was removed from Bill C-9. And I just want to ask the member if he's aware that arson of a dwelling house still remains within Bill C-9. And what they're saying to Canadians almost every day is, I can be polite and say it's wrong, but it's misleading to the point of being deceitful. And I wonder if he would mind correcting, if he's aware of that, a dwelling house, arson of a dwelling house, an inhabited dwelling house is a personal injury offense, and it's quite unfair for him and the Justice Minister to continue to repeat that for Canadians. It's misleading and most unfair.
The honourable member for Palliser.
Oh, Mr. Speaker, I appreciate the member's comments, and certainly I will look into that. Perhaps he's picking on a technicality in the bill. My understanding is that under the Liberal plan, or the Liberal version of justice in this country, and the NDP's version of justice in this country, that people who burn down property should be eligible for a conditional sentence. But notice, Mr. Speaker, that the member didn't mention anything about the fact that for people that break into other people's homes, or for theft over $5,000 or auto theft, he had no problem, Mr. Speaker, with those individuals perhaps serving those sentences in the comfort of their own living room. Mr. Speaker, the Liberals and the NDP just don't get it when it comes to crime. Canadians have had enough. They've said enough is enough. That is one of the major reasons they elected a new government, January 23rd. They think it's time to get tough on crime, and they want the Liberals and the NDP to stop dragging their feet and pass these important bills that are going to improve the safety of our streets and our communities. So notice, everyone who's listening at home, through you, Mr. Speaker, no mention whatsoever that break-and-enters and car thieves shouldn't be allowed to serve their sentences in the comfort of their own living room. That's the honourable member's view. It's not the view of this government.
Questions or comments? Questions et commentaires. L'honorable député.
The honourable member for Verchères les Patriotes. Thank you, Mr. Speaker. The member for Palliser, when he began speaking, said that Liberal members, NDP members, members of the Bloc were all wrong for not supporting this bill. And it seems to me that a majority of members in this House do not support this legislation because it's not good. And the members of the Bloc are not supporting it because we have based our judgment on what we've experienced in Quebec. In Quebec, we emphasize rehabilitation in justice. And it works, Mr. Speaker, because the crime rate in Quebec is lower than the rate in Canada and the rate in the United States. Mr. Speaker, I wonder if the member for Palliser believes in reality, and I'd like to ask him that while he wants more safety on our streets, the Conservative government seems to still want people to be able to allow weapons to be circulated on our streets.
Well, the member, my friend opposite, knows that that's not the case, that this government has actually introduced mandatory minimum penalties for crimes committed with firearms. We believe in effective gun control measures, Mr. Speaker. What we don't believe in is a $2 billion boondoggle registry that didn't prevent one crime or save one life. But, Mr. Speaker, the member opposite, he makes a good point. He talks about the majority of this House. People watching this debate at home, that'll be one of the reasons why more Conservative members will be coming to this place. We, on this side of the House, we believe in rehabilitation of offenders as well. But we're talking in this bill, C-27, about 24 people in this country. The absolute worst of the worst. People convicted of multiple heinous crimes. People like Peter Whitmore in Saskatchewan, who has multiple sexual offenses against children. That's what we're talking about, putting the onus on that individual and giving them an indeterminate sentence of 7 years, Mr. Speaker. and I welcome further questions. Thanks.
Questions and comments. Questions et commentaires. The honourable member for Burnaby Douglas. There we go.
Thank you, Mr. Speaker. I'm happy to join in this debate this afternoon. Mr. Speaker, you know, the bluster from the member is quite something when we all know that right now it is possible to declare somebody a dangerous offender on the first time they do a heinous crime of the kind that he's describing. So this bill really doesn't add anything to protect Canadians. If someone is a dangerous offender, that's possible. But, Mr. Speaker, I want to ask the member, in my riding, there's a group of dedicated grassroots organizers, volunteers, who believe in restorative justice programs. They've organized a youth restorative justice program. They're called the Burnaby Restorative Action Group, BRAG. And they can't get money from any level of government to assist them in that important work. We all know that restorative justice programs work, that they reduce crime, that they bring offenders and victims together, that they resolve the problems, that they take the responsibility of solving the kinds of problems that lead to crime in our cities and in our communities and in our neighborhoods very, very seriously. And here's a group of dedicated volunteers that can't get one penny of assistance to set that kind of program up and run it and operate it effectively from this government. Is that appropriate, Mr. Speaker? I'd like to ask the member that question.
The honourable member for Palliser.
Really quickly, Mr. Speaker, a lot of members are very interested in this topic. This is certainly not bluster, Mr. Speaker. This legislation has received the support of victims' rights groups across the country, as well as the Canadian Professional Police Association. And, Mr. Speaker, our new government's stance is in step with the vast majority of Canadians, with the opinion of the vast majority of Canadians, that serious crime must equal serious time. And it's high time to start looking at crime and punishment through the eyes of victims instead of the criminals. What the member mentions is the association in his riding, BRAG. That's something to take up with the Minister of Justice on another day. Today, we're talking about locking up indefinitely the 24 most dangerous people in this country.
The honourable member for Cambridge.
Thank you, Mr. Speaker. I just want to point out, although unlike members opposite, I won't stoop to as low as calling members of this House being deceitful. I was in this discussion earlier when another colleague of my friend opposite, not being deceitful, just probably didn't read the bill, wasn't prepared, made a promise during the election, no intentions to keep it, so no need to be prepared. This bill deals with primary designated offenses. Offenses not once, twice, but 3 times, Mr. Speaker. We're talking about sexual interference, incest, murder, kidnapping, not once, twice, but kidnapping 3 times, Mr. Speaker. Now, it doesn't, unlike what the opposite member suggested, require a beyond reasonable doubt defense. That was untrue, and I'm not suggesting the members opposite are deceitful. I just don't think they're prepared. I would like to ask my honourable colleague that, given that there is no requirement for a beyond reasonable doubt defense, it's a balance of probabilities. There is still opportunity for a judge to intervene in this case. I would just like to ask my honourable member if he agrees that this is on a balance of probabilities, not on beyond reasonable doubt, as my members opposite are not prepared properly.
The honourable member for Palliser will know that there is 30 seconds left.
Well, thank you, Mr. Speaker. And before my 30 seconds run out, I do want to respond. Earlier, there was a comment made from the member opposite about arson of a dwelling house being removed from C9. He should have been prepared when he came to this House, Mr. Speaker. The truth is that is true. It's taken out if you happen to be in your home at the time when someone burns it down, Mr. Speaker. But, Mr. Speaker, if you're not in your house and someone burns down your home, Liberals and NDP members think you should be able to serve your sentence in the comfort of your own living room. And that's what he should have known before coming. And to my honourable member's question, the Minister of Justice has been very successful in striking an appropriate balance. We have to keep in mind that these people have already been convicted and that certainly this law will...
Reprise du débat.
Resuming debate. The honourable member for Saint-Hyacinthe-Bagotte. Thank you, Mr. Speaker. Mr. Speaker, I'm speaking today, and I'm not a jurist or I'm not a legal expert, but I'm intelligent enough to read a bill and to look at what is happening in reality. I can tell whether a bill is intelligent and relevant. And I know that there are many colleagues who have a certain expertise in this area, and they have been able to discuss this bill with me. And this bill before us, C-27, does not help fight crime, does not help to reduce crime. We're talking about deterring potential criminals from committing crimes. Well, if that's what we want to do, this bill is completely useless. I heard my Conservative colleagues say that if we're against this bill, we're against the victims of criminal acts. What demagoguery, Mr. Speaker. This is a bill that doesn't help with anything, that can even be detrimental to the regular court procedures. If we look at the American experience over the past years, there have been similar measures introduced, and we've seen that they have been harmful in the fight against crime. Mr. Speaker, there is no study which proves that this policy with this 3 strikes and you're out, no one has proved that this can have a positive effect. In the United States, it's quite the contrary. Recent experience has shown that even with this kind of measure, they were not able to deal with the crime rate or reduce the crime rate, and it has one of the highest in the world. And there are even studies which show that that as the rates of incarceration rise, so does the rate of crime. So we have looked at this in studying this bill. There is a principle, Mr. Speaker, a fundamental principle at law which is completely flouted, and that is the principle of presumption of innocence. Before a criminal even does, they're saying now that a criminal has to prove that he is not innocent. And I think that this is not the right way of going about things, and we are supposed to have a true system of justice. And this is not at all in the British tradition of justice. There are exceptions, however, some specific exceptions. For example, the proceeds of crime. And we in the Bloc Québécois helped bring forward a bill that would help to convict someone who took part in organized crime. We helped to make it so that someone who, for example, had bought a second home, that they had to prove that they had acquired their goods legally. But when we look at various criminal groups and groups that study this sort of thing, well, we know that in the case of Hells Angels and gangsters, much of what they have acquired is by illegal means. But back to this bill, we've seen that it can even be detrimental to justice. The member said he'd heard from people in his writing saying, why even wait for the offender to commit a third crime? And I would ask the same question, but in another way. Why wait 3 times? With our present system, Mr. Speaker, the Crown Counsel can ask that after the very first crime, an individual be considered a dangerous offender. You don't have to wait to give this person 3 chances, or give this person 3 strikes. If a crime is particularly heinous and particularly brutal, this person can be considered a dangerous offender. the Crown Prosecutor can ask that this person be so considered, and a judge can so deem it. So I ask the question, why wait 3 times? The present system, with the flexibility that prosecutors and judges have, well, they can act with discernment, and from the very first crime, they can, if the crime is serious and enough and brutal enough, they could decide on the designation of dangerous offender. Now, when we look at these kind of policies, well, let's look at the United States. The prisons there are full. If we want, maybe the Conservatives want to be keep up with the George W. Bush, not only economically, not only in helping the big oil companies, but also in terms of our justice system. And in terms of the prison system we want in Canada. In the United States, the prisons are full, and the imprisonment rate is much higher. But even with a policy of 3 strikes, you're out, they still have a 3 times greater the house arrest limit. This must be significant. When a system doesn't work, like the system in the United States, and this is one of the countries that has the highest rate of crime in the world, well, maybe we should catch a clue and realize that we shouldn't imitate that system. The Conservatives have come forward with this kind of bill. It seems that they think they're the only ones who can guarantee personal security and the pursuit of criminals, that they are the true defenders of justice. But this is not at all the case. We have only to look at this legislation. Mr. Speaker, one is a legislator. One assumes a tremendous responsibility. And of course it has to do with doing justice to victims, but we also need the proper instruments to do so. And these instruments, the ones that we have used over the past 10 years, have led to a fall in the crime rate. But they're saying it's so bad in Canada that they have to bring in measures, but not just any measures. Measures that are completely out of sync with reality. We do need measures, but these aren't the ones the Conservatives are bringing forward. But we heard about, we learned about what their policy would be during the last election campaign, but with their 3 strikes, you're out legislation, well, it has no real connection with reality. There are things to be done. It's true. There is one basic instrument, and that is the control of firearms. We've seen statistics recently from Statistics Canada. We didn't make them up. Statistics Canada, Mr. Speaker, who says that in Quebec and in Prince Edward Island, the crime rate is lower than in the rest of Canada. And the highest rate of crime is in the city of Edmonton. And Calgary is a close runner-up. Doesn't that tell you something? When you live in a region where you have the highest crime rate, I think you might try to be a little more intelligent in dealing with this crime rate. And I think that a firearms registry and firearms control, but they have no firearms registry. We learned that in Edmonton, 80% of crimes were committed with weapons that were not registered. Isn't that another clue, Mr. Speaker? Isn't that a sign that we might have to increase control and make sure that there is a registry? Order, please. The Honourable Member for Saint-Hyacinthe-Bagotte has the floor. And the Speaker would like to hear what he has to say. Thank you, Mr. Speaker. I'm very happy that you want to hear what I'd like to say. Okay, so given these facts, the crime rate has fallen in certain areas. In Quebec, we decided to go the rehabilitation route. And before deciding that someone is a dangerous offender, we first have to go through a first stage and decide whether this should be an offender who has to be supervised. And serious crime in Quebec has fallen. We have the lowest rate of serious crime in the country. And in Quebec, the people are very sensitive to the need for control of firearms. I think that there's a certain intelligence also in the approach to these matters, but the Prime Minister and the Prime Minister's government have decided to abolish firearm control, and it seems they are just deciding that everything is the same. You know, Mr. Speaker, the firearms registry, and they also want us to have safer borders. And they think that what we need are, we should be able to go into a bar or a tavern and be able to buy firearms. It's absolutely incredible. That's the second thing that has to be done, Mr. Speaker. Not cosmetic bills like this one, which are supposed to look good and show the Conservatives to be the only defenders of victims. Not at all, Mr. Speaker. We could also be investing in prevention. When we see young people, and I'm talking about kids 10, 12 years of age, who are conscripted by gangs and people who get involved in growing cannabis, these young people are paid $20 an hour, and they come into contact with organized crime at a very young age. Do you think, Mr. Speaker, that perhaps these young people, as they get older, will continue to remain in contact with the criminal world and the gang world? But I'm talking about prevention here. We have to make sure that young people, young children, or young people with problems will have to get to them before they they fall in with these gangs. And what are the Conservatives going to do with respect to prevention? We never hear anything about prevention. In conclusion, I would like to say that the Conservatives are also saying that they are the great defenders of public funds. And that's something I am interested in, Mr. Speaker. But the thing is, Mr. Speaker, we're going to have more prisons. This 3 strikes you're out thing is going to fill the prisons. People will be sent in greater numbers into the prison system. I'm going to give you some figures, Mr. Speaker. I'll tell you what one prisoner costs and then what it costs to rehabilitate someone. On average in Canada, it's $800,000 to keep someone in the prison system. And I'm not talking about maximum security. Maximum security for dangerous offenders, that's $120,000 a year.
That's a lot of money. Do you know what it costs? When you're talking about an offender who has to be controlled, $26,000 a year. $26,000 compared to $120,000. Those figures talk. Those people are opting for reforms to the criminal code that do absolutely nothing to combat crime, first of all. Secondly, it's just to make political hay, to show that they are great defenders of law and order in the police state and victims, whereas they're not helping victims at all. They're creating criminals, Mr. Speaker. They're creating recidivism. They're creating potential crime. Thirdly, they're not talking about prevention and rehabilitation, and that's what works, Mr. Speaker. Everywhere where this was applied, the crime rate went down. serious crime goes down wherever the representatives of the people are not for rehabilitation. You end up with Moncton and Calgary with very high crime rates. Does that mean anything? Ineffective measures, completely inappropriate measures to protect potential victims. We end up with astronomical costs, waste of public funds. And this is fertile ground to prepare people who one day will be imprisoned, will stay 10, 12, 15 years behind bars, and when they come out, as most studies show, when they come out of prison, the risk of recidivism is even greater than when they are in rehabilitation, as is the example of Quebec and other countries worldwide. You have to think a bit and stop playing the police state, the right-wing state, saying we're the only defenders of law and order. That's not true, Mr. Speaker. Questions and comments?
The Honourable Member for Regina, Lumsden Lake Centre.
Mr. Speaker, I have one comment to make basically on the whole issue of the opposition's soft on crime stance, and then one particular question for the honourable member from the bloc. The first thing I would make comment on, apparently the opposition members think it's an appropriate sentence to have a criminal sit at home watching a 52-inch plasma TV stolen from the house that you own just before he burnt it down. That's exactly what these members are saying should be an appropriate sentence as opposed to C9. But my question to the member from the bloc, I am absolutely appalled that he would stand in this House and say for $26,000, that's the reason we cannot afford to designate somebody as a dangerous offender. In our province, there's a man by the name of Peter Whitmore who just recently abused two 12-year-old boys. This was the 6th or 7th time he has done this. He was not designated a dangerous offender. Had he been so, he would have been in jail. Why does that member come to my province and tell the parents of these 12-year-olds that $26,000 is more than the value of a young child? Please come out.
The honourable member for Saint-Hyacinthe-Bacotte has to reply. Mr. Speaker, let's be a little more civilized here. The Conservative attitude to holler like this and get indignant, they should be indignant about the inaction of their government toward organized crime and stop throwing stones at the Bloc Québécois, because I have a memory, Mr. Speaker. In 13 years, the 3 major reforms to the criminal code to imprison Hell's Angels and other groups under criminal gangs like that. The 3 major reforms came from the Bloc Québécois. We did everything to have this passed. The Conservatives were reluctant to have us carry out the reforms necessary to combat real crime with real tools. Let me go back to his example. What does C-27 bring? A coroner can, as soon as there's an odious crime, a sexual assault, something we find just as odious as my Conservative colleague, from the first offence, he can ask that this individual be considered dangerous offenders. They allow them 3 chances. Where's the logic in that? Where's the logic in this bill?
For Malpeck.
Thank you, Mr. Speaker. And I might say in beginning that as one of the ones you tuned up for shouting across the floor here earlier, I might say that, Mr. Speaker, you are to be congratulated for the non-partisan and fair approach you take to your occupancy of the chair. You treat both sides the same. My question to the member who spoke, it spins off what the new government member spoke of a minute ago, in which they yes outline a serious crime, and that indeed is a serious crime. But I think when we're looking at these bills, the key question is, will it work? That's what's fundamental. We all know there's crimes out there and there needs to be penalties for them. But the key question in terms of the whole new approach they're taking to a law and order is, will it work? I was at Justice Committee the other day, Mr. Speaker, and no evidence, no concrete facts. They're basically bringing in an Americanization of our justice system, and we know. Which country do you feel safer in walking the streets, Mr. Speaker? This one or south of the border? So I ask them.
To be fair, again, this question period will collapse at 5:30, and I would like to recommend to to give time for a question from the New Democratic Party, I recognize the honourable member for Saint-Hyacinthe-Bagotte.
A brief answer, please. Yes, Mr. Speaker. You're perfectly correct. My Liberal colleague is perfectly right. When there's a policy like that that's applied, and this is what this government is trying to do, they're trying to copy the Americans. Wherever it's been applied, notably in the U.S., the result today is that there are 7 times as many people incarcerated in the U.S., 3 times more serious homicides in the U.S. than in Canada, and 4 times more than in Quebec. Why are we reproducing a recipe that doesn't work, that doesn't bring anything new? Despite my colleagues' indignation, I maintain that this is a completely ridiculous, ludicrous measure. It's just to make the Conservatives look good because of promises they have to keep, but that are completely ludicrous.
The member for Winnipeg Centre will recognize there's less than a minute for both the question and the answer.
Thank you, Mr. Speaker. I will be brief. I want to thank my colleague from Saint-Hyacinthe-Bagotte for an eloquent and thoughtful remarks. I will dwell only on the one issue that he raised. In my earlier comments, I said that, in fact, the Conservatives are being soft on crime in the issue of reverse onus as it pertains to the proceeds of crime. And it was a Bloc Québécois initiative that said in situations of organized crime, why shouldn't we be able to seize their luxury homes and their assets and have them prove that they earned that money legally and that was not purchased through the proceeds of crime? Is it not the Conservatives who are going soft on that policy, that they're not going after organized crime nearly as stiffly as was recommended by our colleague Richard Marceau from the Bloc Québécois?
The honourable member for Saint-Hyacinthe-Bagotte, 20 seconds. Yes, I thank my colleague and friend from the NDP for this question. Indeed, when you talk about reverse onus for the proceeds of crime, that's not the only improvement we brought to the criminal code. There were 3 others, all major ones. One that led to the spring 2001 operation with biker gangs. We facilitated the evidence for belonging to an organized crime group. Those are real, genuine tools, not ridiculous things like we're being presented with today. That was a contribution by the Bloc Québécois, Mr. Speaker. As it is 5:30 p.m., this House will now proceed with private members' business in accordance with today's order paper.
Affaires émanant des députés.
Private members' business.
Reading of Bill C-279. An act to amend the DNA Identification Act, establishment of indexes, standing in the name of Mr. Wallace.
Resuming debate, the honourable member for Etobicoke North.
Well, thank you very much, Mr. Speaker, and I'm very pleased to speak on Bill C-279, an act to amend the DNA Identification Act, establishment of indexes. And I want to congratulate the member from Burlington for bringing this forward. And if I would guess right, he probably inherited this from the member from Saanich Gulf Islands, maybe in a somewhat different form. But, of course, the member from Saanich Gulf Islands is now the Minister of Natural Resources, and so the colleague from Burlington has picked up this important initiative, and I congratulate him for doing that. I worked with a member from Saanich Gulf Islands in the previous Parliament to see if we could enact this, and you know, the federal government then, our federal government at the time, the Liberal government, was supportive of developing a missing persons index, and in fact launched a public consultation process that was completed last year. And because there are some issues that the member knows about, none of them I don't believe are insurmountable at all, and I think that we need to move towards a missing persons index. But there are some issues around privacy, there are some issues around jurisdiction, and there are some technical issues. And that's why the government, our government at the time, launched the public consultation process. That was completed last year, and I think it was taken to the federal, provincial, territorial ministers of justice last year in November at their meeting. 2005, there were further working groups established, and I believe it's on the agenda for the meeting coming up in November 2006, if my knowledge is right. So that The officials were asked to look at various issues around cost, privacy, legal implications, and to bring forward recommendations. So in terms of the sequencing of this bill, perhaps this bill has all the answers in it. I don't know. I suspect not, but the process is maybe somewhat out of sync, but there's ways to deal with that. And I think that it's a very worthwhile initiative. And, you know, we definitely empathize with those who have relatives or friends that have gone missing. I mean, it's a horrible thing to have to go through, and we know that this happens with some frequency. A lot of people go missing and then are located subsequently, so that the number, for example, of long-term missing persons in Canada is approximately 5,000 or less than 5,000, and an average of 270 new long-term cases are recorded each year, and the Canadian Police Information Centre currently records a total of 286 sets of partial sets of unidentified human remains. So this is the challenge, to see if there can be a match. If someone is missing, maybe they could be linked back to a crime scene or to some other event, and the DNA matched, and it would bring, in the case of a person who is deceased, that would bring some closure to that case and allow people at least to get on with their lives. They know that their missing relative or friend was located at that crime scene, and that is the end of it. You have, though, other situations, I would suggest, where, let's say, young people leave home and they just disappear. And in some cases that may be because of some mischievous event. It might be a voluntary move on their part, just to leave home and travel around and disappear and go under the radar. So that it does raise, I think, some privacy issues with respect to DNA. Of course, in a case like that, the relatives would be approached, and or there'd be some interaction with the relatives to identify some DNA, either off some of their personal belongings or et cetera. And but what happens, for example, if that relative is involved in, let's say, some crime himself or herself? Do they have any privacy rights? What happens if the police are able to match, if it's a deceased person, that's fairly straightforward, but if they're able to match the DNA of the missing person with the DNA of a person at a crime scene who was either at large or convicted or a victim, what privacy rights would that person have? Maybe they don't want to know about their family anymore for various reasons. There can be a lot of things that go on in families, and for whatever reason, they might not want to be associated with their family anymore. Is that what obligations, what responsibilities come into play then? So I think those rules would have to be laid out very, very clearly, and that's not always simple, but I think it's surmountable, but it's not always simple. There are also, Mr. Speaker, issues around jurisdiction. We never like to get bogged down in which jurisdiction has the responsibility, but the fact is that our Constitution lays out certain responsibilities. With respect to criminal law, the federal government has that responsibility. With respect to civil law and property rights, that is provincial. So that when we're talking about missing persons, that normally comes up in the context of local police work. And until such time as there is some criminality attached to it, or there is a suspicion that there is a crime involved, it becomes a local issue. So these matters are dealt with often by local police, and every province and jurisdiction has a different approach with respect to the DNA. So that is why it's clearly appropriate for the federal government to be talking with the provinces and the territories to make an assessment of what is being done currently and what could be done with the national DNA data bank. It's interesting to know, too, Mr. Speaker, that not all DNA is collected and kept in the DNA data bank, the national DNA data bank. So you might have a missing person's DNA, but you won't have all the DNA necessarily in the DNA data bank. In fact, with this Parliament, in the last Parliament, the Parliament passed laws that reduced the judicial discretion in terms of feeding DNA to the DNA data bank, and in this Parliament, there were further, in my judgment, enhancements to that, so that major crimes, serious crimes, there is no discretion with respect to the DNA passing to the National Data Bank, but it's only applicable at this point, even with those changes, to the most heinous and serious of crimes like rape and murder and the like. So there is currently no process for systematically gathering and comparing the DNA samples. So that's an issue that has to be dealt with. The consultation paper that involved a number of Canadians really sought to get some views from experts and other interested parties on how one could put together this kind of missing persons index. That report is in, and in a moment I'll go through some of the findings or some of the recommendations that came out of that consultation process. But there are different approaches to the privacy issues, and we need to have a good debate around that. There are different ways of structuring a missing persons index. It could either be run at the provincial level and coordinated at the national data bank level. It could be run at the national data bank level and fed in by the provinces and the territories. So, Mr. Speaker, there are issues like that need to be worked on, and in fact this consultation process identified a number of different options for the government to look at and for the provincial and territorial and federal minister to look at. And I'm hoping that we make some progress. I hope that the member can take this through to committee and somehow harmonize it with this consultation process and bring it into play, because we need it, and it's an important tool that we can all use. Thank you.
Excellent.
Reprise du débat, l'honorable.
Resuming debate, the honourable member for Argenteuil-Papineau-Mirabel. Thank you very much, Mr. Speaker. I'm pleased to speak on behalf of the Bloc Québécois with reference to this private member's bill, Bill C-279, on an act entitled An Act to Amend the DNA Identification Act, Establishment of Indexes. I'll read you the summary. This enactment amends the DNA Identification Act to provide for the establishment of a Human Remains Index and a Missing Persons Index to help law enforcement agencies search for and identify persons reported missing. Mr. Speaker, as you know, the Bloc Québécois' efforts to defend Quebecers' interests and at the same time to defend provincial jurisdiction. You know about that. And once again, we're seeing discussion here in the chamber, in the House, about a bill, and I'll read a commentary from a parliamentary analyst, a commentary on C-279 that was tabled in the last Parliament. The bill had the same content back then as it does today, and the analyst said that the bill exceeded the federal jurisdiction because it had to do with a local issue. So quite simply, because this bill is not under federal jurisdiction, you know, we can repeat until we're blue in the face, but people keep ignoring us. Before it was the Liberals, today it's the Conservatives. They're always ready to encroach on provincial jurisdiction, and that, Mr. Speaker, you don't have to ask yourself why so many Quebecers want to leave Canada and have their own country, Quebec. It's because ultimately they're sick and tired of this continuous encroachment, intrusion, so much energy and money. 25% of it comes from Quebec, and now it's being spent in areas of jurisdiction that aren't federal. The federal government has enough problems with its own jurisdiction, and that obviously, Mr. Speaker, we can see since the Conservative government was elected, its investment in arms, in weaponry, they have enough problems as it is within their own areas of jurisdiction that they should just leave the provinces alone. Let the provinces enact their own legislation, their own regulations within their own jurisdiction. That said, Mr. Speaker, this is not what the Bloc Québécois said. It was a Library of Parliament researcher who said that this exceeded federal jurisdiction. And there was an admission that there was a jurisdictional issue here, but when there's an issue like that, you simply shouldn't table legislation. That would solve the problem. And that would, if you don't like the Bloc Québécois criticizing you when they're right, then don't table this kind of legislation. This simply isn't a matter of federal jurisdiction. And that, Mr. Speaker, happens too often. It's not that we lack good issues to discuss. There's the fiscal imbalance, for example. Why don't we debate that here in the House? It would be great if other members tabled private members' bills to deal with the fiscal imbalance. Some members say, no, we can't do that because it would cost money, and if it's going to cost money, you need a royal recommendation. But this little bill here, C-279, also requires funding, and so that would require a royal recommendation too. So when bills come up with bills like this that require spending, it would require a royal recommendation, it would require budgeting and so on, so it's not sure it will go through. Well, why don't they try working on the fiscal imbalance in the interest of Quebecers? The Bloc Québécois has always said that it's a $3.9 billion shortfall under the heading of the fiscal imbalance. So why don't some private members table legislation to fix that problem? And that way they can represent, this is something that's in the interest of other provinces too, solving the fiscal imbalance problem. So, Mr. Speaker, you've understood that the Bloc Québécois is going to be voting against this bill, C-279. The reason's simple. This is not a matter that comes under federal jurisdiction. Establishment of indexes for human remains or missing persons, that's really a matter of provincial jurisdiction. And we are always very careful to respect the Constitution of Canada. As you know, Quebec didn't sign the Constitution. The rest of Canada, the ROC, the rest of Canada, came up with its own constitution without Quebec, and now they don't even respect it. That document wasn't acceptable to Quebecers. That's why we didn't sign on. But we're not the ones in breach of it here. So I hope my colleagues have understood that the Bloc wanted to clarify its position. We're against bills that encroach on provincial jurisdiction. This is increasingly unbearable to the Bloc Québécois. So we would invite our colleagues from other provinces to respect Quebec jurisdiction when tabling private members' bills. And I would repeat so that I'm understood clearly. It's not my position. I'm merely repeating what the researcher from the Library of Parliament said about Bill C-240, which is the same, it's identical to C-279 from the previous legislature, and he says that the bill exceeds federal jurisdiction because it deals with an essentially local issue. So the same thing goes for C-279. We didn't ask for a specific analysis from the Library of Parliament on this new bill because we already had one for C-240, so it should be no surprise that the colleague tabling this bill should not be surprised that the bloc is going to vote against C-279. I know it may seem picky, but the top priority, if you want to make sure that we respect each level of government, the province and the federal government, well, the first step is to reread the Constitution to see if it's clear. And it was clear to the researchers, so I hope it's clear to my colleague too, that this bill, C-279, is ultra vires the federal jurisdiction. Under federal jurisdiction, money has been spent and will be spent, and we hope that the conservative vision, Republican right-wing vision of the conservative government, i.e. spending a lot of money investing in the army and weaponry, well, we certainly can't fault them for exceeding their jurisdiction. That is federal jurisdiction. I think the Conservatives have understood that, and that's why they're investing increasingly. The problem is that there's no debate here in the House about what type of weaponry to purchase. There's no debate about the advisedness of our role in Afghanistan, and there's no debate about the environment, about the international conference in Kenya currently. We asked for a genuine debate so that the environment minister would go to Kenya with a genuine position. Now, this isn't the first time this happened. The same thing happened under the Liberals. The problem is, some will say, well, at least she went to the meeting, because it's true, the current government, the Conservative government, doesn't often attend major international meetings. Thank you very much, Mr. Speaker. You're telling me that I just have 2 minutes left. So it's true that the Conservative government doesn't often attend international discussions, and here they'll be attending, but empty-handed, because quite simply the Canadian government has no position and doesn't want to respect the Kyoto Protocol. The Conservative government is basically in cahoots with the oil industry. This is news to no one. Those watching know that the Conservative government is controlled by big oil. That's news to no one. But when you have a major problem like global warming, I think it's time to put aside your personal interests and look at the common good and defend the interests of all Quebecers and Canadians who, as we speak, want the federal government to have a genuine program to fight climate change and meet the Kyoto Protocol objectives, and not adopt legislation like this one, C-279. Thank you very much. Resuming debate.
The honourable member for Barrie.
Thank you, Mr. Speaker. I ask for the consent from all my colleagues in the House on behalf of the member from Burlington, the sponsor of the bill, for this item to be designated to the Standing Committee of Public Safety and National Security.
Does the honourable member have the unanimous consent of the House to move the motion? The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? There is no unanimous consent. The honourable member for Barrie.
Mr. Speaker, I am pleased to rise today in the House for the second hour of debate on Bill C-279 to amend the DNA Identification Act. I am pleased that the Government of Canada is committed to tackling crime and ensuring its law enforcement officers have the tools and resources needed to do their job. And I am proud that the Government also remains committed to working in collaboration with provincial and territorial partners to develop effective tools to fight crime. Mr. Speaker, the bill proposed by the Honourable Member for Burlington suggests that the new index be added to the National DNA Databank. The new index would be used to hold the DNA profiles of both missing persons and unidentified human remains. The bill proposes that these profiles should be cross-checked against each other and against the convicted offender and crime scene indices. The purpose of this cross-check would be to identify human remains. Mr. Speaker, the government fully understands the principles behind this private member's bill. We're also sympathetic to the issues it raises. DNA is an incredibly valuable tool for law enforcement. It is understandable that it could be seen as a way to aid in the investigation of missing persons. If we were to create a missing person index, in this way, we would be aiding a humanitarian aspect to the DNA databank. The question we must address, and one of the reasons that I have risen today in the House to be part of this debate, is should the National DNA Databank be used not only to help solve serious crimes, but also for compassionate and humanitarian reasons, to help solve often lengthy and emotionally charged missing person cases. Mr. Speaker, I would like to give my honourable members in the House some background about how the Government of Canada already uses DNA to fight crime in this country. Here are some data for context. There are currently between 500 and 600 sets of unidentified human remains in Canada. Approximately 100,000 missing person reports are made to police each and every year. Most cases are resolved quickly. I was pleased to learn that an estimated approximately 95% of missing persons are located within 30 days. However, there is approximately 6,000 ongoing missing person cases recorded on the Canadian Police Information Centre. And each year, about 420 cases of people who have been missing for at least 1 year are added to this number. My honourable colleagues may be wondering what the Government of Canada's role in this issue is. First of all, officials from various federal departments are working with their counterparts in the provinces and territories to identify areas that can be improved in the National DNA Databank. Second, the RCMP operates the National DNA Databank on behalf of the Canadian law enforcement organizations. Furthermore, there is federal legislation in place under the DNA Identification Act and further related provisions in the Criminal Code of Canada. DNA is used to solve crimes and assist police investigations by matching DNA profiles from individuals contained in 2 national DNA databank indexes, the Crime Scene Index and the Convicted Offender Index. Related laboratory analysis of samples is done in the RCMP-operated laboratories and in the provincial laboratories of Ontario and Quebec. Mr. Speaker, the addition of the Missing Persons Index has been a work in progress for a number of years now. Let me give you a bit of background on its development. It was during public consultations that preceded the passage of the DNA Information Act in 1998 that the possibility of establishing a DNA Missing Person Index was first raised. It was considered that such a national index would allow the DNA profile of a missing person or close biological relative to be compared to the DNA of found unidentified human remains from jurisdictions across Canada. It was stated that a match could provide family members with confirmation of the death of a missing loved one and could assist with such issues as inheritance and insurance. In 2003, the federal, provincial, and territorial ministers responsible for justice directed officials to further explore the issues involved in the possible creation of a national, principally humanitarian missing persons index. In mid-2005, a federal, provincial, and territorial working group on the Missing Persons Index conducted consultations that revealed broad support among the public for a national Missing Persons Index that would be managed by the RCMP. During the same year, federal, provincial, and territorial ministers confirmed that their continued commitment to developing options for an effective, nationally, principally humanitarian Missing Persons Index that would fit within the existing criminal law regime. They directed officials to complete their work by examining the cost, the privacy, and the legal implications of a Missing Persons Index. These officials were tasked to bring forward recommendations Federal, provincial, and territorial ministers responsible for justice met in October of 2006 to review the recent progress of the working group. Ministers noted that the work is well advanced and directed the working group to focus on outstanding issues relating to cross-matching, jurisdiction, and cost. At the time, provincial and territorial ministers indicated their support for the establishment of a missing persons index, but expressed some concern about the proposals in Bill C-279. Ministers agreed in principle to the concept of a missing persons index and directed the FPT working group to work to resolve key ongoing concerns and report back to FPT deputy ministers at their next meeting in January of 2007. Both the Minister of Public Safety and the Minister of Justice agreed to bring forward FPT concerns on a missing person index in parliamentary discussions of Bill C-279. And it seems sensible to encourage any committee hearings to consider hearing from provincial and territorial authorities as witnesses. Mr. Speaker, speaking of today's proposal, this brings me to our current examination of this option to help fight crime. As it is proposed, Bill 279 would amend the DNA Identification Act by creating within the National DNA Data Bank new DNA indices of missing persons and unidentified human remains. As I noted earlier, the proposed bill also adds to the principles of the Act the goal of bringing relief and comfort to relatives of missing persons. It proposes the new indices should be cross-checked, both against each other and against the criminal indices maintained by the National DNA Data Bank. This process would help identify found human remains. The government has identified legal concerns with this use of the DNA Data Bank. The creation of a missing persons index raises a certain jurisdictional, legal, and privacy issues, as well as jurisdictional and financial questions about which the government would provide the resources to proceed with such an initiative. Mr. Speaker, the government understands that there may be public support for a national DNA Missing Persons Index program and that there is a chance that it could help law enforcement agencies solve missing person cases. We also understand that this could bring about relief and comfort to the relatives of loved ones of missing persons. However, if this use of the DNA was developed as a tool with which to fight crime, we must consider the implications on the privacy of Canadians. I would also note that further analysis of Bill C-279 has revealed that other legal concerns would also need to be addressed before the bill was adopted. In conclusion, Mr. Speaker, this is a worthy initiative. The government is studying ways to ease the emotional burden of Canadian families with loved ones that go missing. We are reviewing the proposal with our colleagues in the provinces and territories. As of this debate, we still need more time to study the matter to see how adding a new index to the DNA data bank can be done effectively in the interest of public safety. Mr. Speaker, I thank you for the opportunity to speak to this motion today, and I applaud the member for Burlington for bringing this debate and discussion up.
Resuming debate, the honourable member for Richmond Hill.
Well, thank you very much, Mr. Speaker, and I'm pleased to speak on Bill C-279 tonight to amend the DNA Identification Act. And I think it's certainly a worthy initiative and one which I will say off the bat I think should go to committee for further study. I am somewhat surprised, however, that in reading the comments of the Parliamentary Secretary, the Minister of Public Security, that the government has not seen fit to be supportive, particularly in terms of initiative which this side of the House had started prior to the last election. I think it is important for Canadians to understand that there's over 100,000 people who go missing every year in this country. 6,000 missing person cases are currently unresolved, and another 450 come online annually. There are 15,000 samples of unidentified DNA that are recovered from crime scenes across this country, and currently they're stored in the RCMP's National DNA Data Bank in Ottawa, as well as there are hundreds and hundreds of unidentified John Does and Janes in morgues across this country. Now, as you know, Mr. Speaker, and members of the House I'm sure know, there are current restrictions in terms of dealing with DNA under the DNA Identification Act, and it is impossible. It's impossible to match DNA to those thousands of missing persons in the country currently. And given the need for missing person information or missing person index, DNA data bank, and the widespread support of Canadians and law enforcement professionals, the provinces and territorial governments, DNA indices for missing persons should be created. This is obviously an interjurisdictional issue. You have often local law enforcement people who arrive at a crime scene. You have a provincial coroner who is often involved, obviously, in these cases. And therefore, those are the kind of issues, Mr. Speaker, that at the committee level, I believe, are worthy of examination. I think it is important, and I think it's something that we should be moving forward on. Clearly, Mr. Speaker, there are some issues that some members have already identified with regard to this proposal, but I don't think that they should block the movement of this bill to committee. I think one of the purposes of a committee is obviously to do more in-depth work, and I'm sure that the mover from Burlington, and I congratulate him for the fact that this needs to have a hearing, it needs to get the experts in, it needs to get witnesses in, and it needs to be looked at. I would hope that members of the government, and particularly the minister, would also look favourably on this proposal. Amendments to the committee clearly need to identify, for example, Mr. Speaker, federal provincial jurisdictions. The federal government has, of course, jurisdiction in terms of the criminal code. But in terms of cooperation with the provinces, with the territories, we established a national DNA bank, data bank, that's used for criminal investigations, and we've just heard that from some honourable members. The creation of this national DNA MPI, or missing person index, would reassure families of missing persons that current and future unidentified individuals will be checked on a voluntary basis across the country. Missing persons investigations, as I said, are led by local police forces, and of course we have provincial coroners who have jurisdiction over unidentified human remains. Now, barring an interprovincial or international element to the disappearance of a person who is found, the matter would be one of local concern and therefore be within provincial jurisdiction. But I do believe it's certainly commendable and a worthy idea to move forward on. I think we need to deal with the fact that there are many families in this country who are clearly agonizing over whether or not a loved one, in fact, is deceased. And a way to do that clearly is to have this type of legislation in place. I think it will be helpful. And again, I urge all members to support this at committee where a good examination of the legislation can be done. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Chatham, Kent, Essex.
Well, thank you, Mr. Speaker. And I think, Mr. Speaker, you would find unanimous consent for the following motion. I'd like to read that motion. I ask for consent from all my colleagues in the House on behalf of Mr. Wallace, the sponsor of this bill, for this item to be designated to the Standing Committee of Public Safety and National Security.
L'honorable député a-t-il le consentement?
Does the honourable member have the unanimous consent of the House to move the motion?
The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Adopté.
Carried.
Member for Chatham, Kent, Essex.
Well, thank you, Mr. Speaker. I welcome the opportunity to speak before this House and my honourable colleagues about this issue brought forward by the honourable member for Burlington. Let me begin by telling you that the addition of a missing persons index to the National DNA Data Bank would be beneficiary on two fronts. On the one hand, it would help law enforcement agencies solve missing person cases with solid scientific proof. On the other, it would enable officials to make positive matches with missing persons, thereby providing the families of missing loved ones with closure and relief. In the time that has been allotted to me today, I will address the motion of the honourable member. I would first like to note that this government fully understands the principles of this motion. The government recognizes the valuable and expanding role of DNA as a tool for law enforcement. Mr. Speaker, DNA analysis is a powerful tool. It is unparalleled in terms of its ability to identify an individual. As you probably know, with the exception of identical twins, each person's DNA is unique to them. We believe that it is a worthwhile endeavor to further investigate how to use DNA technology more effectively to assist in the identification of found human remains and to bring relief to the families of missing persons. In fact, the Department of Public Safety is leading the significant work to establish a DNA missing persons index. Federal officials are working with their counterparts in each of the provinces and territories. It is important, Mr. Speaker, that we understand first how DNA is now used in the criminal system before we can contemplate adding the humanitarian aspect of a missing persons index in that system as proposed in this bill. The use of forensic DNA analysis to solve crime has shown itself to be of enormous benefit to public safety in Canada. The use of DNA is one of the most valid and reliable investigative tools known in law enforcement today. Mr. Speaker, since the National DNA Bank came into existence in June 2000, thousands of DNA profiles from convicted offenders have been processed and added to it. Also added are the profiles received from crime scenes across the country. Police from across Canada have been trained on how to properly collect DNA samples from a crime scene. It is from these samples that profiles are obtained. As I have said, the DNA data bank is an extremely valuable tool, and its value can be seen very clearly in these statistics. In the first year of use, 2000, the data bank scored 25 hits. It linked DNA evidence found at crime scenes to other investigations or to DNA profiles of convicted offenders. However, from April 2005 to April 2006, that number had increased to 2,323 hits in a year. During its 6 years of operation, over 130,000 DNA profiles have been entered into the data bank. What is the final result? As of this past summer, the data bank has assisted in over 5,800 criminal cases in Canada. Mr. Speaker, clearly it is undeniable that DNA technology is an important part of law enforcement in Canada and is being used quite successfully by our law enforcement agencies across the country. The government continues to consult on the principles behind the proposed legislation and must investigate the matter further. What needs to be determined is whether the resources of the National DNA Data Bank should be used not only to help protect the safety of Canadians by solving serious crimes, but also for compassionate and humanitarian reasons. The honourable member proposes that a new index be added to the data bank that would hold DNA samples of missing persons and unidentified human remains. He also proposes that the new samples should be cross-checked both against each other and also against the existing criminal samples maintained by the data bank in an effort to identify human remains. Using the National DNA Data Bank in this way might offer the potential to bring comfort to Canadian families whose loved ones have disappeared and who have waited for years for news of a missing person. It is understandable how using the data bank in this way could be seen to offer the potential to comfort those families whose loved ones have disappeared. The thought that we might have a tool that could bring a sense of closure to these families compels us to consider this idea. However, concerns have been raised with the way this bill is currently drafted. For instance, jurisdictional issues are raised because both the identification of found remains and the police response of missing persons reports are provincial responsibilities. Therefore, the federal government's right to legislate in this area is not entirely agreed upon by all parties. It is a fact that the federal government and the RCMP Commissioner have no jurisdiction to impose duties upon the provincial laboratory, police, and coroners. Also, Canadian charter rights would be infringed upon if the unloading of the DNA profile to the National DNA Data Bank is made without the consent of the person in question. This government is committed to ensuring that the privacies of Canadians will always be respected. This proposal, as it now stands, could constitute an unreasonable search and seizure. Therefore, it could be argued that any evidence derived from the match between the crime scene index of the National DNA Data Bank and the Missing Persons Index could be inadmissible in court. Moreover, there is concern that relatives who are asked to provide their own bodily substances for DNA analysis may be reluctant to do so if it exposes them to the potential of a criminal investigation. Finally, as with all new government incentives, there would be added costs to running the National DNA Data Bank. Until decisions are made about the design and exact parameters of this project, it is not possible to accurately estimate costs and precisely profile expenditures. The existing National DNA Data Bank and forensic laboratories operate as efficient public safety programs. It is important that the inclusion of a missing persons index add to its value and not draw on the data bank for the forensic laboratory's existing resources used for current criminal investigations. For all these reasons, the government must take the time it needs to further its study of this issue before going forward. The work that remains now continues to be dealt with by the already established federal, provincial, territorial, Missing Persons Index Working Group. In conclusion, Mr. Speaker, the detailed issues that need to be considered before moving forward with this bill may seem minor compared to the enormous suffering of a family whose loved one is missing. But we cannot move forward before ensuring that the method proposed will be effective and workable for all jurisdictions, will not infringe on privacy rights of Canadians, and will withstand the possible future charter challenges. If we put something in place that will simply not work, then we're not looking after the best interest of Canadians. No one is denying that the proposed bill has merit, but amendments to the bill must be made before we can adopt a firm position. As it stands, I believe that this is important for federal, provincial, and territorial officials to continue their work on this matter and to find an acceptable solution to possibly allowing the DNA data bank to serve a humanitarian purpose as well as criminal investigative purpose. Mr. Speaker, until it can move ahead on this process, the government needs to reserve any further judgment on the bill presented by the honourable member. Thank you.
Resuming debate. Reprise du débat.
Resuming debate.
I just want to give the House fair warning that I'm about to recognize the honourable member for Burlington, who is the mover of this motion, for the right of reply. Once he has spoken for 5 minutes, that's the end of the debate on this issue. The honourable member for Burlington.
Thank you, Mr. Speaker, and I could take 15 minutes if you'd like. I appreciate the opportunity, and I want to thank everybody who has spoken to my private member's bill on all sides of the House. Don't necessarily agree with everybody, but I do appreciate the effort that everyone has put into this. It has been discussed that there are nearly 100,000 missing persons in Canada, 6,000 missing person cases currently unresolved, and about 450 added every year. This data bank will help resolve issues for many, many, many families. And I've heard tonight and in our previous debate discussions about jurisdiction and privacy, and previously about the definition of missing persons. And I want to assure this House, Mr. Speaker, that that is why we need to get this bill to committee. We have a number of things that we would like to bring forward, we need to discuss, and sending it to committee was where that action can take place. And I really appreciate the words I've heard from all sides of the House in terms of support of it getting to committee so that we can properly debate this item. There has been a few things that have gone on that I want to share with the House since the first hour of debate about the FPT and the Justice Ministers. There has been a meeting. I think my friend from Etobicoke North mentioned November. It actually happened in October, and they have met. And this bill and the missing persons piece has been part of that conversation. And they have worked on a number of issues, including the privacy issue and this jurisdiction issue that has been presented by the bloc. There's still more work to be done, and that can be done at committee, and I'm looking forward to presenting that and making that happen. All parties basically have said that they're in favor of moving this forward, other than the bloc, not on its merit as a bill, but as its merit as a on jurisdiction. And I just want to quote from the bloc member who spoke in the first hour, from Marc Aroux-Fontaine. I'm not sure if I'm saying the writing correctly. I think this is an excellent idea, and it should be implemented. So the idea is good, and I heard that from the bloc member, and I appreciate that. I've heard from the Liberal side that they also believe it's a great idea. They admit that they were working on it before, and I appreciate all the work that they have done. It's certainly helping me make this happen at this point. There's been others who've been working on this. Staff have been working on this. The Privacy Commissioner's Office, the Data Bank Advisory Committee, Justice has been working on it. The Public Safety Department's been working on it. I do have to give credit where credit is due. I think it was the member from Gulf Islands, Senate Gulf Islands, who's now a minister, who really worked on this project with Miss Judy Peterson, who's done a fabulous job making sure that we're aware of the issue, understand what the issues are, and that we move ahead to try to rectify those as quickly as possible. In the end, Mr. Speaker, what this bill will do, if we can make it happen, which I know we can, it will help bring closure to families with missing persons. It will help law enforcement professionals to do a better job of catching criminals, and will reflect Canada's commitment to be a leader in DNA. We are a leader in the use of DNA now. There is no reason why we cannot continue to create an example for other communities, other countries, as a leader in this area. I want to thank my honourable colleagues for all their words. I look forward to the debate at committee. I look forward to providing the information and the feedback on all the concerns that they had with the particular bill, and I look forward to support from the departments that have the information to be able to provide that for me. And with that, Mr. Speaker, I'm going to close. I appreciate the time, and I look forward to seeing this becoming law someday. Thank you.
The question is as follows. Mr. Wallace, seconded by Mr. Van Kesteren, move that Bill C-279, an act to amend the DNA Identification Act, Establishment of Indices, be now read a second time and referred to the Standing Committee on Public Safety and National Security. Plaît-il à la Chambre d'adopter?
Is it the pleasure of the House to adopt the motion?
All those in favour of the motion will please say yea. Yay! All those opposed, please say nay. No! À mon avis,
in my opinion, the yeas have it.
Conformément
Pursuant to Standing Order 93, the recorded division is deferred until Wednesday, November 22nd, 2006, just prior to the period provided for private members' business.
The Honourable Parliamentary Secretary rises on a point of order.
Point of order, yes. Mr. Speaker, I hope if you sought unanimous consent, you would find it to see the clock at 6:30.
So ordered. À l'ordre.
Order.
In accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn.
The Honourable Member for Laval. Thank you, Mr. Speaker. Mr. Speaker, on June 9th, I asked the Minister of Health why he refused to provide AIDS drugs through the Special Access Program, whereas he was allowing silicone breast implants through the similar type of program. Since then, the Minister of Health has given his agreement for a license to 2 companies to manufacture silicone gel pressed implants that had been prohibited since 1992 and put them back on the market, whereas we know full well that no long-term studies have been conducted to allow for the return of these breast implants without ensuring that they are safe for women's health. We were told that the minister had a set 65,000 pages of research examined by Health Canada. However, most of these documents were provided by the manufacturers that were requesting the approval. So we're wondering how one can trust 2 corporations that were investigated criminally in 2002 for having hidden data from the FDA and that are facing new allegations about fraudulent data, according to another scientific paper, and an investigation started just 2 weeks ago. Like the health department, the minister was unable to cite a single independent researcher. Ms. Bell of Health Canada gave us Dr. Brandon. Unfortunately, he's one of 4 scientists on the expert committee that was in conflict of interest. Many women today have problems with their implants. I receive email every day. I receive letters and phone calls every day about this. Michelle, a young woman, 24 in Quebec City, only 24 years old, who has acute pain, and called upon a surgeon because she had breast asymmetry. The surgeon did not tell her that she could experience problems later on or that he had to ask for an exemption from Health Canada, but he did inform her that gel implants gave better results. Now, she has contractions of the fibrous capsule. She has to undergo more surgery to have the implants removed, and she has to pay to get them removed. That's $5,000. That's a lot. Lise of Laval had her implants removed. She had health problems, a chronic nature. Roseline in Laval as well has fibromyalgia. Lucienne in Laval has back pain, arm pain, even after her implants have been removed, because these implants were stuck on her thorax, Mr. Speaker. There were fissures, they were stuck. There are class action suits underway right now in Quebec and in Ontario. And we're wondering how the Minister of Health can agree to spend taxpayers' money on class action suits to defend his vision of this, whereas he's not paying for MRIs for these women, nor for having these implants removed in case of an emergency. We feel that this is a disgraceful use of taxpayers' money. This is money contributed by all citizens who pay taxes. So we would like to know whether the minister intends to restrict in some way the corporations that got authorization to manufacture these breast implants. The Honourable Parliamentary Secretary to the Minister of Health.
Thank you, Mr. Speaker, and I'd like to thank the member from Laval for raising awareness about this important issue. In the original question that was asked in June, the member asked why one product was allowed under the Special Access Program, why one is not. And if I could just take a moment to discuss this. Health Canada has 2 special access programs, one for drugs and one for medical devices that are governed by different regulations which are administered differently in 2 different programs. Both programs are administered with the aim of providing Canadian health care professionals with access to therapeutic products to meet the treatment needs of their patients. Neither special access program is intended as a means of marketing a product without appropriate regulatory oversight. The Drug Special Access Program allows physicians to access drugs for the emergency treatment of serious or life-threatening conditions of their patients. Health Canada must be assured that sufficient evidence exists to support the safe use of the drug. The Drug Special Access Program is not intended to replace clinical trials. A drug clinical trial is most often the best option for manufacturers, patients, and physicians to ensure both continued access and protection of patient safety. It is a means for manufacturers to collect the necessary safety and effectiveness data for the marketing applications. The Medical Device Special Program allows physicians access to medical devices for emergency use or conventional therapies that are not available or unsuitable. Medical devices, the Medical Device Special Access Program, which is the program dealing with the breast implants, is not intended to replace general marketing authorizations. Health Canada must be assured through the review of safety and effectiveness data for the device that the device will provide a benefit for the patient without causing undue harm. In the case of the Drug Special Access Program request for the access to combination treatment for the HIV/AIDS, the physician that was referred to in the original question in June was unable to supply the necessary data to support the authorization of access to the drug combination. In August of 2005, Health Canada offered to consider early access to the same combination through a clinical trial. Had this offer been taken, the patient would have had the medications they were seeking at the time and been protected by inherent checks and balances in the clinical trial settings. A clinical trial application was not received from the physician until December 2005, and once received, it was subsequently reviewed and approved within 24 hours by Health Canada. Each medical device special access request for a silicone gel breast implant is supported by the safety and effectiveness data contained in the license application. In addition, the specific benefits and conditions to be treated are provided for each individual patient by their surgeon in support of their special access authorization application. With a decision imminent on, as we've made a decision on silicone gel breast implants, the special access program is no longer relevant in this particular case, and the fact remains that there have been many trials that have taken place within the margin of reasonable risk. They have been approved.
L'honorable député de Laval. Honourable member for Laval. Thank you, Mr. Speaker. Mr. Speaker, I would have liked to have the minister have the courage to answer me himself, but since he does so through his parliamentary secretary, allow me to continue. An American patient received Mentor gel silicone implants for an augmentation in 2000, not in 1960, not in 1970, nor 1980, in the year 2000. The same year, this patient developed an infection, staph infection. The same year, these implants had to be removed and the patient died a few weeks later because of septic shock. Multiple organs were no longer able to function. Mr. Speaker, how can the minister allow these breast implants back on the market, not regulate the special access program, and wait to have sufficient data? The Honourable Parliamentary Secretary to the Minister of Health.
Mr. Speaker, Canada remains only one of two major industrial countries where silicone gel-filled implants have not been available. Now they are. So that brings us in accordance with international standards. It's interesting to note that Health Canada has taken 4 years to review over 65,000 pages of manufacturers' information and test results submitted to meet the safety and effectiveness requirements of the medical device regulations. Health Canada has convened an expert advisory panel to consider the information and questions raised during the review process. This panel has also heard from members of the public, healthcare professionals, and other scientists on the issue of silicone-filled breast implants. Health Canada has received and considered the advice of the panel in its review. Mr. Speaker, Canadians can rest assured that Health Canada is doing everything in its power to ensure the safety, health, and well-being of Canadians. I also like to stress that Health Canada has taken strong measures to ensure Canadians are protected through every step of the process. It is evident from the honourable member's question that she does not believe that the safety and effectiveness of silicone gel breast implants have been established. However, in the past 15 years, silicone breast implants have become the most intensely studied medical device in the world. There have been a number of strong, well-controlled studies undertaken by independent researchers. There have been more than 2,500 scientific articles published in the scientific literature, and more than 100 million patients in 78 countries have received breast implants.
The honourable member for Nanaimo Cowichan.
Thank you, Mr. Speaker. And I'm rising today around a question that I raised on October 17th to the Minister of Public Safety. And in that question, I talked about the fact that Aboriginal peoples only form 3% of the population in Canada. They are 18% of the prison population, and also talked about the poverty that contributes to higher incarceration rates. And in his response, the Minister of Public Safety indicated that it was not a matter of discrimination in the prison system, but it's a matter of personal responsibility being taken. Well, Mr. Speaker, the Correctional Investigator's annual report was a damning document outlining the problems with the system. And it's the problems with the system, not the people. And it's the problem with the systems of corrections in Canada and how it discriminates against Aboriginal peoples. Now, there are a number of discriminatory points here, Mr. Speaker. For example, more Native people than non-Native people fail to get parole. And there is also discrimination before they even get into the system. First Nations, Métis and Inuit peoples are more likely to plead guilty, to not have legal device, and they are more likely to receive longer sentences. And these statistics are incontrovertible. And from the 2001 speech from the throne, I'd like to quote, "Canada must take the measures needed to significantly reduce the percentage of Aboriginal people entering the criminal justice system so that within a generation it is no higher than the Canadian average." And what we have seen, Mr. Speaker, is examples of both the Liberals and the Conservatives backing away from that promise. Prisons are full of Aboriginal people not because they are crime-prone, but because they are much younger and much poorer than Canadians generally, and statistics show that poverty and youth very often lead to problems with the law. There is also discrimination because many of the people who make decisions, guards, parole officers, wardens, use standards and approaches that are culturally inappropriate, and this leads to breakdowns in communications and misunderstandings. Canada cannot afford to neglect this problem. It will fester and worsen for generations ahead of us, and these jails and remand sentences will become residential schools of this generation, and we know what the costs are both to Aboriginal peoples and to Canada. The Minister refused to commit to any program to end this discrimination, and will he say now what plans does the Ministry have to honour the promise made to reduce the number of Aboriginal peoples in prisons to the Canadian average?
The Honourable, the Parliamentary Secretary to the Leader of the Government in the House of Commons and Minister for Democratic Reform.
Thank you, Mr. Speaker. Mr. Speaker, Canada's new government is committed to ensuring an effective and fair federal correction system that protects Canadians as the overarching priority. The Correctional Service of Canada is committed to partnering with communities in the development of innovative community-based approaches for offender healing and reintegration. There are many factors that have been contributed to the overrepresentation of Aboriginals in the prison system, and our government acknowledges the challenges many Aboriginals have in addressing poverty, education and substance abuse. The CSC is dealing with changing inmate populations. This includes an increasing percentage of Aboriginal offenders, which research has shown to be younger, more likely to commit violent crimes, have lower levels of education, and are less likely than the general population to be employed when admitted to custody. This leads them to be classified as higher risk and higher need inmates. Higher risk and higher need inmates are placed in high security levels, are kept in jails longer, and are less likely to be released on some form of conditional release. It is for this reason that Canada's new government is committed to preventing crime from taking place. The 2006 budget allocated $20 million over 2 years for communities to prevent youth crimes with a focus on guns, gangs, and drugs. By supporting our citizens, and youth in particular, we will hopefully prevent incarceration from taking place. At the same time, the issue of Aboriginal overrepresentation is a concern of CSC and the Department of Public Safety and Emergency Preparedness. That's why in 2006, CSC launched its 5-year strategic plan for Aboriginal corrections with commitment to action in 3 key areas. Firstly, program and service delivery through further development of the continuum of care model in consultation with Aboriginal leaders and communities. Secondly, enhanced collaboration with other stakeholders. And finally, address systematic barriers through an enhanced organizational capacity to work effectively with Aboriginal offenders and their communities. Aboriginal offenders attend programs under the guidance of elders, Aboriginal liaison officers, and elders helpers. These programs are a means to promote and encourage traditional, cultural, and spiritual healing that increases positive reintegration into the community, recognizing the hurdles that have prevented Aboriginal people from full participation in Canadian society and making commitments towards healing and renewal. CSC is also working in areas such as Aboriginal liaison services and spiritual services. An Aboriginal-specific substance abuse treatment program and sex offender treatment initiatives are under development. Healing lodges developed in collaboration with Aboriginal communities provide supportive healing and reintegration environments. As well, the National Parole Board utilizes elder and other forms of assisted hearings in all regions of Canada. These hearings allow the Parole Board to make more thorough assessments about an inmate's likelihood of successful release. The Government of Canada has a major role in ensuring strong and safe Aboriginal communities, and that commitment, Mr. Speaker, is taken very seriously. The Department's First Nations policing program, with agreements in some 300 First Nation communities, helps foster better relationships with First Nations by providing culturally appropriate professional police services. These services meet local needs and are leaders in crime prevention. The Aboriginal Community Corrections Initiative, Mr. Speaker, has proven to be a successful program. It is designed to treat offenders, victims and their families, and has produced other community-wide benefits.
The Honourable Member for Nanaimo Cowichan.
Well, Mr. Speaker, the correctional investigator laid out a series of recommendations to deal with the situation. For example, build capacity for and increase the use of Section 84 and Section 81 agreements with Aboriginal communities. Implement a security classification process that ends the overclassification of Aboriginal offenders. Significantly increase the number of Aboriginal offenders housed at minimum security institutions. Significantly increase the number of Aboriginal offenders appearing before the National Parole Board at their earliest eligibility dates. And I would like to add one of my own, Mr. Speaker. Correctional Services should set up a senior management committee to meet with First Nations, Métis and Inuit leadership intensively for a 6-month period with a mandate to develop an implementation plan for the recommendations of the correctional investigator. So, Mr. Speaker, which one of these recommendations is the Minister going to act on and when?
The
Honourable Parliamentary Secretary to the Leader of the Government in the House and the Minister for Democratic Reform.
The Department of Public Safety and Emergency Preparedness will continue to enhance its Aboriginal continuum of care for Aboriginal offenders that strives to provide Aboriginal responses and alternatives at every critical step along the correctional path to ensure that they have every opportunity to address the issues that brought them into conflict with the law. CSE will continue to expand involvement in Aboriginal corrections by recruiting, retaining and developing Aboriginal and non-Aboriginal correctional staff at all levels. To improve the safety of Aboriginal communities and for all Canadians, the Department and CSE are working with other government departments, provinces and territories, as well as Aboriginal people, to address the larger social, cultural and economic problems facing Aboriginal people. Let me conclude, Mr. Speaker, by saying that Canada's new government is committed to ensuring an effective and fair correction system that protects Canadians as the overarching priority.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 10 a.m. pursuant to Standing Order 24-1.
ridiculous to think that one of my kids could have done it.
Unless you were there, how would you know?
I know because I know my children.
Having faith in them is not the same as knowing what happened to Carmen. Everyone has to be investigated.
Okay, listen. I'm only suggesting they'd be low priority.
Neil, I can't tell you how many clients are shocked and appalled.